Knight. Representative Agello.
Present.
Representative Batista.
Present.
Representative Bennett.
Here.
Representative Caldwell. Representative Casimiro. Here. Representative Cruz. Representative Corbasi. Representative Dawson. Representative Felix. Representative Norrie.
Here.
Representative Place.
Present.
Representative Representative Place. Representative Roberts. Chairman, we have a quorum.
Okay, thank you. Welcome to the House Committee on Judiciary. Today is Wednesday, March 27th, 2024. We're in the House Lounge. We have one bill to vote out of committee onto the floor tonight, and we have 24 bills here for hearing or for consideration. So I'd like to take the bill that's scheduled for consideration first. House Bill 7569. It's a general treasurer's bill. It's sponsored by Representative Finkelman, and it's an act related to conditions where persons paid to recover or assist in recovering reported property must comply with. It's involving with probate practice and unclaimed property. If there's no questions on the bill, do I hear a motion for consideration?
I move passage, Mr. Chairman.
Second. Roll call.
Chairman Craven.
Aye.
First Vice Chair McEntee.
Aye.
Second Vice Chair Knight. Representative Agello. Aye. Representative Batista. Aye. Representative Bennett.
Yes.
Representative Caldwell. Representative Casimiro.
Aye.
Representative Cruz.
Yes.
Representative Corbasi. Representative Dawson.
Aye.
Representative Felix. Representative Norrie.
Yes.
Representative Place.
Aye.
Representative Roberts.
Yes.
The ayes have it, Chairman.
Thank you. It passes, goes to the floor. So we have 24 other bills that we're going to hear and consider tonight. Before I ask for a motion to hold those bills for further study, I will read something that we've been reading all year. Before the committee starts hearing testimony on the bills on today's agenda, I am going to ask for a motion to hold the bills for further study. I'd like to remind the committee that a vote in favor of holding all bills for further study is not substantive and does not signify any position on the merits of the bill. This motion is procedural only and simply allows the committee sufficient time to review both verbal and written testimony and to organize the hearing process. With that, we're going to put all the bills in play now. That means have the sponsors or someone else on committee introduce the bill, and we have two representatives here. The first is Representative Falella. I'll ask you to put your bill in play. If you want me to read it, I'll be happy to read the introduction. It's up to you.
Yeah, you can read it, Chairman.
Okay. It is House Bill 8084. It's an act related to property, residential landlord and tenant act. It modifies the summons for eviction for reasons other than non-payment of rent with the district court to add a certificate of service section and provides the option to post the summons/complaint conspicuously on the door of the tenant or defendant's dwelling.
Thank you, Mr. Chairman and members of the committee. Thank you for having me here this evening. This bill really only has 4 points that I can bring to you. The bill actually corrects a flaw in existing law by bringing uniformity to how eviction cases are served. The goal is to minimize confusion for the defendant or the tenants. It reduces waste and cost in the court system by eliminating frivolous hearings caused by the defendants or tenants who willfully avoid service of court process. Unlike rent cases, these cases are more problems that are dealt with, problem behaviors such as threats, drug dealing, lack of hygiene, that neighboring residents, and failure to comply with the HUD rules. This bill does not change eviction procedures or protections in any way. It only brings uniformity to the service process at the addresses where the defendant tenants are confirmed to live. I know the Constables Association is in full support of this legislation, and you'll probably be hearing from him later this evening. Any questions? I'd be glad to take them.
Any questions of the sponsor? Thank you. Representative Stewart, you have 2, right?
That's correct.
You could take them in any order, but if you want to start with 7304, that would be great.
I'd be happy to. Thank you.
Thank you.
Okay. Thank you, Chairman Craven and members of the Judiciary Committee for the opportunity to speak with you today about House Bill 7304, otherwise known as the Fair Notice Act. I am so proud that this bill is included among so many fine bills on this agenda today, and to be among the sponsors who are seeking to bring some sanity to what has become a crazy market for renters in Rhode Island. So I want to begin with a premise that we all deserve a safe, stable place to call home. And too many Rhode Island families are living with the stress and fear that they will lose their homes. Why? Because rents have been rapidly increasing, but incomes have not. That's a familiar story to all of us. And the supply of reasonably priced apartments has not kept pace with the demand for them. And we all know that last session, under the leadership of the Speaker and several House members, we passed important legislation that will eventually help to increase our housing supply. But until that housing materializes, we need to act urgently to help today's renters. Renters make up about 38% of our state's households, and 7304 seeks to increase the number of days' notice that people have prior to a rent increase. This bill was introduced last session. It actually passed in our chamber under a sub-A, but it was held for further study in the Senate, and I've reintroduced it this year, modifying the number of days for most renters, an increase from the current 30 days to 90 days. And for those elders 62 and over, a doubling of what currently exists, 60 days to 120. What I want to point out about this bill is that it really just seeks to respond to current conditions, which we've all heard about, as far as the difficulty for finding affordable apartments. We know that many people are rent burdened in our state and living paycheck to paycheck, and adding to that situation, one of these huge increases that we've been hearing about over the last couple of years in the news is basically a recipe for disaster. So this bill seeks to give all renters an opportunity to simply adjust budgets, seek additional employment, get a security deposit together, and reduce the stress a little bit, to have a little more time to figure out what comes next. And I just want to end on this bill by saying that unfortunately, to rent these days is to live under a kind of sword of Damocles situation, because one never knows what the rent increase is going to mean when it happens. And so, housing is so fundamental that it's unlike anything else, and we can't treat it like everything else. And we simply need to do more to increase the odds that people can remain adequately housed. And it's a modest attempt to try to help with that. Is it okay to go on to 7967?
Just ask if any members
I'm
of the
sorry.
committee have any questions.
Yeah.
Yes, Dave.
Representative, there's two reasons why rent will go up. One, adjustment to market rate, which I think is what you're primarily concerned with. But obviously, rent can also go up, or the need for rent to go up can also go up because of fixed cost, just in terms of that the landlord holds. So they have to, otherwise they themselves are losing money. Would you entertain any language to differentiate between the notice for market rate changes versus, say, a fixed rate change that the owner may have?
Well, I guess I would look at some language if you have some suggestion about how that might work in a bill. I don't quite see how that might be feasible or practical to differentiate. Yeah.
Offhand, I could probably say maybe percentage of increase. Because the fixed rate increases, the market rates are the market rate increases are the biggest driver right now. And then there's underlying, obviously, inflationary costs for the owners. So I think getting into the percentage, but again, like I said, something we can talk about another
Okay.
time. Thank you.
Thank you.
Any other questions? Okay, let's charge on to the next one.
Okay. Thank you. So again, thank you for the opportunity to talk about 7967,
Yep.
which seeks to amend our state's homeless Bill of Rights. So in 2012, some of you, I'm sure, were part of the effort to pass the original homeless Bill of Rights. But in 2012, the General Assembly and Governor Lincoln Chafee made history when they joined to pass that original homeless Bill of Rights. And it was historic because Rhode Island was the first state in the country to affirm in law that the unhoused have the same rights as everyone else. Under that original homeless Bill of Rights, it delineated that the unhoused, like everyone else, have the use of public spaces such as parks, libraries, public transportation, that they should enjoy protection from discrimination by employers and government agencies, and have the ability to pursue legal action to obtain relief for violations, including damages and attorneys' fees. And that was a big deal. And at the time, as I'm sure many of you know, national advocacy organizations recognized and applauded Rhode Island because it stood in stark contrast to the other possible response to the unhoused population that stigmatizes, criminalizes, and abuses the most economically unfortunate among us. And those organizations that recognized Rhode Island, they knew that Rhode Island could serve as a model for other places around the United States. And Rhode Island has, albeit slowly. Since 2012, according to the homeless news website Invisible People, as of October 2022, Connecticut and Illinois enacted a homeless Bill of Rights legislation, and there has been proposed legislation to do the same in California, Hawaii, Oregon, Vermont, and Missouri. So that's all fantastic, right? And the important thing I want to point out is that in 2012, we in Rhode Island acknowledged the reality that although unhoused people are technically covered under the Bill of Rights in our national constitution, those liberties and protections are frequently infringed upon whenever the powers that be feel like they can get away with it. So we took a stand to change that situation. And unfortunately, since the passage of our Homeless Bill of Rights, Rhode Island has experienced the astronomical growth of the homeless crisis and the worsening of the affordable housing shortage in our state. And so, once again, we must acknowledge that the rights of the unhoused continue to be violated because they're a vulnerable population, and that the powers that be throughout our state can get away with violating their rights because they have. And there will be plenty of people here tonight who will describe evidence of that. So let's send a stronger message to let everyone know that that is unacceptable and there will be consequences. This bill strengthens the existing Homeless Bill of Rights because it unequivocally and clearly states a reasonable expectation of privacy and protection from unreasonable searches, extends to temporary dwellings such as tents. It requires that police and public works departments adopt written policies and procedures necessary to fully comply with all requirements of the Homeless Bill of Rights and to make them available to the public. It affirms the necessity for access to the materials that create sanitary conditions, as the real lack of this access has been used as a precursor for relocation. It asks for collaboration with outreach workers when there is any relocation of an encampment. It defines a period of notice before any relocation of encampment occupants. And it establishes specific fines for violating the Homeless Bill of Rights and requires that money from these fines be used for housing stabilization services and to address other issues related to homelessness. And importantly, it allows organizations chartered for the purpose of ensuring civil liberties or combating homelessness to actually bring civil actions. So here in Rhode Island, just to wrap up, we've been experiencing some cold, wet, and windy weather. Imagine experiencing those conditions while you're living in a tent. Then imagine having the police basically serve you with eviction papers to relocate you or face arrest, and then having your tent destroyed and your belongings discarded. Then imagine having no recourse because you can't realistically file a lawsuit due to the instability and precariousness of your living conditions. And this is why we need to strengthen our Homeless Bill of Rights. Thank you.
Any questions for the sponsor?
Thank you, Chair. Thank you, Representative. Quick question, page 2, line 8. So has the right reasonable expectation to privacy as if, the property extent of personal property, and the same right of privacy in his or her temporary housing, including tents or permanent residence. So my understanding in reading this is if someone established residency on my property in a tent, I approach them, they tell me that I have to leave my property because I'm now violating their space where their tent is established on my property, and I have to go through the process of eviction. And they call the police, I'm warned, if I show up again on my property where they're established a temporary residence, I will be charged a fine of $2,500. That's
how, excuse me, you're asking if that is what this does?
through the chair, my interpretation of how I would serve as a law enforcement officer, yes, if I was called to someone's property to issue a trespass warning, the second time they come back, if you're trespassing again, you would be subject to the fine of $2,500, which is what's outlined in lines 20 through 21. That's my interpretation of how this could be interpreted by law enforcement or a judge. So we can discuss that offline, but
Yeah.
that by the right of temporary housing, giving them the same property rights as a permanent residence, again, trespassing would be included in this.
Well, I guess I would ask, what would be the protection or remedy that could be offered instead of this to ensure that a tent is, or other temporary dwelling is not trespassed against without going through some kind of, warrant for doing so.
So I guess my question ultimately, and I don't want to go back and forth on this, but is if the tent is set up on someone else's property and that person is questioning that established residence on the property, that's, I guess, where we find ourselves in a conundrum of whose property and who's trespassing. So.
Okay, I would have to think that through, but I would think that the fine would kick in if there was found to be indeed a violation of someone's rights under this bill. And there wouldn't be any fine unless it was found through a civil action that had indeed happened.
Okay, thank you.
Any other questions of the sponsor? Thank you.
Thank you.
John? You want to handle both of your bills?
Yes, thank you,
Sure.
Mr. Chair, and members of the committee. I appreciate your indulgence with this, and thank you for taking me early. It's greatly appreciated. Let's see, Bill number 7174. This act would prohibit landlords from inquiring, and that's the key word here, about an applicant's prior incarceration and from discriminating against those who have been released from prison. It's just an inquiry during the discussion or whatever. That doesn't mean that you don't do a background check. No one's prohibiting anybody from doing that. That doesn't obviate if someone is a sex offender and if they get into if they are allowed to be a person within that confines, that they would be required to abide by that law. My esteemed colleague used the sword of Damocles in the poorer, less affluent minority neighborhoods throughout the city and the state of Rhode Island. I can only speak for mine, obviously. These are crazy times. It is a crazy market, and people are looking for any excuse to throw somebody out, not rent property, because they're literally renting spaces $8,000, $9,000, $1,000 a room. So if you got a 3-family house with 9 rooms, there could be as much as $9,000 a month. That becomes a cash cow. And, you know, just maybe 18 months ago, 2 years ago, people may have been paying $1,200, $1,300 rent for the entire floor. So that's what this does. No one's saying you can't do a background check. I think you should. I can tell you this as a practicing attorney, and I would certainly defer to my colleagues that practice law. Whenever a situation comes to my office, I always do background checks on not only the person that I may be representing, but I also do it on the other parties, whether it be a plaintiff, a victim, alleged victim, or whatever. So I do that all the time. There's nothing that prohibits me from doing that. And I would imagine any landlord, especially if that's your livelihood, that you're not going to do a background check. It's just a matter of you're not asking, just not asking. That's all this is, basically. And that's it, Mr. Chair. If there's any questions, I will try to answer them.
Any questions for the sponsor?
Thank you, Mr. Chairman, members of the committee. I also understand that there's a lot of letters of support on this, as far as I know. I really haven't seen it. Bill number 7162. And what this bill does, this act would permit those other residents of a residential dwelling unit to extend the term of a rental agreement for a period not to exceed 3 months after the death of a lessee or permanent paralysis, something of that sort. So what happens in some instances is someone's in an apartment, they take a stroke, a massive heart attack, they need assistance, their grandchild may move in, their a child, and they basically have to close up their apartment to go take care of the needs of whomever that person is. So what's happening is, if the person's not on the lease or somewhere noted, the landlord can, upon death, can basically say, okay, you're gone, and that person's back on the street. Housing is at a premium. Certainly in my neighborhood, it's. I mean, we could probably use 500 units just in my district. So, again, I think it affects people of the lower social stratification, lower social stratification of society, people of color, people of the poor, downtrodden. So this is just something that I've had, not a lot of inquiries, but I have had inquiries certainly in the last year or two of people saying, what do I do now? Where do I go now? How do I get housing? And all of you know, there is nowhere to go. I mean, unless, you go from a fixed income and you can say, I can pay $3,000 a month. I know some places on the east side, my understanding is $4,000, $4,500 a month, $5,000 a month. That's a good mortgage for a lot of houses. And whoever can pay it, I say bless you. And that's where we are. And that's it. If we can endeavor to answer some questions, I will be, yes, sir.
Yes, Steve.
Curious, why not allow someone just to assume the lease if they're able to pay? If they're already living in the unit, why not allow them to assume the lease in its entirety? So say maybe it's day 1 or day 2 of the lease, and this potentially happens. Why not allow or write in some option to assign that person's lease rights or their contractual rights to someone else living in the unit?
Yeah. I totally hear what you're saying. In many instances, it's not done. Again, lower social stratification, people not educated, people from other countries don't like to shake up the system. The problem that we're seeing in my neighborhood, in Feather Hill, for example, in Oneyville, they're dying to get people out of those apartments. They're locked in at $12, $13, $14, $1,500 dollars rather. And then they're saying, well, your lease is about to run out. It's going to go to $1,800. But can you imagine, literally on Broadway, right near my office, those apartments went from $1,200, $1,300, $1,400 to $2,500 a month. They want you out because, especially with the students, what they're doing across the street from me, behind me, people from California, other states, Massachusetts, they're purchasing houses. They're buying a 3-family home. If there's 3 rooms, $800, $900, $1,000 a month. I mean, can you imagine? That's.
Well, I understand. My question is, why not make it longer?
I'm sorry?
You're saying 3 months. My question is, why not put an ability to make it longer in terms of, like, again, the duration of the lease?
I think I'm trying to be mindful of where a landlord would stand. I mean, if they need 3 months, try and get housing, and they may not be able to get the housing, to be quite frank with you, but do some repairs, do what they got to do, and then try and move on. But listen, it's okay with me. We could change that number to a year, 6 months. I'm okay with that.
So my point isn't to just haphazardly extend it, but there's a current lease. There's a lease in place. And I guess the lease would remain in place until the expiration of the lease. That's all it was. In other words, the assignment of the leasee's rights, i.e. the person who passes away, would then just be passed on to whoever's living in the apartment. So there would be no change in the landlord's position because they are agreed to pay whatever the number is. Again,
I think that if that person is not on the lease, whomever that person may be, and, you know, it could have started off as a temporary situation. The problem that we're having in my neighborhood is, if they can get that person out of there, they're paying $1,200 a month, and they know that next door is charging $2,500 a month. To me, it's a no-brainer from a financial and a business standpoint, and that's really what's happening, to be quite candid with you and quite frank. I mean, it's disturbing. You know, we oftentimes don't want to restrict free enterprise and business, but if they can get out of there because of someone's death, and I guess that's a reason to break a lease, and they don't have to infer or ask about this other person, whomever this other person may be, I would think that they would tend to go, you know what, we want this vacated, you better leave now, and now it's not $1,200, now it's $2,000 a month, $2,500. At least that's what I'm experiencing.
Any other questions of the sponsor? Tom?
Representative?
Yes.
I'm actually, I like this concept.
Thank you.
My only question or concern, legal obligation of the person without being a signatory and having a contract between the landlord and the new tenant. Would that hold up?
Yes, there's certainly a legal obligation. There's
So-
always a legal obligation.
So again, they're not on the original lease.
No.
They're just gonna stay. This law would keep them, without a signature, legally obligated to pay all these bills and do all these things
Sure. Yeah,
for
because,
3 months.
yeah, because they would be considered a tenant anyway. And they would, I don't think you could just go in and say, oh, by the way, you better leave because your grandmother died or your mom died. You still have to go through the process, at least in my opinion. I think there's a tenant eviction is process that you have to go through.
No, and
Yeah,
again,
no,
I understand
I'm
that.
agreeing
but-
with you.
But to hold them to have to pay, so again.
Sure.
You know, girlfriend, friend moves in, right? They're gonna be, you know, they're not on the lease whatsoever.
Yes.
Where the landlord can still hold them to the obligation.
Absolutely.
Okay,
You got
perfect. Thank you.
Tenant-landlord law would apply.
Not a property owner, thank you.
Absolutely.
Any other questions of the sponsor?
Thank you, Mr. Chairman,
Go
members of the
forward and
committee.
judge.
Thank you, I appreciate it.
Chairman Solomon?
Thank you, Mr. Chairman and members of the committee. House Bill 7948 would provide amendments to the requirements of the inclusionary zoning law for affordable housing developments. As this committee is already very well aware, inclusionary zoning is a tool which allows municipalities to require developers at a certain threshold of units they are developing to provide a certain percentage of those units as low and moderate income designated units. Last year, as a part of the housing package, among other changes, these same provisions were amended to increase the percentage of affordable units required from 10 to 25, and an automatic density bonus of 2 market rate units for every one affordable provider was included. After the passage of the amendment, unfortunately, many municipalities removed inclusionary zoning from their ordinances, reasoning that the density bonus was too high. So after staff meetings with the Rhode Island chapter of the American Planning Association, in hopes that municipalities put inclusionary zoning back into the ordinances as a tool for the encouragement of low and moderate income housing, these thresholds were adjusted, and it was made clear as to how the total calculation works. So it's a great bill, and I'll take any questions.
Any questions of the sponsor? Thank you, Chairman.
Thank you.
Representative Porter?
Well, good afternoon, Chairman. Thank you. And let me just begin by saying thank you to the entire committee for your time today. I know you have a long agenda ahead of you, and you're hearing some very important bills today, so I personally appreciate it. I want to start my comments just by saying that everyone, whether they own their home or they rent, they deserve the dignity to have some predictability of the security of maintaining the place that they call home. So the bill that I have before you would implement very reasonable limitations on the amount that landlords can raise their rental amounts by prohibiting any rental increase within the first year that a tenant occupies a unit, and then limiting further increases after that point to 4% annually. I think the entirety of the House is very well aware of how complicated solving our housing crisis is. We've certainly made a lot of progress on it, and we've done a lot of really good work, whether that's, with making efforts to streamline the building permit process and update very archaic zoning, or create revenue streams to fund different types of housing development. But all of these measures, even with our most ambitious estimates, are very long-term projects, and they're going to take a very long time to materialize in any meaningful way to actually bring real difference to the people who are most suffering through this housing crisis. So in the interest of acting in urgency, I would just ask, why not have this be one more tool in the toolbox to help deal with our housing crisis along the way? I would certainly be welcome to any collaborative input and effort to make sure that this bill does not have any unintended consequences to it. Maybe we need to add some provisions in here that better control for the natural rate of inflation. Maybe we need to make some carve-outs so that landlords can realistically put some actual investment into their units that would benefit the quality of life for their tenants. But while this committee hears testimony tonight from the people who are opposed to this bill, whether they be landlords or people in the real estate industry generally, I would just ask the committee not to be lost in the details of the particulars of this bill. I think I have full confidence that we as a body can meaningfully address any of the particulars and iron those out. But I would just ask you rather to consider a very fundamental question, and that is, do our constituents who rent and are in good standing in those rental units deserve some level of protection and security in their homes? Do they have the right to have some reasonable expectation of how they budget and how they plan their futures, of what it's going to cost them to stay in the place that they call home from month to month or from year to year? Or do we look at housing, which I would argue is a fundamental human right, like it's any other product in the market, that it can be left totally to the market to regulate itself? And if that is the question that's the answer to the question that you lead yourself to, I would ask you, why are we in the situation that we are in right now? Purely leaving housing to the market is not working for Rhode Islanders. And in the current situation that we have, landlords are allowed to raise their rents by 25%, 50%, 100%, 200% at any point with very little notice. I think if you ask that question to most people, reasonable minds will agree that we should have some level of protection so people can reasonably anticipate, plan, and budget accordingly. And with that, I'm certainly happy to answer any questions that the committee may have. Thank you, Chairman.
Yes, Dave, go ahead.
Not a question necessarily, but just a statement to the introduction. The fact is, we recognize by the changes we're making in our zoning that our zoning laws have had an impact on how, on where we are. The fact that our zoning limits the ability of a property owner to use their property as they see fit, whether it be for a 20-unit affordable housing complex or a 6,000 square foot mansion. Our laws prevent people from using the property as they see fit. And I think before we start trying to continually limit the ability of the landlords to use their property as they see fit, I think we start looking at the other side of things, which I think, I have some disagreements with the speaker's housing packages, but I think the zoning, some of the zoning changes are reasonable and should move through. And I think we should address that side first. Why the housing? Why haven't we been building more housing? Because our local zoning officials and our local zoning boards have been preventing those homes from being built using the laws we already have in place. And I think we should work that end before we start limiting the ability of these landlords to control the amount of revenue they get from their properties.
May I respond to that briefly?
Sure.
Chairman? Thank you. I would just say, Rep. Place, I don't think that that is mutually exclusive, right? Why not do both simultaneously? As I was saying in the comments earlier, I think we recognize that these zoning updates are going to take a very long time to materialize. It's not a very quick process to put shovels in the ground even after you have a zoning update and a building permit issued. Along the way, until we actually get to a place where there is enough housing stock to adequately have a market that operates like a marketplace should operate, where there's enough supply to meet demand, why not have some level of security so people can anticipate what their rent will be, and they know that once they get settled into a unit with their family, their rent isn't going to go up by 50% or 100% the next 2 months, 6 months, 1 year from now. It's just further exasperating our housing crisis and our homeless issue in Rhode Island. It's just, again, one tool that I would represent to the committee we can put in our toolbox to get us to that point where we no longer have the issues in zoning that we're talking about.
Thank you. Any other questions of the sponsor? Yes, Jose.
Thank you. Thank you, Representative Potter. I have a couple of quick questions for you. I appreciate and agree with what you're trying to do. I've had many clients in my career call and ask that question, right? Is it legal to raise rent 100%, et cetera? And so, while I appreciate both sides, right, there's obviously a very diverse spectrum of folks who are property owners, and not everybody's trying to do harm. Two quick questions. One, I want to make sure I understand how this works, and then I want to add something broader. So, any 12-month period, no raise greater than 4%. Does that mean like total for the whole 12 months?
Correct.
So, for example, if my rent for whatever reason is $1,000, which I don't know where you find rent for $1,000 right now, but if it were $1,000, 4% of that would be like $40, and so that'd be the maximum raise for per year.
Correct.
Okay. Now I'm curious. I imagine there's a lot of different models of rent control. Maybe they're based on figure. Maybe there's different percentages. Can you tell us a little bit about how you arrived at this particular proposal versus any other ones that exist?
This was duplicate legislation that Senator Tiara Mack has filed in the Senate. Previously, Representative Stewart had it in our House. There wasn't going to be a sponsor on it this year, so I kept all of the language identical to how it was before. And again, I'm certainly agreeable to make some adjustments with input if there's actual good faith collaborative effort and an interest from people who are opposed to this bill to fine tune that and find the right sweet spot so that you wouldn't have any unintended consequences of the bill.
Yes. Go ahead, Dave.
Can you give an example of where rent control has actually accomplished what you're looking to do?
I believe that we'll have some people testifying tonight that would probably be better suited to answer that question for you.
Any other questions? Okay, thank you.
Thank you, Chairman.
Now, Secretary Pryor's here. Which bill are you testifying on? 7746. Oh, yes, both of you come. Representative Cruz, after the secretary testifies and you introduce the bill, then you can, I think you've got 4 of them on the, do you want to put them all in play? Oh, you go back over there? Okay. All right. 7746, sponsored by Representative Cruz on behalf of the Department of Housing. It's an act related to property, residential landlord and tenant act. It provides that landlords would pay interest on the security deposits in residential landlord-tenant matters.
Yes, and I just want to thank again Director Pryor for putting in this piece of legislation. I know my first year, last year, I had a lot of constituents who actually reached out to me about this specific legislation, so I want to thank you again for putting that in. And this act would...
Thank you, ma'am.
Yeah, thank you. So this act will require that residential landlords of 6 or more dwelling units hold their tenant security deposit in interest-bearing federally insured deposit accounts, and within 20 days of the end of the tenancy, any remaining interest accrued shall be paid to the tenant. You know, there are many states, there's 16 states actually already that have it, and DC, and some municipalities, and there are some working on it as we speak, to grow that number. And this simply, again, is just to provide interest that accrues from a renter's security deposit while in the bank that is supposed to be returned already to the renter according to our existing Rhode Island law. So with that said, I will just hand it over to Director Pryor.
Thank you, Representative Cruz. Mr. Chair, such a pleasure to be before you. Thank you for the work that this committee is doing under your chairmanship regarding these housing issues. Really very much appreciated. And through you to the Speaker for the profoundly important and terrific set of bills that has been considered in previous sessions. And we are grateful that there is newly to be considered a set of bills that could advance us in terms of addressing our housing challenges. Mr. Chair, I do want to note that as a general matter, our housing department is grateful for the Speaker's package and looks forward to further dialogue on the details of all of them, but we think that on the whole, the direction is right and that the kinds of initiatives that the Speaker and you all are undertaking is valuable. Thank you so much. 7746. As Representative Cruz expressed, this is a bill that accomplishes something that maybe we all assume to be true, but we want to make sure is a matter of law and in partnership with landlords happens routinely and uniformly. A security deposit, of course, is money that belongs to the tenant. The deposit exists for the purpose of recompense for any damages that may occur in an apartment. It could be to remedy rent arrears. That should remain true. But if the security deposit is not drawn upon, it should be returned in full with interest. And there should be an interest-bearing account that receives the deposit, and the initial deposit plus the interest should be returned to the tenant in that it is the tenant's money. I think we all assume that is the case, but we want to make sure that that is, in fact, the practice across Rhode Island. And why is that important? First of all, as Representative Cruz has correctly illustrated, other states do it. As a matter of fact, you know, there are 15 other states that are getting it done. The details vary, but it's an established and proven policy solution. The banking system works effectively with the statutes in these states. Landlords are accustomed to it, and it works fine, and tenants do receive their dollars. There's a second major reason, Mr. Chair, and that's the possibility of, even in a modest way, helping families build wealth. One of the themes that the McKee administration under Governor McKee is aiming to strike, is aiming to put out there, is aiming to advance, is the theme of home ownership, helping families, including families of lesser means, families in poverty, families that are struggling, families that are making their way, individuals with all the same characteristics. We want to ensure that there's greater access to wealth building in general and to home ownership in particular. Even the modest ways of building wealth are welcome, and we want to make sure that we create the ways. To receive one's interest as is appropriate and as is due is one such way. Albeit modest, we want to make sure that it happens. A couple of specific details that matter, Mr. Chair and honorable members of the committee. As proposed, H. 7746 would require that interest payments be not less than the prevailing market rate of interest. The Department of Business Regulation publishes that prevailing rate, so this would be a competitive rate for savings accounts that's routinely published by DBR, not hard to access. Other states use similar methods to make sure that this is a fair interest rate. It does provide that if that's not working for any reason, DBR can establish alternative standards. There's a sentence or a segment of a sentence in the bill as drafted that would let DBR alter that rule if for any reason that system doesn't work. We expect that to work. In addition, a key feature, Representative Cruz appropriately referenced this as well, is that this bill would not apply to the smallest landlords. It only applies to landlords renting 6 or more dwelling units. We wanted to ensure that although this is not a burdensome provision, that the smallest landlords don't have to grapple with it in this initial iteration. We would want to see how this works. In Rhode Island, we expect it to work just fine. Again, this is a proven practice. Works for landlord, works for tenant, should be very successful. And we can always revisit that rule, but for now, we wanted to make sure that the smallest landlords don't have to specifically undertake this as a matter of law. Of course, we'd like to see them do it as a matter of practice. Bottom line is renters are cost burdened in Rhode Island. There is a lot we need to do to address our housing challenges. As Speaker Shekarshi correctly points out, it's largely about supply, supply, supply. We're doing a lot to catalyze supply. We are working together on regulatory reforms that are reasonable and that can free up developers to get more done at the local level. We're working in partnership with cities and towns. We're providing dollars for infrastructure through the Rhode Island Infrastructure Bank. We are creating a municipal fellows program to help municipalities staff up to do more housing, helping towns break down barriers. We are, of course, financing housing development through the allocation of state fiscal recovery dollars under the American Rescue Plan, and there is a proposal, of course, for a historically high figure $100 million bond for the purpose of housing production and related purposes. All those things must happen. In that context, though, we also have to help renters in even modest ways that help them get the money they're due and help them build wealth, and this is one such measure. Mr. Chair, thank you very, very much.
Any questions? Dave, yes.
As I read it, and I just want to confirm that I'm reading it properly, it would allow the landlord to draw upon the interest if there were additional damages beyond the security deposit. Is that correct? So again, if they have to draw on the security deposit because of damage to the unit, they could also draw on the interest as well?
Representative, I'd like to get back to you on that to make sure I'm reading the drafted statute properly. So I'd like to get back to you. It is certainly the case that the landlord can draw upon the security deposit itself, definitively.
Justine? Oh, okay. Any other questions? Thank you, Secretary. Appreciate you coming.
Mr. Chair, again, thank you for all of your work on this subject, sir. Thank you.
My pleasure. Do you want to put the rest in play? Yeah. I can see 3 on page 3. Yeah. And then, Matt, I'll have you and your witness up. Oh, yes, she wishes to be recorded as being here, and that it isn't a phenomenon of my imagination that she's sitting next to me. Oh, thank you.
Okay.
Representative Roberts is here as well. You want to put your bill in play there, young man? Would you like?
This bill comes to me from that guy, Mr. Delaney, who's sitting next to me. It's his idea to point out something that's fairly obvious. It just updates some the notice procedure in a cases of mortgage foreclosure, which seems probably technical to most people, but since the last 70 years, it's been done the same way, certified mail by the U.S. mail, which many people don't get. Many people, when they find out they have certified mail, they go out of their way not to get it. This just allows attorneys and such to come up to the present time, and most things, as you know, serious things come via FedEx these days, and UPS and other overnight carriers. But I'll let Mr. Delaney explain it.
William?
Mr. Chairman, good afternoon. Ladies and gentlemen, thank you for the opportunity to speak relative to my thoughts that I presented to Representative Dawson. I've been a Rhode Island attorney for 37 years. I've been an attorney for 41. I've spent the majority of my career doing commercial work, which includes, among other things, the good times relative to loans and the bad times relative to default and the consequences of default. One of the consequences to default, the ultimate consequence, is in the area of mortgage law, foreclosing a mortgage and foreclosing the ownership interest in real estate. There is a mechanism that has been promulgated by your predecessors that provides us the roadmap in which to effectively foreclose the rights relative to a mortgage and to the owner of the property being able to continue not to continue to hold ownership in the property and to let a successor purchaser take it, and also, practically speaking, be able to insure from a title insurance perspective, which I'm sure many or not all of you have if you own your own homes, to protect your rights to the property. The statute was promulgated in 1911 and through the years has been amended. Most recently, the year after I was born, 1955. Again, I'm going to be 70 in June, so this is sort of my send-off. It provides for notice, and the only thing that this amendment proposes is a change in the form of notice. It recommends the change from that of certified mail to, as my Senate Representative Dawson says, overnight through either FedEx or UPS or whomever is going to be a subsequent provider of such services. And it's to do it for one particular reason. It's to ensure or minimize the risk of the owner of the property not getting notice for any deprivation that they may allege, to due process and the opportunity to be heard. Quite honestly, the United States Postal Service is not quite effective, and it's not quite effective in the area of certified mail. Because, for example, if I was, and I was last week, foreclosing on a property, and through the mechanism in compliance with the statute under Title 34, I would have to send the notice of the demand, the notice that demand continues, the actual form of the publication of the legal ad that's going to run in the paper of general circulation in the area in which the real estate is located, through certified mail. If I didn't go to the post office and get a receipt, I have no guarantee that, in fact, that notice is ever going to be effectively delivered to the addressee, because I will not have the information to access the Postal Service software program to track that package. If I just stuck it in the mail, as I was wont to do when I was a young lawyer, but don't do it anymore, but and just dropped it in, I would not have had that ability, although there was no software program when I first started practicing law. But that being said, this has a consequence because there is a situation that has arisen. And I foreclosed through my career over 1,500 mortgages, which is a tough situation. But trying to do it by the book is one thing. What has happened over about 10 or 20 over that period of time has been a contest over the actual act of preparing, executing, putting in the mail, proper postage, that letter, with the green card, as you get when you get a certified mail. I have, as recently as a year ago, in the Providence County Superior Court business calendar, been the subject of a lawsuit by a guarantor of a commercial loan relative to the process that I conducted, because I did not go to the post office to send that entity a copy of all of the notices. I dispatched it in the mail. I had a receipt, but it was not good enough relative to what Judge Stern had wanted relative to ensuring that the due process for that particular owner received. So as a result, I had to redo the process. This process brings this entire notice up to the current time because of the practical point that the company that provides the overnight services will, within approximately 1 to 4 days, be able to come back and inform me whether or not this was a good address. And if it was not a good address, I still would have the opportunity to correct that situation. But languishing in the software program, trying to figure out where that green card and that envelope is going to be coming to is really difficult to ensure that the system works. So from a practical perspective, there are no substantive changes at all relative to this amendment. The only thing that is going to happen if you adopt this and recommend it to the House and the Senate goes and passes it and it's before the governor is that the mode of transporting the information is going to be transformed from the Postal Service to an overnight carrier, which brings us into the 21st century.
Any questions, Dave?
I see one major problem with this. When I was in Iraq, FedEx didn't come to my outpost in Iraq. So I'm just trying to figure out, again, I understand, and even if a person is on a military concern, third-party carriers aren't necessarily given access to that concern now due to security protocol at the gate. So I'm trying to figure out, U.S. Postal Service gets there, and you have a box, I have an address, APO addresses, right? U.S. Mail gets there, but if I live physically on the concern or on the base, third-party carriers can't get on.
When I was stationed in Turkey, back before you were born, sir, we got the mail. The amendment allows and continues the mail from the Postal Service to go to Turkey, to my base where I was sitting in a hut for about 6 months. There is no change relative to that. As a matter of fact, you make reference, and it's really important, the theory of law here in Rhode Island is based upon the state's rights to regulate it. I heard from the people who had made presentations before you before, all of what you're deliberating on is state in nature. The feds don't run real estate except in areas that involve itself with, among other things, federal lending programs, et cetera. These are commercial loans that I'm talking about right now. As far as the rights are concerned, under the SCRA, those are protected. The 3427 does protect those rights as well. This is the actual service of the notice of the foreclosure ad, which will be sent out. It will be sent out regular mail, and it will be sent out, well, it will currently be being sent out certified mail. So it will go through the United States Postal Service system. So it will come out to Iraq. It will go out to Turkey back in 1973. So that will...
Please, you're coming across as speaking down to me right now, so I'm going to ask, I'm just letting you know, so I'm asking through the chair, okay? I understand the mail gets to your hut in Turkey, because it got to my hut in Iraq. It got to the huts of my compadres in Afghanistan, so I know that. The thing is, you're authorizing it to be sent by overnight carrier, FedEx, UPS. They can't access these things. So in terms of allowing a active duty member to receive or to guarantee the receipt of it, FedEx can't get onto a fob in Iraq or a fob when we were in Afghanistan or a fob in Syria. They can get on, that your mail will get there, you're right. But what I'm saying is, this does not accomplish the goal of notice. Like you said, mail, regular mail got to me. You write me a mail, you write me, hey, postcard from San Francisco. That postcard, drop it in the mail, put a stamp on it. Yes, it gets to the person. You're adding a third-party overnight carrier. That third-party overnight carrier cannot get to every active duty service member.
Sir, I'm not trying to be disrespectful to your service. I'm not trying to be, I would point out again, I proudly served as an officer overseas, and I hold that near and dear to my heart. I had the opportunity to be educated under the GI Bill, and I really take my days in the military really reflectively, but I also take my responsibility as an attorney really important as well as the owners of these homes. It's to provide notice. The problem with certified mail is you get these green cards. Nobody wants to get the thing in the mail that says, come on down to the post office and pick up this green card, because it's never like, have a good day. I don't have clients coming into my office or calling me every day in 41 years saying, Bill, have a great day going forward. I don't get that. So the only point here is that regular mail is going to be, along with the overnight mail, going to be the subject of this amendment. If you want it to go forward, we can certainly deliberate it, but the point is that due notice with the opportunity to be heard. One of the things that you fought for when you were in, one of the things I fought for when I was in, is not going to be upset. The importance of the opportunity to be heard is a common tenet and the main tenet in our laws. And that is just the purpose of which I wanted to have this amended, because the reality of it is that the time and the expense associated with redoing this process adds on an additional 3 to 6 months, in which time the mortgagee is not being paid, in which time the mortgagor may be continuing to reside on the property. But if they aren't, they may be leasing it out to someone else, which will go and wreak havoc under the Residential Landlord-Tenant Act, which a couple of people have already talked about today. So all it does is push the stone down, forward down, and doesn't provide for formality. I mean, I'm not here to stir up the past. I'm just here to make things efficient. And from an efficiency perspective, we can't live in 1955 anymore. And what's going on today, again, we still have to abide by our rules of due process, which is something this amendment only helps to enhance.
If you were to strike and overnight delivery service, it's perfectly fine. But again, how do you define overnight delivery service?
But it's and/or. He can send in the mail to military folks that, like you say, the manner in which you want it delivered, that they can do.
And/or, but it doesn't mandate. Again, if you send it by FedEx or UPS, it physically can't get there.
Understood.
You go ahead, find out how much it's going to cost you to deliver a UPS package to a mountain in Afghanistan. I mean, I bet that's my point. You're saying you're trying to bring this up to date.
But in those situations, it would have to go U.S. mail.
Does it? It doesn't say that in here.
There's an obligation to make sure the person gets notice.
Sir, under the...
I'm not going to get into it.
No, but under the SCRA, there are special requirements that need to be made, including, among other things, again, my son-in-law, as a matter of fact, a Marine out in San Diego. He's being deployed overseas somewhere on April 4th for 7 months. He has a problem with his automobile as far as car loans are concerned. But the first thing he said to me was, Dad, don't worry about it. The SCRA is in place, and we don't need you to help us out if there's a default. Those provisions, those safeguards are there, and they're there for a reason, to protect what you fought for, what I fought for, and what he's fought for. But the reality of it is that there is a safety net. But the most important thing here to consider is, aside from getting married, the third most important thing you do if you have children, is to buy a house. And the problem that I have is that I don't want to do anything to jeopardize the transfer of ownership in that house unless I've done everything I'm supposed to do under the law. And I want the law to be fluid. I want everybody to understand what the law is all about. But unfortunately, people, when they sign the mortgage and they get the funding and then they have the house closing, they have the party with their family, friends, etc., they don't think about anything else except making the monthly payments. But when things happen and when things have to occur, that's when people get antsy. And that doesn't help me because my job is to enforce a contract that was entered into between two parties. And as far as getting it to, to a mountain in Iraq or a valley in Turkey where I was at, it still went to an APO. So, at least in my day. So, the notice was there. And if the problem that I saw, and I've seen for 30 years here in Rhode Island, is that nobody has been willing to put forward this issue of ensuring the due process requirements are met with bringing this notice into now the 21st century.
Okay, any other questions of the sponsor? Seeing none, we'll move on. I see Representative Newberry's here, and
I want to thank the committee.
He wants to come forward. He's got another committee he's going to be in. And then, Roberta, could we get text Representative Kislak? Tell her to come up.
Thank you, Mr. Chairman. I actually forgot the number of the bill, if you could say it, though.
I can tell you, it is 7648.
Thank you. I'll just introduce this briefly, and I explain where it came from and make more sense. One of my law partners does a lot of real estate law, and next to his office is our former colleague, Rep. Marcello, and I'm down the hall. And one day he came out to the two of us and said, take a look at this law, the existing law. And we did. He said, does this make sense to you? And this amendment to the law is designed to make a change. Basically, the existing law is designed to give tenants protection in case of a fire or casualty loss. You rent an apartment in triple decker, there's a fire, you're allowed under existing statute to terminate your lease, get your security deposit back, no questions asked, which makes sense. Nothing wrong with that. But the law, and I don't know if this has ever come up before, but we're all lawyers, we think like this. Under the existing statute, someone who intentionally sets fire will benefit from the statute. That can't possibly be the intent. Or someone who's the negligent cause of the fires. This is just designed to close a loophole. It may not be the biggest issue this body faces, but it really isn't. It should be fixed. That's really all there is to it.
Great. Any questions for the sponsor? Thank you.
Thank you.
All right, Representative Cruz, we have the Cruz agenda. 4 more.
Thank you, Mr. Chair. I'll start with 7957, and that is enact the right to counsel. So this act will create the Division of Civil Representation with the Department of Housing and require a designated legal organization to provide legal representation to all tenants who qualify in eviction proceedings. The act would also provide that notice of a tenant's right to legal representation be included in all residential landlord-tenant complaint forms, and that any attempt to waive that right in a lease would be void. Really, this bill is about access, a right of access to legal counsel for all tenants who face an eviction in unsafe conditions who cannot afford an attorney. This bill is about the right to counsel for tenants at risk of eviction. We are currently in a housing crisis right here in Rhode Island. I think we all know this. This crisis has many layers for access with burdensome fees just to simply apply, and all the way to the point of eviction. We know Rhode Island Legal Services and Center for Justice, who actually is here as an expert witness, I have John Karwashin over there, have been doing this work. And I've witnessed firsthand the insurmountable task of Rills and CFJ and other attorneys at the help desk, and their efforts are nothing short of miraculous every day. I watched as they saved countless elderly, disabled, low-income constituents of mine from homelessness and had positive results. The right to counsel is a necessary tool in this fight to attack this housing crisis. With something so detrimental to one's health, livelihood, and overall well-being, the potential loss of housing to homelessness should be just as much a right as that of a criminal defense that we are afforded in this country through our current criminal legal system. And, before these efforts, tenants in Rhode Island were underrepresented. So before that help desk, tenants were underrepresented 90% of the time, whereas landlords usually were represented by a lawyer. This was a tremendous imbalance. Tenants vulnerable to losing their home and being placed at risk of homelessness without the ability to assert that legal defense they may have. So that is the right to counsel. If there's any questions.
Any questions of the sponsor? I have one. You referenced an expert that was here to testify.
Yes.
Can you tell me who that is?
Yes, that is.
Oh, there's my man. How are you?
You are.
No, what I wanted to do is I want each side to have extra time for their experts. So I designated 2 for each side. So, and I haven't seen you since district court a long time ago. Good. Okay, next one.
Next one I'll introduce is 7961. So this act would impose a fine up to $150 per unit on a landlord for failure to deliver a copy of a state or local housing code violation to each residential tenant and notice to protect prospective tenants of the building affected by said violation within 30 days of its receipt. You know, this bill, this actually, the responsibility of landlords to provide this notice, this copy of this notice of code violations has been in our law since 1988. I have not seen one copy given. I've actually seen tenants go to the municipality and were told to go back to the landlord where it was refused to give that code violation. Refused to give copies of what could be unsafe in their housing. This bill is straightforward, it's uncontroversial, an essential effort to protect and strengthen the rights of tenants. Everyone deserves to live in a safe house free of health hazards. And I believe landlords should be held accountable when their properties are unsafe and knowingly rent those units to unsuspecting tenants. This has literally, again, been in the law since '88 and has yet to be realized. This demonstrates it's time to for a stick and to give municipalities and municipal judges more tools in their toolboxes to hold landlords renting unsafe units accountable and fulfilling their mission to keep their community and their residents who live within them safe. And again, such violations may include lack of proper lead certification, unsafe structures, improper ventilation, electricity issues, fire safety issues. And this bill helps to fix the problem by imposing a fine on landlords who violate these housing codes and not provide that copy. So that is this bill. If anyone has any questions.
Any questions of the sponsor? Yes, Dave.
I don't disagree. My question is, how is this enforced? Again, if the tenant doesn't find out about it, and if they go to code enforcement, and code enforcement isn't allowed to let them know it exists, how does anybody actually know that a violation of this section actually occurs?
Yeah, that's a great question. And, you know, I was a family visitor for 8 years with pregnant families and children up to 5, and tenants would call code, and code would come and inspect, and there would be a report, and it's given to the landlord. And then at that point, because of this law, because of this statute since 1988, the municipality will have to tell that tenant that the landlord is supposed to give them a copy. But because when they don't give them a copy, there's no way to enforce it, right? I mean, there really was no teeth. We were just going on the good faith of landlords since 1988 to provide that. Some municipalities and some code enforcement officers I worked with, fortunately for family safety, actually provided a copy and said they had for many years. But unfortunately, then some municipalities and their legal departments made tenants file APRAs and denied them of these code violations in their own unit, which I thought was even more unscrupulous. So this is a basic safety bill. I think it's about time since 1988, you know, to hold landlords accountable who don't provide these necessary documents so families know if there's unsafe conditions they live in.
again, I don't disagree. I'm just trying to figure out, like you said, up to this point, it has been enforced. Other than the fine, how can I, if I'm the tenant and my landlord violates this, I don't know my landlord has violated this. So is there a requirement on the landlord to bring back to the code enforcement documentation showing that the tenants were notified of the violation? Because again, the fine, I don't disagree with the fine. The thing is, just because the fine's there, we still actually have to know that the violation's taken place. And the fine doesn't fix that, but a notification requirement, i.e., once you have, the code enforcement knows you have 6 units, well, then they need to bring back a documentation showing that all 6 of those tenants have signed off on the fact that they received a notice of that. Because that's the biggest problem. Trust me, I like this bill. I like the bill. To do it, you need to know it exists. So there needs to be either a reporting requirement on behalf of the landlord or code enforcement upon the showing of a lease has to be mandated to show any violations within the building. That would be my approach to it. Personally, I would say if a tenant goes down to code enforcement with a copy of a up-to-date copy of their lease, then the code enforcement would be mandated, 0 fees charged for APA requests, whatever it is, would be mandated to show code, a code violation. And then there has to be, again, a mechanism to report the violation so that, again, we can come back. Just slapping the fine does no good if I can speed all day long, but if some of Representative Noray's colleagues don't actually pull me over and gun me for it, I can't do it. So we just need that mechanism. Like I said, I on its face, as of right now, looking at it, I like the bill. It's just, in order to do it, you need to be able to find out it's taking place.
And I just wanted to add some clarifying. So you talked about like 6 units, for example. If all 6 units are impacted, because it may be, in fact, it's only 3 of the units or 2 of the units, depending on wiring or what's happening there. In addition, the municipal court judges can actually fine it. So when they go in for those code violations and before that municipal court judge, it's at that point in time when the tenant who is in contact with the code enforcement officer can let them know that they were not given a copy at their request, or even not at their request, because they're supposed to give it regardless. And then that municipal court judge can act appropriately to fine up to $150 per day until it's provided. So I think there is a mechanism there, and thank you for that feedback, where it can be even close the loop even more to ensure that that's one of the questions asked of tenants when landlords are brought before code, to make sure that this was adhered to as well. So thank you for that.
Any other questions of the sponsor? Seeing none, your next, I'm sorry.
Yes, thank you.
Senator Roberts.
Thank you, Chairman. So I just wanted to ask, does this legislation refer to all landlords if it were to pass, regardless of number of tenants?
So this is what was in the statute since 1988. That is exactly how it's written.
Okay.
But I mean, if you're asking about maybe an owner-occupied or a small mom and pop, is that what you're?
It seems like it would be, I'm just asking, would it apply to a property owner who has, 200 tenants as opposed to 6 tenants? I'm just curious. Only because I think, the legislation is requesting legal representation for the renter, but not equal is there any place in this bill that would offer representation to the property owner equally?
This bill that I just introduced is actually for notice of fine if they don't provide a copy of the code. Although if you're asking about a right to representation in eviction hearings or things like that, right now, I mean, landlords are pretty much, research has shown up to 90% have access to landlords, I mean, to attorneys during those proceedings.
I'm thinking maybe the larger ones do, not so much the smaller ones. It could, because a lot of these
Maybe.
landlords, they're in this because they had to work for their properties, and to them, that is their source of income. So if we pass a lot of intrusive legislation, I think it's going to dissuade many people from even wanting to rent. And since we have a housing crisis, I'm just not convinced that this is the best way to address it. This is all I'm saying.
Yeah, thank you.
Thank you.
Any other questions? Okay, you want to do 7961?
Getting there. Oh, that was 7961. So I will go on to. Oh, yes, so 7960, that's what I'll go into.
Okay.
Okay. So this act would allow a landlord to remove a tenant from any housing accommodation or attempt such removal or exclusion from possession, notwithstanding that the tenant had no written lease or that the lease or other rental agreement has expired or otherwise terminated, except upon order of a court of competent jurisdiction, entered into appropriate judicial action, or proceeding in which the petition or plaintiff have established one of the several grounds of just cause set forth for removal or eviction. So this piece of legislation will work to prohibit arbitrary evictions, prevent displacement, discrimination, and retaliatory behavior we have seen time and time again by unscrupulous landlords, and is a driving factor in this housing crisis here in Rhode Island. In our state, many tenants are forced into month-to-month leases that bring uncertainty to the lives of countless tenants, and implementing just cause evictions protections would effectively halt this destabilizing practice. We know here in Rhode Island we have close to 40% of our population who are renters, and I've seen it over and over again, the negative impacts of unjust evictions. Tenants who pay their rent and abide by their rental agreement, and I've seen countless evictions brought toward those same tenants for simply asking for repairs for unsafe conditions in their homes. Retaliation that comes in the form of eviction notices and an abhorrent rent increases. Rent increases. Thank you. Should I keep going? Should I keep going? Mhm.
Just for helping somebody. It's retired. It's ridiculous. You take somebody, you want to help somebody. It's not right to be evicted for that.
Can we get her out? No? I'll keep going.
You want me to go talk to him? Yeah, go get the
People are suffering because
Thank you.
of this. There was a lady, she's living 20 years in a place. Just because she helped her son, they threw her out. She was there, but that's all she knows, that place.
impacting people's lives.
I do.
Thank you. So, as I've seen countless evictions brought toward those same tenants for simply asking for repairs to unsafe conditions in their homes, retaliation that comes in the form of eviction notices and abhorrent rent increases to units that tenants moved into with broken windows, infestation, and units that had no upgrades or repairs, unjustifiable rent increases that are retaliatory and driven out of greed and exploitation of people suffering the most in this current housing crisis: seniors, people with disabilities, working-class families with small children, and rent increases with no proof provided of a greater rise in landlord costs. So this is a public health crisis, and this legislation can work to curb some of these unscrupulous practices. We need to recognize that these arbitrary evictions not only disrupt the lives of the tenants, but also exacerbate our housing instability, contributing to a cycle of poverty and homelessness. It is only getting worse, and in the past 7 months, about 911 evictions have been filed for reasons unrelated to non-payment. I want to highlight that these behaviors are common among the landlord investors, now who own 25, 50, 100, 300, 500 or more units. Those who are not mom and pop landlords, which is defined by the National Realtors Association as a person who owns 1 to 4 unit dwelling in addition to their single family home. I just do not see these types of behaviors, unscrupulous behaviors from owner-occupied landlords or mom and pops as defined. And if this is not you, you should not worry. I'm happy to meet and discuss and support. As you can see already, owner-occupied landlords with less than 4 units are exempt from this legislation. And again, I'm happy to discuss expanding the true, quote, mom and pop landlords as just defined. And I want to add, I do sincerely appreciate those who are larger landlords who reached out and shared that they do not increase rents over a certain amount or at all and care for their tenants. This legislation should not negatively impact you, and if you have demonstrable cost increases, then it's something you can prove and is reasonable, and hence raise appropriately and reasonably under this legislation. Thank you.
Any questions of the sponsor? You want to go to the last one now? I think it's
Where are we at?
7965.
Yeah.
Mortgage foreclosure and sale?
Yes, thank you very much, Mr. Chair. So this act would provide prospective owner occupants a first opportunity to purchase properties acquired through foreclosure and would prohibit bundle foreclosure sales. And again, the intent of this is to promote owner occupancy by enacting legislation that provides owner occupants and affordable housing providers an opportunity for their offers to be considered on foreclosed properties prior to other offers, and ensure that the requirements of this section are consistent with the goal to expand home ownership opportunities, strengthen neighborhoods and communities in Rhode Island. So that is 7965. Thank you.
Any questions for the sponsor? Okay. Representative Kislak.
Thank you, Chairman and members of the committee. I'm really pleased to be here before you tonight on this night when there are so many really great bills up for hearing. And my contribution to this suite of bills to support and protect tenants and their rights is a transparency bill. And it started because I started hearing more frequently than I shouldn't have heard about it ever, but landlords are starting to require payment electronically online and not accepting payment in money orders or checks. And in order to pay the rent online, they are also charging a mandatory convenience fee. And it's not a convenience fee if it's mandatory, and it seems to be more a part of rent than a convenience fee if you cannot also pay in some way that is free. So that's how I started with this bill, is wanting to really address that and make sure that people could pay in a way to make sure that every landlord had one way that people could pay rent without getting an additional charge assessed to them on a monthly basis in addition to the rent. So that's how I started down this path. I then started hearing about other non-optional fees that are being charged to tenants, a mandatory move-in fee, mandatory renter's insurance, mandatory convenience fees for this or that or the other. And I wanted tenants to understand what they were being charged before they signed a lease, because I think that that's only fair, that they should know what they're going to be charged for rent plus anything additional that's outside of rent. I also, in researching this bill, learned that this is aligned with the Biden administration's priority to address junk fees for consumers in many areas, including in tenancy. And so I'm really pleased to offer this committee and the General Assembly the opportunity to make sure that tenants know what fees are being charged ahead of time. I just want to go through this bill very quickly because this is one of those instances that the summary at the end that we all look at is incomplete. And there's a lot of great stuff in this bill. First, it would require that convenience fees be prohibited unless there is a free way for people to pay their rent. Upon reviewing the language again in preparation to introduce this bill, I see a few things that I would want to do to just really clarify that intent in the legislative language with a sub-A before we move forward on it, but this is the intent of those sentences. Then all non-optional fees must be disclosed in the lease agreement, or in Rhode Island, so many people sign a lease for their first year and then become month-to-month tenants, and it could be that after the lease rolls over but is a month-to-month tenancy that there's nothing in writing, but that fees are imposed and new in a community. Maybe there's a new fee for something cool that then you have to pay. Anytime that happens, that would be required to be provided in notice, in written notice to the tenant. It would also require written notice of fees that are outside of the lease in the listing and the advertisement for the unit. It would also require written notice and disclosure about whether utilities are included or not in the rent. Usually that's disclosed, but actually not always. And so that's an important consumer information piece of information about whether the utilities will be within or outside of the lease and the landlord's responsibility or the tenant's. And in addition, I learned that sometimes tenants did not know who was providing the utilities. And I think it's a very important piece of information to know where they're going to be getting their utilities from and to have that information in writing when entering into the rental agreement. So, and then there's an enforcement provision, and that is this bill, and I hope you will join me in supporting this transparency measure. Thank you very much.
Any questions for the sponsor? Yes.
I just wanted to thank Representative Kislak for putting this in, because what you just said, we see over and over again with the hidden fees. They move in, and then they get slapped with them. Yep. They're required to have insurance, even though renter's insurance, but then try to use their renter's insurance to fix something that was pre-existing that their landlord's insurance should have been fixed, and filing claims on them and requiring them to put them as beneficiaries, the landlord. A lot of really unscrupulous things happening. The utilities, where one tenant unknowingly knows that they're paying for everyone's utilities because they're all hooked onto one unit, and it wasn't disclosed. So a lot of these things happening that you mentioned, and I want to thank you for putting this in, and really this will help to curb a lot of what's happening to tenants and our public health crisis and our housing crisis here in Rhode Island. So thank you so much.
Yes, and thank you very much. And that situation that is far too common, that I hear about a lot, that you hear about a lot, about one tenant paying the utilities for more than one tenant. That's actually a current code violation, so it meshes nicely with another bill that you've presented for tonight that's already illegal. And the tenants, right now, the current law is that if a unit is not on its own meters, then the landlord is supposed to be paying for the utilities for that tenant in the whole building. But we know that that doesn't happen also. So thank you very much. I also want to say that this started as I was annoyed on behalf of the folks who had approached me for this $6 a month convenience fee in multiple different situations, $3, $5, $6, $8, a small monthly fee. And as I was doing the research for this bill, learned that it's actually not uncommon for people to have hundreds of dollars a month outside the rent that they're expected to pay. So, thank you.
Any other questions for the sponsor? Yes, Tom.
Thank you, Chairman. Thank you, Representative, and I'm glad Representative Cruz brought up utilities. What are utilities? I guess that's a question I'm asking you, because I know what I see as utilities, but what are utilities?
So I'd have to go back and look at our general statutes, because I think we have a definition, but
We actually don't.
we
So
don't.
30
Okay.
34, 1811 definitions under Residential Landlord and Tenant Act. Utilities is not defined. So we may want to amend that before we require, because I consider cable a utility. So would we have to tell them that streaming services, Hulu? So again, I know it's
Right.
sounds kind of frivolous, but let's define utilities
Yeah.
before we're actually making a list.
I would be very happy to be very specific, and also I think that in a different part of the statute, of our statutes, for the PUC specifically, may actually define utilities, and that's what I was thinking of utilities, although we can incorporate that. And I would also say that sometimes in some apartment communities, cable fees are one of those non-optional fees. So it's not a utility, but it's you're going to pay rent and then this amount of money for cable, which everyone in the building gets. So I can see that being separately. I would love to regulate access to internet and cellular phones as a utility, and I think that that's a deficit in our statutory construction, but that's for another day.
Sure. Thank you.
Thank you.
Any other questions? Yes, Sherry.
I made that statement about utilities, about it being all on one. I was referring to heat, which under the building maintenance code has to be provided, right? Or a working heating system.
Right.
And that's what I referred to when I said utilities, just to clarify that and how they were hooked to each other. And when one person's gas went off, which provided the heat, everyone's heat went off.
Yep.
Unbeknown to the tenants who were paying, who they were told it was included.
Right, and the current code requires the ability for each unit to heat their apartment up to 68 degrees in the winter, which is the current law, and also requires that each unit, if they're paying separately, can regulate their own heat and be on their own meter. So we know that in our old houses in Rhode Island, that often there is one thermostat for more than one apartment. So,
Any more questions? Thank you. Representative Giraldo, you're up.
Thank you, Mr. Chairman and members of the committee. I am here today to present House Bill 7963, which would prohibit a landlord from explicitly inquiring about the immigration or citizenship status of a tenant or prospective tenant. I'd like to be clear, though, before we get into the merits of the bill, that nothing in this law prohibits a landlord from complying with any legal obligation under federal law or application, or from requesting information or documentation necessary to verify the financial qualifications or the identity of a prospective tenant. This means you can still ask for information like pay stubs, past utility bills, verification of work, that sort of thing. The good news is also that for an overwhelming majority of landlords across Rhode Island, this is a non-issue. They don't ask about this. They have no reason to ask and recognize that it's probably unnecessary and inappropriate to ask. As a former landlord of a 3-family home, I honestly believe that asking for someone's immigration status is unnecessary to this tenant selection process or tenant-renter relationship at all. So why I put this forward if the overwhelming majority of landlords don't feel the need to require to ask this information? Quite frankly, it's for the small problem landlords that do, in particular for the ones that use it as leverage against renters. It's a small number, I'm sure, but there are predatory landlords that use low rent to entice people into apartments in poor conditions and then use knowledge of their immigration status as a way to force them into accepting atrocious living conditions or bullying them from reporting things to code enforcement. This kind of activity is cruel and inhumane and can be frightening to anyone, regardless of their immigration status. Threats or bullying from someone about their status is unacceptable, whether they are here on a student visa, refugee status, in a family with mixed citizenship, all of those things. And at least in my own personal experience, to be straightforward, it's usually people of color that are receiving this type of threat or facing this type of predicament. So in closing, this bill aims to prevent abusive practices and makes it so that Rhode Islanders can rent with dignity, and it would also strengthen and encourage compliance with the state's Fair Housing Practices Act and Federal Fair Housing Act. Many other states have passed similar bills: California, Michigan, New York, and North Carolina. And I thank you all for your time and consideration of this bill.
Any questions for the sponsor? Yes.
See how common it is. I just got a call a few hours ago about this same thing, about a landlord using the tenant's immigration to threaten them when they ask for something to be fixed. Pay their rent, they help even clean up outside the property, and literally get a text from someone asking for help because they're being threatened because they asked for something to be fixed. So I want to thank you for putting this in.
Appreciate that. I think that behavior is absolutely disgusting and despicable. And when I worked for the city of Central Falls, I remember residents coming in scared to go to code enforcement because of their landlord having knowledge of their immigration status. And it was an absolutely heartbreaking thing. And so this is just a protective measure that would help in situations like that.
I agree. Any others? Okay. Thank you, both of you. Representative Morales. Edie, would you want to do yours next? Yeah.
Thank you, Mr. Chair and members of the committee. I am proud to introduce House Bill 7962, as it would further codify the rights that renters have to formally organize among each other and collectively advocate through the formation of a tenant union. This legislation would further establish a much-needed hearing procedure for tenant unions to formally file grievances and concerns through the Housing Resource Commission. For background, a tenants union is essentially a group of renters that reside in the same residential building or rent from the same property management entity and or landlord that have come together for the purpose of engaging in mutual aid, social support, and or collective advocacy related to the conditions of their living spaces. In practice, tenant unions serve, act, and adopt a collective bargaining model similar to one of a labor union. For context, the right for tenants to organize and form a tenant union has been state law since 1986, specifically Title 34, Chapter 18-46, the prohibition of retaliatory conduct. Despite being state law, however, there have been countless attempts from landlords and property management companies in recent years to stall the formation of tenant unions through various forms of retaliation, most notably threats of eviction and deferral of unit maintenance. One of the most notable examples of these threatening and harmful behaviors happened last year in West Warwick, when tenants living in units owned by Pioneer Investments came together to demand better living conditions, considering that their units were full of code violations, such as the presence of rats, bugs, mold leaks, lack of heat, lack of hot water, raw sewage, and lead paint. And tonight you're going to hear directly from some of these tenants who were a part of these ongoing organizing efforts, who could tell you a little more in detail about the housing conditions that they had to suffer that forced them to mobilize in the first place. Now, despite initial requests that these renters did make to their landlord before they ever even thought about organizing, they were ignored. They were ignored, which is why they ultimately came together to organize and form what is now known as the Pioneer Tenants United Union. When they did this, however, they were immediately met with threats of retaliation. Threats of retaliation in the form of being evicted. Similarly, there is an ongoing lawsuit happening right now between Elmwood Realty and tenants who have been facing serious threats of intimidation and retaliation since they started organizing. And if you look through your written testimony, you will see literal pieces of evidence and actual links that will take you directly to audio voicemails that the property manager left to tenants, essentially threatening them to stop organizing amongst themselves and to stop having motions of social advocacy. In other words, don't make us look bad to the media, otherwise we're going to find a way to be able to get you out of these current units. So all that said, this is why it is necessary to have this legislation. That way we are formally enshrining existing law that states that renters have the right to organize and form tenant unions, as there is also an element to this legislation, which I will speak briefly on in regards to allowing tenant unions to formally register with the Rhode Island Department of Housing. Because needless to say, it's not just enough to have the right to organize. We also need to have formal procedures in place that recognize tenant unions. And so on that note, I'm going to talk about the second half of the bill. The second half is in relation to outlining a specific and transparent process for tenant unions to file complaints with the Housing Resource
think we're back, so you can continue, Representative Morales. We're back in session? Can I ask everybody to be quiet? We're going to continue with the meeting now.
Thank you so much, Mr. Chair and colleagues. So, as noted, I thankfully was able to time it to the point where I was able to describe the first half of the bill as relates to the rights that tenants have as relates to organizing and ultimately being able to form a tenant union. For the second half of the bill, I want to be able to note that the legislation would outline a specific and transparent process for tenant unions to file complaints with the Housing Resource Commission, which would be the public body responsible for administering public hearings to address complaints related to dire housing conditions, retaliation, and violations of tenant rights. So in other words, if there are housing laws being broken, there is a way to file a complaint and have it be heard. As necessary, the commission would be authorized to coordinate with local city and town departments to obtain information and records that would support evidence and contribute to the hearing, whether that is on behalf of the landlord, the property management company, or the tenant. The commission would also be authorized to refer complaints to the relevant town, city, state, or federal agency and ultimately ensure that they are taking action to address the complaint in question. If the commission determines after a hearing that they did not refer out to, but ultimately had it in-house and ultimately determined that there was a municipal ordinance or a state statute that was being violated as it relates to our housing laws and tenant right laws, the commission would have the ability to order the suspension or reduction of further payment as it relates to rent up until such time has passed that the landlord and or property management company has made the necessary changes, repairs, or installations in order to ensure that the house is up to code and is no longer in violation of any housing laws or tenant rights. Alternatively, the commission would also be authorized, if they chose not to suspend rent, they could essentially order that tenants submit their rent into an escrow account. An escrow account under the Housing Resource Commission that the landlord would ultimately be able to have access to in terms of the funds once the necessary repairs have been made and they are no longer in violation of any housing laws. And this is very similar to legislation that we passed last year, when we passed a law essentially stating that if you were in a household where there were lead hazards and you were able to prove it in court, that you could have an escrow account that would be managed by the state that, again, the respective property management company or landlord would not have access to until the repairs are made. So far, it has been a successful model since it was officially law in September, hence why we want to emulate a similar model to ensure that regardless of whether it's related to lead or any other safety hazards, there is a process in place to ensure that there's an incentive for the repairs to actually be made. And as I close, I will add that I did have conversations with members of the Housing Resource Commission in regards to the responsibilities that they would be tasked with under this legislation. And following our conversations, I have ultimately determined that due to the nature of the Housing Resource Commission, the fact that it's driven by volunteer members, that the model that we have outlined in this legislation should still proceed as is with the amendment that instead it be the Rhode Island Department of Housing, our state agency with full-time employees, that should be responsible for administering. So in other words, I would make a request for an amendment in relation to this bill, not to alter any of the substance or the process, but instead to enable the regulatory body to instead be the Rhode Island Department of Housing. All that said, in an ideal world, we would not need legislation to outline what a hearing process looks like anytime there's violations of housing laws or tenant rights. But the ultimate reality is, more often than not, people who rent tend to be working class people, those of lower incomes, who don't often have a formal voice when trying to share their concerns or complaints as it relates to housing violations. While it is different for every municipality, our code enforcement teams, more often than not, are not fully staffed. So even when you try to make repairs or reports about ongoing issues, they still go ignored. Hence why there is a need to ensure that there's a process in place to have these hearings. I'll take any questions. Thank you, Mr. Chair.
questions for the sponsor? Seeing none, thank you.
Mr. Chair.
Yes, our second vice chair is here.
May I
He would
have
like to be
my,
recorded on his
yeah.
votes, on his menu choices,
And my presence, please.
and his presence.
Thank you.
Edie? Thank you.
Thank you, Chairman Criven. Bill 7304 is a bill I introduced at the request of the Rhode Island Human Rights Commission. It makes changes to the Fair Housing Practices Act, and I want to say at the outset that it needs some sub-Aing, because it's aiming at people who live with assistance animals or service animals, but it only mentions assistance animals. So I will read how I would like the legislation to read. On page 3, the term assistance animal means an animal that has been determined to mitigate the effects of a physical or mental disability by a physician, psychologist, physician's assistant, nurse practitioner, other healthcare provider, vocational rehabilitation specialist, or licensed social worker. And then item 20 is the term service animal means a guide dog, hearing dog, or other dog that is specifically trained to assist a person with a disability to perform independent living tasks. The provision of emotional support, well-being, comfort, or companionship do not constitute work or tasks for the purpose of this definition. So we would be defining assistance animal and service animal on page 3 in the sub-A. And then on page 7, we would be deleting the current section 2, which begins on 21, and goes through most of line 27, and substituting that with an owner may not refuse to make reasonable accommodation in rules, policies, practices, or services to allow a person with a disability who has a service animal or assistant animal, or who obtains a service animal or assistance animal, full and equal access to all housing accommodations provided for in this section, when those accommodations may be necessary to use and enjoy a housing accommodation. A person with a disability who has a service animal or assistance animal, or who obtains a service animal or assistance animal, shall not be required to pay a pet fee, pet deposit, or other extra compensation, but shall be liable for any damages done to the premises by a service or assistance animal. And going on to page 8, in determining whether a dog qualifies as a service animal, an owner shall not inquire into the nature extent of a person's disability, or require documentation such as proof that the dog has been certified, trained, or licensed as a service animal, unless it is readily apparent that the dog is trained to do work or perform tasks for an individual with a disability. An owner may ask if the animal is required because of a disability and what work or task the animal has been trained to perform. So that's quite simply adding service animals, and essentially service dogs, and assistance dogs to our Fair Housing Practices Act. And I would ask that the committee strongly consider amending the bill as I've quoted and passing it, and therefore protecting people who need service animals or assistance animals in their housing. Thank you, sir.
Any questions for the sponsor? Thank you. Okay, we've got a few more bills we're going to put in play, but the sponsor's on here, except for myself. So I'll put the, my two bills in last, so I can answer questions. The next bill is 7372, sponsored by Representative Perez. It's an act related to Residential Landlord and Tenant Act. It limits residential rent increases to 10%, plus the increase in the Consumer Price Index, also known as CPI, and that would be annually. The next bill to be put in play is, let's see, Representative Perez again, 7959. It's an act related again to the Residential Landlord and Tenant Act. It prohibits a landlord from inquiring about the immigration status of a tenant, subject to any federal laws or regulation, but may request financial information or proof of identification. Let's see, the last bill is by Chairwoman Baginski. It's an act related to the Residential Landlord and Tenant Act. It prohibits the use of algorithms or artificial intelligence to set residential rental amounts and prohibits landlord price fixing of residential rents. Violations constitute a deceptive trade practice, and violators are subject to civil suit. And the last two are my bills. The first would be 7951. It's an act related to cities and towns, the Rhode Island Comprehensive Planning and Land Use Act. It provides amendments relative to the compliance and implementation of the Comprehensive Planning and Use Act, including the conditions upon which limitations may be placed on land use applications by municipalities. I would be happy to answer questions on that now or wait till the end, because we have our expert here who was very helpful in not only creating these bills, but also last year's, not yet. She was very much responsible for the legislation that was passed last year in relationship to housing. And the last bill of mine is an act related to cities and towns subdivision of land. It makes amendments to various provisions relative to subdivision of land review stages, special provisions related to the development and the procedures for approvals from various permitting authorities. A lot of this can be explained in rather more, the Felix bill, okay.
Yeah, one more. 7950. Sponsored by Representative Felix. It's an act related to cities and towns subdivisions of land. It provides amendments relative to permitting authority of and acceptable forms of financial security, permissible for construction and/or improvement guarantees relating to the completion of required public improvements. Those are called bonds that developers put up when they haven't finished building a road or some other form of infrastructure. So we have our expert here. If there are any specific questions, I'm happy to answer any of the questions in reference to my two bills. If I don't see any, do you want, anybody wish to come forward? Is that good enough? Okay. So that completes the, as I say, anecdotally, putting all bills in play, all 24. Now we're going to go to the testimony of the members who have signed up from the public. The first four are going to be two pro, two con, without picking sides. I'm just trying to
differentiate which position you stand for. And then they will be allowed to testify to 5 minutes each. The balance of, believe it or not, the 89 additional people that will be testifying, 90, will be 2 minutes each. We will be keeping time. You'll hear that quasi-annoying little ding, 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 or beep, beep, beep. And I'll ask that that you do your best to wrap it up as soon as you hear it. It's not my desire to prevent anybody from testifying, but as you sit there and listen to some other people, you may find that some people have said what you said. So I would ask you, as I do in my profession, when I go to court, I try to think of what is the one thing that I want to leave with the judge or the jury. And that usually is something in my heart. And then, as opposed to telling us what the law is. Usually it's some perspective that we can't relate to because we're not in your business or in your situation. That being the case, let's see, Justin Mann and Shannon Weinstein. And then after that, it'll be John Washington and Jennifer Wood. Everybody that testifies, your red light's got to be on.
All right. Good evening, everyone. Thank you for having us today. My name is Shannon Elizabeth Weinstein, and I'm here to testify on behalf of the Rhode Island Coalition of Housing Providers. I am a realtor, property manager, and a landlord of 17 years in Rhode Island. We would like to be on the record as opposing Housing Bills 7049, 7960, 7372, 7962, 7957, 7961, 7746, 7174, 7647, 7305, 7304, 7162, but recognize in the interest of time, I'll focus my testimony in a few areas. First, I would like to address the idea of just cause eviction, including Housing Bill 7960, as it is detrimental not only to housing providers, but to tenants as well. While even the title of the proposed law insinuates that tenants are being unfairly displaced at alarming rates, the data shows otherwise. It is important to understand the context of previously reported post-pandemic high eviction rates, which have since fallen. It is also important to understand the perspective of housing providers and the tenants that they serve, which I hope to briefly outline tonight. We all know that the COVID-19 pandemic wreaked havoc on the lives of everyone possible, and it was no different in the housing market. During this time, there was a national eviction moratorium in place, which started in March 2020. Rhode Island, within reason, upheld this moratorium for a longer period of time than some other states, and even when the moratorium was lifted, made it so a tenant could not be evicted so long as there was an application for rent relief submitted. Reasonable. Rent relief programs were available in Rhode Island from March 2020 to September 2022. During this time, evictions fell to lower levels than usual, but when funds were no longer available, there was a backlog of evictions that were unable to take place for over 2 years. Yes, there was a spike, but on average, eviction filings remained close to the norm. Now, those eviction proceedings have returned to pre-pandemic levels, and according to Rhode Island Housing, eviction filings for reasons other than non-payment have reached a 2.5% decline on average for the past 13 months in comparison to pre-pandemic levels. That's for 2016 through 2019. There's actually a graph here too if you'd like to look at it. Evictionlab.org even reports that eviction filings in total since the pandemic are 85% of what filings were for the same time period in Rhode Island prior to the pandemic. Providence ranks lower at 77%. And it is also worth noting that eviction filings do not always translate to eviction executions or judgments, meaning a filing can happen, but it doesn't mean that the person actually gets evicted. In my experience, tenants are likely to have adequate time to remedy their actions and/or even enter into a stipulation agreement, which is a payment plan to get caught up. Housing providers do not want to evict people. It is not something to be taken lightly for many reasons, and that includes financially as well. No property owner hopes to get into a situation where they must incur expenses of lost rent, attorney fees, and on top of it, more times than not, have to have large turnover expenses in order to make the property habitable again. Eviction is very costly. Just cause eviction makes it so that the landlord cannot terminate a lease agreement. While there are many reasons to terminate tenancy, this is one of the most worrisome for neighboring tenants. You see, without the right to terminate a lease agreement and ask for someone to peacefully move out and avoid an eviction, the burden becomes greater in proving that the tenant is breaking a clause in their lease or even the law. Just cause eviction shifts the onus to the neighboring tenants to report the evidence, which in many cases may not be safe or comfortable for them to do. Hard evidence is required for evictions for reasons other than non-payment, which is a forced remedy if termination is no longer an option. Good tenants may be placed in harm's way by subjecting themselves to retaliation, or might even give up and decide that they must uproot their families and search for new homes, since the problem cannot easily be resolved. While I know that the overwhelming amount of tenants are good, hardworking people, I have also seen the other side to that equation, and the stories are serious. I am happy to discuss that in another forum if you'd like. This does, however, bring me to another point to touch on. Just cause eviction, especially in conjunction with any other housing law that seeks to reduce the application process for or provide fair housing protections to convicted criminals, really creates a worrisome situation. Many of our tenants are happy to submit their application and answer questions, as it provides the peace of mind knowing that we will not just let anyone move in. Of course, within the current fair housing law, which I do think is justly focused on protecting marginalized populations. We understand that everyone needs a place to live, but we also understand that certain considerations must be made. Bill 7174 protects even those who have committed the most heinous crimes, as it provides fair housing protections to any previously incarcerated individual. Unfortunately, it is also possible that this law would disproportionately affect those protected under fair housing law most. We know that high-density rental housing cities that have high-density rental housing statistically house the larger percentage of our minority populations, which are justly protected under fair housing laws. So it would be fair to say that this proposal would hurt those populations disproportionately in a time when equity is at the forefront of so many agendas. I had some more to say, but I'll wrap it up. But if you have any questions, I would be happy to answer.
Thank you, Shannon. Any questions of this witness? Representative Caldwell.
Can I share I think we're sharing a microphone. Thank you so much for coming in and for your testimony. Because I wasn't following along with the agenda when you listed all of your bill numbers at the
There's a lot.
beginning, I could look at them. I'm sure you sent in written testimony. Were there any of the bills that your group is either not opposed to or supportive of on the agenda? Like I'm thinking of Rep. Giraldo's bill about the immigration status.
Yeah, actually, we don't have any issue with that bill. That was something that I was going to touch on.
Okay.
So that's the one that prohibits the inquiry about immigration status. That one, we think that's written well, as long as we can do our due diligence and we can, get everyone's identity, do the normal application process that we would for everyone. That's fine. I would act in accordance with that anyway, because I think asking a question like that subjects us to liability. So why would you do that? So we're completely fine with that. We're not ICE. We're not La Migra. We're here to rent our housing.
Okay, thanks. I'm just, at the start of the hearing, I was trying to find any places where we already might all have some agreement and some places of compromise, so.
Yeah, that would be one that I would say out front, I think is great.
Rep, go ahead.
Thank you.
Roberts.
Thank you. I just wanted to ask a question in general, if you could answer it for me, was during that time when when rent was suspended during COVID, how did the landlords recover their money to make their payments on time? Because if they're not able to do that, they can't provide housing for anyone.
Very, very good question. So it was a very difficult time period. I was happy to see that the landlords that I am a landlord, but I represent a lot of landlords in my business, and I was happy to see that everyone was really working with their people. But the truth of the matter is, with rent relief, it was a tough period because the application process would go in, and most of the times, even when it was considered to be running quick, landlords weren't seeing their rent for 6 months at a time, sometimes longer. So it's great that that happened, but it was a time period that I think that landlords and tenants were really working together. That's what I saw, at least in my experience. Everyone was working together on that. But it was tough. It was tough for the landlords. You know, you have your mortgage payment. Most people, you know, they're using their rent to pay their mortgage payment. They're not independently wealthy. And you have a mortgage payment to pay. And going 6 to 9 months without receiving any rent relief was a burden on them. Yeah.
Okay, yeah, so I was just asking that question just because I think that there's a lot of things that we need to consider because we don't want to hurt the housing availability when the speaker is working so hard to close that gap. So I think that we need to be careful in what we pass in legislation. So that's why I was bringing that up. We just don't want to hurt the landlords either, so.
Yeah, exactly.
Okay, thank you.
Got to work together.
Yes.
Seeing no more questions, go ahead, Justin. Oh, sorry. All right. Oh, and I want to recognize Chairman Corvese and that he's here, Roberta, and do you want your vote counted in the affirmative? Thank you. Did you have anything else to say? No? And, Representative Place.
I guess it's kind of a statement, but a question at the same time to see whether or not, and to save the time for both witnesses up here, I'm assuming you're both here representing landlords
Yes.
on the issue. Last night, I'm in HHS. Last night, we were hearing legislation on nursing homes. And the situation there is, over years, similar situations. You hear these very, very personal stories of how people have been abused, in their case, in the nursing homes, in this case, in the rental environment. And the epiphany I came to, sitting here listening to testimony, is we're approaching a situation where if we start passing laws and regulations into the rental market the way we did the nursing home market, at some point in time, the only landlords we're going to have left are the state and large corporations. There will be no more mother and pop. There will be no more resident tenant. There will be no resident owner operator, whatever you want to call it. Those are going to disappear. And I used a different term, beginning with an F, to describe the situation where we would find ourselves in our rental environment. And my question to you is there a point where you're just going to say, I don't want to do this anymore, it's not worth my time, I'm going to sell to a big corporation who doesn't really care and has the lawyers to overcome all of these laws and regulations that are being proposed in here tonight?
Well, I think the problem is that this legislation, you know, might force some people into that situation. And more than likely, it is going to be the mom and pops that have taken care of their properties and they're trying to build equity and use it for all the right reasons, whether it be sending their kids to school or what it be. And, I don't think that's necessarily fair. And to your point, the less landlords that we have, if it does turn into state landlords or big corporations and there's less of them, less competition just means that they are going to have more control to do whatever they want at that point. And at this point, even with companies being involved, investors and whatnot, there's plenty of them in the state to go around, and there is competition, which helps us keep our standards up as well. That's what competition is supposed to do.
The question was to both, to save time and efficiency.
Yeah, I appreciate that, Representative Place. If I may, I'll answer it and echo some of what she said. There absolutely is a breaking point for everybody, because at the end of the day, this is really a math discussion, right? When you're talking about real estate investment, if you've ever spent any time in the space, you understand that it is a get rich, if you will, very, very slowly process. And at the end of the day, money is mobile. And so the investors that are putting money into this state right now, into the residential real estate space, do not have to. They have choices. Their money is mobile. They can go elsewhere. I can tell you that we've worked with clients that have brought money to this area from the likes of Boston and other, municipalities like New York, right, where the cap rates had started to get to a point where it was unsustainable for them, so they looked for a better place to put their money. And we want them to bring their money here. And so I would ask the committee to consider this from the perspective of an ecosystem demands balance. And I understand, and I've heard a lot of stories just listening here, that there has been actions against tenants which is not defensible. But I would also suggest that painting all landlords with that brush is folly, and it is a very dangerous and slippery slope we find ourselves on. Because at the end of the day, as Shannon had said, it will actually be the mom and pops that will fold first, as it were. And I think you can liken it to the banking analogy, right? A couple of decades ago, we had tens of thousands of banks, right? It has been consolidated over and over and over again, where the regionals now are actually most at risk. And we saw bank failures. And with the lack of banks as an analogy, we lost the competition. And with the lack of competition, it really causes problems for the overall market. Thank you.
Okay. Oh, go ahead, Rep. Norrie.
Quick question. So Shannon, I know Representative Caldwell asked about written testimony. There's 151 pieces of submitted written testimony. I'm not seeing your name here. Did you submit the written testimony?
Mine is being submitted with the
Perfect.
lobbyist.
Thank
too.
you.
Yeah. Yep.
Okay. And so next is Justin Mann, and the two of them are from the Rhode Island Coalition of Housing Providers. So go ahead, Justin. You have 5 minutes now.
Thank you. I'll be brief. Thank you so much. I genuinely appreciate everybody's time. I understand this is going to be a long night, so I'm going to only be speaking to House Bill 7049 and 7746, and I'll address rent control first. Honorable members of the committee, I sit before you today in opposition to this bill, as well-intentioned as it is, and I do understand that. Rent control does not solve the issue of affordable housing. In actuality, it is proven, and we will talk about that shortly, to hurt the people that is intended to help. I would call your attention to a quote from Swedish social economist Assar Lindback, who all the way back in 1967 concluded, "In many cases, rent control appears to be the most efficient technique presently known to destroy a city, except for bombing." The idea of rent control is not new. The first rent control laws were adopted all the way back in the 1920s. So we do actually have plenty of data on this, and we've looked back over the decades of data. For instance, in the May 1992 issue of the American Economic Review, a survey of 464 economists, both conservative and liberals alike, found that 93% of those same economists agreed, if you can imagine this, 93% of economists agreeing on something, that a ceiling on rents reduces the quantity and quality of housing available. Put another way, economists as different as the late Milton Friedman all the way up to Paul Krugman wholeheartedly agreed and confirmed that rent control doesn't work. A 2018 Stanford study found that rent control in San Francisco reduced rental supply, led to higher rents for future renters, created gentrification, and reduced housing options for all but the wealthiest of people. We can call our attention to a study actually done by none other than the U.S. Department of Housing and Urban Development regarding rent control, which they concluded it reduces the supply. This was based on a study of the data for St. Paul, Minnesota, which adopted rent control and saw that multifamily building permits, plunged 47% after St. Paul passed rent control laws. However, building permits in neighboring Minneapolis, St. Paul actually increased by 11%, and in other municipalities around the country that did not pass rent control laws. I would ask you to think about the effect of building permits plunging by 47% in this state, where Rhode Island already ranks dead last in the country for the issuance of building permits. But the good news is we also have data that tells us what happens when rent control is reversed. It's called decontrol, and we only need to look to our neighbors to the north. An MIT study that was done found that when rent control was removed from Cambridge, Mass. In the 1990s, rental housing quality improved as maintenance got funded, crime was reduced, and nearby property values improved. While rent control is an understandable emotional response to a broad spectrum of economic conditions, the data has proven over decades and decades the following, and I'm almost about to wrap this up. It hurts the people that it's supposed to help the most. It gives housing providers little incentive, let alone little funding, to reinvest in their housing stock because they actually don't have the money to do so, leading to housing blight. Okay, so there's a degradation of an already aging housing supply. And lastly, it reduces the housing supply overall because as an investor, a developer, somebody looking to put money into the state and construct new housing units, which I think we can all hold hands and desperately agree we need, those developers are disincentivized because they have no encouragement that their investment in the state is going to get paid off because there's controls placed or government controls placed. I'll end you with this quote. The philosopher George Santayana famously said that those who cannot remember the past are condemned to repeat it. So let us not forget the lessons of our past now by implementing rent control policies that we already know do not work.
Thank you.
Thank you for your
Justin.
time.
Any questions of this witness? Seeing none. Now, thank you both for your testimony.
Thank you so
Thank
much.
you.
Next is John Washan and Jennifer Wood. Welcome. Did I say your name right, John? Okay.
Thank you to the members of the committee for allowing me to be heard on this topic. I'm here to express my strong support for Rhode Island House Bill 7957, which seeks to establish a right to counsel for tenants facing eviction. As a former public defender and current housing lawyer at the Rhode Island Center for Justice, I have a firsthand experience representing individuals in legal proceedings. It resonates deeply with my professional experiences and underscores the vital importance of legal representation in safeguarding the rights and interests of vulnerable members of our community. My experience as a public defender has taught me that access to legal representation is not just a matter of fairness, but a fundamental component of a just and equitable society. When individuals have access to competent legal counsel, they are more likely to receive fair treatment under the law, achieve positive outcomes in their case, and avoid unnecessary hardship and displacement. By enacting this legislation, Rhode Island has the opportunity to demonstrate its commitment to protecting the rights and dignity of all its residents, regardless of their socioeconomic status. House Bill number 7957 recognizes the fundamental importance of providing tenants with access to legal counsel to help level the playing field in eviction proceedings. This bill enhances the integrity of the eviction process by ensuring that all parties are on equal footing and have the opportunity to present their case effectively, by ensuring that tenants have knowledgeable advocates to represent their interests and protect their rights. This legislation not only promotes fairness and due process, but also helps to prevent homelessness and stabilize communities. Moreover, investing in right to counsel for tenants facing eviction is economically beneficial for the state of Rhode Island as a whole. Stable housing is foundational to economic progress and public health. By preventing homelessness and preserving tenancies, this legislation would contribute to greater housing stability, reduces reliance on emergency services, and mitigates the strain on social services. Studies have consistently shown that the cost of providing legal representation to tenants is far outweighed by the savings generated through reduced homelessness, decreased reliance on emergency shelters, and increased housing stability. By enacting House Bill 7957, Rhode Island has an opportunity to lead the way in safeguarding the rights of tenants and promoting housing stability for all residents. This legislation aligns with our state's commitment to fairness, justice, and compassion, and it represents a critical step toward building a more equitable society where everyone has the opportunity to thrive. I urge you to support House Bill 7957 and take action to ensure that all the tenants in Rhode Island have access to legal representation when facing eviction. Thank you for your time, and I'm open to answering any questions.
Any questions of this witness? I have one, John. So you were a public defender,
Yes,
is that right? And you know that they're dying for lawyers over there, too. I mean, they've been up here requesting money for more lawyers.
Correct.
how are we going, do you have any ideas? And I think it's a good idea. As a lawyer, I believe everyone needs a lawyer. But how do we fund this?
That's a good question. I know that there is a bill, I believe a companion bill in the Senate that would increase filing fees, which are routinely, I understand that this is a concern that landlords initially pay the filing fee to get the case into court. These fees are routinely put back onto tenants when cases are resolved in court. So I'm in court every single day representing these folks, and these filing fees are turned back onto the tenants. If a tenant wants to cure their rental deficit, their arrearage, they have to pay the rent that's back due, and they have to pay the filing fee. So an increase in filing fees, which I believe is sponsored by Senator Mack in the Senate, would be one way to produce some of this. But not to be lost is the amount that the state would save from not having folks rely on social services, the amount of money that we would save from investing in these homeless shelters, because we would create more stable housing for more individuals. So initially, there might be.
It's a great idea. It's just where's the money coming from? That's what I'm asking. That's all. I get that it's a good idea, but we have everybody's looking for more lawyers, more money in state government. So, but thank you.
Thank you.
Oh, Representative Cruz?
And thank you, John and Jen, for, your tireless work at the Housing Court, because I know it is tireless. I just wanted to ask John, too, because you just touched on the additional fees. Do you see a lot the attorney's fees being also put onto the tenant during eviction proceedings?
The way that the current laws are structured, landlords have a lot of leverage. So when we're in court representing individuals, most of these cases are resolved by stipulation. And so when a tenant is looking to stay in their home, they're looking to enter into a repayment agreement, and the landlord's attorney says, okay, well, we're going to add attorney's fees into this stipulation. The tenant really doesn't have a choice but to say, yes, I'm going to agree to pay this landlord's attorney's fee. $350, $375, because the alternative is, no, I'm not going to pay the attorney's fee. Okay, well, then we're not going to offer a payment plan. And if you don't offer a payment plan, the person is going to become homeless. So we talk about attorney's fees every single day when we're in the housing court, and a lot of these filing fees and attorney's fees that landlords incur on the front end are oftentimes put back on the tenants on the back end.
Well,
But not always, not always. Many times the landlords will agree to waive all of that, so long as they have a payment plan and the person wants to stay and there's an agreement between the two of them. So I think that's misrepresenting that this happens all the time. It doesn't. Many of these settlements, people walk away with a meeting of the minds, and it's not
And that's why I
terrible.
asked how when it happens and what it looks like.
Yeah.
I know for myself, going there with tenants, unfortunately, at least for my eyes, I see it more often than not, and these are low-income, working-class people. So to think that they're also covering the fees of these attorneys is, to me, I think it's unscrupulous. But I just wanted to thank, again, Center for Justice for working to balance the levers of justice for tenants in the courtroom.
Thank you. Any other questions?
I just had a comment, please.
Go ahead, Rep. Roberts.
I know, Representative, you said that you view this as unscrupulous, and I think in some cases that may very well be true. But I just wanted to mention that sometimes these people who are offering the rental properties themselves probably started out low income, they're struggling, they want to retire, they could be much older. In their mind, they may be thinking, hey, I shouldn't have to take them to court, but I'm being forced into a position. So I think at times maybe if that cost is passed down to the tenant, there's probably a reason. So I think we just need to keep that in mind as well. Thank you.
No, thank you for that. And I'll just respond. And as I shared earlier, I don't see these practices with mom and pops, which is defined by the National Realtors Association as someone who owns 1 to 4 units and has a separate single-family home. I see this from individuals or corporations that own 200, 300, 400 units and more that are putting that back. I don't see that from the mom and pops as defined by the National Realtors Association themselves. So that's why I wanted to say that. And no, I don't think they're all bad. I'm a renter. There's not many of us in this state house, and I don't have these issues. I do have a good landlord. And they do everything by law. And these bills wouldn't impact them because they wouldn't have unsafe housing. They would fix it. They would abide by the laws that are already in place. They would do those things. So these wouldn't harm them either. So I just want to make that clear, that even, as in just cause, there's an exemption as well. I'm sure, at the courthouses too, judges and lawyers, they look at that if it's an actual mom and pop, and they do work a lot, even like in code enforcement. They work a lot to help those smaller landlords. But unfortunately, we're seeing more and more that those aren't the case.
Okay. Jen, you're up.
Good evening. Thank you, members of the committee, Madam Chair. My name is Jennifer Wood. I'm the Executive Director at the Rhode Island Center for Justice, and along with my colleague John, I'm grateful for the opportunity to address a wide range of bills affecting the Landlord-Tenant Act and housing here this evening. Mindful of the time and the many people who are waiting to offer their insights, we've submitted written testimony on most of the bills which we support. None of the bills that we are speaking to or submitting testimony on this evening are in opposition. Each of the bills that we've addressed this evening through written testimony or oral testimony is in support of those bills. Touching on those topic areas, we support some framework to rein in unlimited rental increases, unlimited in both frequency and amount. So whether it's 4%, 10% CPI, there are a lot of good discussions, I think, to be had in the General Assembly about this topic area. There's a lot of research, as has been alluded to, in the area of rent control. You don't actually have rent control bills in front of you this evening. If you've met one rent control regulatory scheme, you've met one rent control regulatory scheme, and they're all we need to examine each of the studies and the histories in larger urban centers across the United States where there is some history of that experimentation. But what you've got in front of you as a General Assembly this year is some minimal constraint on the amount and frequency of rental increases, as opposed to what is typically referred to as a rent control framework, which would involve a whole framework, a regulatory framework, and a commission that oversees its implementation. So we support some rational constraint on the frequency and proportion of increases. We also support a framework in which there is a leveling of the playing field for landlords and tenants. And the two that I'm going to dwell on for a moment this evening are right to counsel and just cause eviction standard. Because, as you asked, Madam Vice Chair, most people kind of get the equity principle and the fairness that if 95% of landlords are represented by an attorney, you're probably going to have a more relevant and balanced conversation about the resolution of a legal matter if the tenant is also represented by an attorney. So how do we get there? And why do we even talk about this? Because there are lots of areas in civil law where an attorney is not guaranteed. Everyone knows a public defender is guaranteed because of the risk of the loss of one's liberty, and that's a constitutional right. There are very limited areas for civil right to counsel that are being implemented nationally, and one of them is in the arena of housing. And why is that? That is because housing is a commodity, and we heard a lot about that this evening, but housing is not just a commodity, because housing is actually health, it is a public health imperative, it is a major cost to society when it is unavailable to people, and it is a human right. And that's why we have a framework to have that balancing of having attorneys on both sides of the equation. Only in very limited civil matters. Housing is one where in 4 states across the nation, Connecticut, Maryland, Washington, there is an implementation now ongoing. Connecticut's been phasing it in for the last 3 to 5 years. So we have some really good neighbors to look at for how much it costs, how to make the eligibility standards, and how it's going to work well. New York City was the pioneer with a universal right to counsel implemented over a 5-year period. Funding is available from a variety of federal and state sources, so it's usually done through blended funding, and that's how expanded access to counsel is being done right now in Rhode Island. And you know that's in the governor's budget, and that's something that's been being worked on for several years. So we have a good glide path towards right to counsel, and we would need to get there over a multi-year phase-in.
Thank you. Thank you very much, Jen. Any questions of this witness? Representative Knight.
Thank you, Jen, for your testimony. I know that you're up to your eyes in this and have tremendous experience, so I actually have a question, just not really related to any of the bills. But I'm curious, do any other states or frankly countries have, any kind of real regulatory enforcement? I'm talking like boots on the ground, like rent cops, who have some version of a landlord-tenant law and are out there enforcing the provisions of it. Because a lot of what I see and hear in this committee tonight and last year and the year before comes not so much from the rules, but people breaking the rules. And I'm constantly left with this question of where's the enforcement? Like, who's going out and saying, number one, you can't do that, or you must do something, and then backing it up with dragging someone into, fines, dragging them in front of a judge, court orders, contempt, any of that stuff. Does anybody have that in the United States?
Well, thank you for limiting your inquiry to the United States, because I was thinking I'm going to need to Google that in the international context, although I suspect that there are a number of frameworks around the globe where there's a greater investment in public employees who oversee some of these frameworks. We know that there's a significant underinvestment in code enforcement officials and inspectors in Rhode Island and in the United States generally. So really, I would point to the code enforcement framework as the bedrock on which most of this stands, and that is a system that needs strengthening. And I think both landlords and tenants would acknowledge that that system requires some strengthening. It's a private attorney general model. Statutes are put in place, requirements are put in place, and people have to go to court to bring claims and counterclaims to work out those differences. And that's the way it works in virtually every jurisdiction in the United States, to the best of my knowledge.
So, for the record, it seems like we could, you talk about money, you talk about funding and bang for the buck. I mean, we have the Secretary of Housing, we have a deceptive business trade law. We can do a little fixing of jurisdiction and hire 50 people and make a department that goes fans out through 39 cities and towns and sets up the rules and enforces them. And maybe we could think about that.
Well, and I do want to affirm that there are mechanisms in place. For example, in the Attorney General's Office Civil Division, there are enforcement mechanisms around lead poisoning, wide-scale violations of the Landlord-Tenant Act. We've seen some evidence of enforcement in that arena, and also in the Fair Housing Act arena. There are federally funded entities that bring litigation on behalf of those who have been discriminated against by being excluded from renting property due to their race, national origin, or other impermissible factors.
And I'm aware of those measures. They're big swings going after big targets to try to this kind of impact litigation in a way coming from the AG's office. But I appreciate the opportunity, the back and forth to sort of fill that out, because it seems like there's an opportunity there. Thanks.
Thank you.
Okay, thank you both for your testimony. So now we have 90 people who want to testify. So let's try and stick to the 2 minutes, please, because we've already been here for 3 hours. So let's see, Javon Sabrino Wheeler. Okay. Harry Bilodeau. Is Harry here? Come on up, Harry. Steve Alquist, is he here? I don't see him. Okay. I'll keep calling until I get 3. Where's Harry? Are you coming up? Harry? Gail Golden? Peggy DeJardis? Harry. Okay, who wants to start? Harry, you want to get started? Please, is your light on red over there on the microphone?
Yes, it is. Thank you.
Okay.
I'll be quite quick. I appreciate the time that everybody is putting in. I specifically wanted to talk about House Bill 7960 and 7962. I think that I will really just move on to Mr. Morales' bill of 7962, which I think contains a component that is shockingly appalling, and that is his request for a quote-unquote a hearing, a proposed hearing or hearing process. I think there's a word for this. It's called a tribunal. And in a real world, Representative Morales said we would not need this kind of judicial component. But in fact, we do not need the component in a less than real world. I feel pretty strongly that in reality, in other words, what has he proposed? He's proposing to judge a hearing that contains complaints by tenant union members. The bill calls this review a hearing process, but it is not. It is a tribunal. One thinks of the famous tribunals of Paris during the Parisian Revolution, which they were actually a reign of terror was installed. I don't think we go that far, but it is a kangaroo court. Kangaroo court is an idiom referring to a court whose proceedings deviate so far from accepted legal norms that they can no longer be considered fair or just. I'll conclude by saying, in summary, both of these bills do not strengthen, encourage, or enhance individual responsibility. These bills undermine individual responsibility and undermine faith in the laws.
Thank you, Harry.
You're welcome.
Are you Gail? I am. Oh, go ahead, Gail. You're up.
Thank you, Madam Chair, and honorable members that are left here in the committee. I'm coming to you today to oppose a good number of these bills, and for the record, I have 7962, 7957, 7960, 7961, 7746, 7174, 7372, 7304, 7305, 7162, and 7049. I have submitted written testimony, so I won't obviously go into all that detail, but I think I want to address the chair's concerns that I leave you with something that's really important.
Sure.
And so that's what I intend to do. I'm here because I'm in both camps. I am both a tenant and a landlord. It gives me a very unique perspective with what I do. My partner and I, 2 years ago, started a furnished housing company to address the short-term employment needs here in the state. Some of those are critical needs in our hospitals. I know many of you know travel nurses. But there are other needs, including the state. We've had tenants from RIPTA. We've had tenants that are working for various departments for the state or the cities. We have obviously private tenants as well as universities. And so we have had a really great chance to look at what some of their needs are. And I don't think they're much different than what I think most tenants want. They want a clean, safe, affordable place. Mm-hmm. But my concern as the tenant and the landlord is whether or not I can even provide that to them if some of this were to move forward. Mm-hmm. What I don't see here, and I've been involved with public policy in one subject or another in various states, mostly in New England, but what I don't see here is that compromise position. You know, it seems like we're either far in one direction or far in the other. And it doesn't make any sense to me to alienate the housing providers when 40% of of our population here in Rhode Island is actually renting. And for the critical needs, employment needs we have that are often short-term, some of those do turn into permanent residents, which we're happy that they do. I would like to see that we have a lot more compromise position here.
That would be nice.
Wouldn't it be nice? I mean,
That'd be nice.
You know, I've been able to see that and have it done on other subjects, and it's doable because I don't think the two goals are different.
Well, maybe
Okay?
we'll get there, but thank
So
you for your
hopefully.
testimony.
You're
Gail, oh, go ahead, Rep. Caldwell.
This is just a general comment and not just directed at you, but since you all do only have 2 minutes, I will tell you that it is impossible for us to know when you list all those bill numbers exactly which ones you're talking about. So if you sent in written testimony with those, we have it and it's on the record, and you might want to save that time to use to like make some comments because we just don't have all the bill numbers memorized, as I'm sure
And
you
you
don't.
did check them
and you have them
You
checked
have-
off.
I did
yeah,
check them off,
So we
yes.
have all that information. And so
Alright.
since everyone has a short amount of time,
Right.
that would be my advice.
And I would also like to see more data from both sides about what, you know, when we say a lot, what is a lot? Is it 1%? Is it 0.5%?
Right.
We really don't know the size of the problem.
Exactly. Thank you very much.
You're welcome.
Steve?
Hi, I'm going to be fast if I can. As Speaker Shikarchi mentioned when he introduced the housing packages this year, I am a reporter who has covered the crisis of homelessness in this state for many years. The current Homeless Bill of Rights has, in my experience, never been all that useful in defending the rights of people experiencing homelessness against the depredations of the state. State and municipal leaders and members of police departments throughout the state routinely violate both the letter and the spirit of the statute. Judges rarely consider the Bill of Rights when rendering decisions from the bench. When the Bill of Rights is considered at all, is given little weight. I want to, on December 4th of last year, I got a message from an outreach worker telling me that 2 undercover Providence police officers went to an encampment and harassed unhoused people, mostly women, living in tents. I interviewed the women at the encampment. For their protection, I am withholding identifying information. As I'm walking back to my tent, I see these 2 guys, says Mary. They're not in uniform. They have no papers. At the moment they arrived, there was no criminal activity going on at all. We were all having a regular morning. We were just waking up. The 2 male officers were wearing regular clothes like a hoodie, jeans, and sneakers. One of them had his gun and badge showing, hanging from his belt. Another woman told me they had a badge, but I didn't know for sure that it's a real badge. They told me to come out of the tent and didn't say anything, and I didn't say anything at first. For the first 3 times that they said come out of the tent, I didn't say jack shit. And then they literally kicked my tent. Now my tent's already ripped, so they were kicking it where it's ripped, breaking it even more. And they said, I'm not going to ask again, come out. And I replied, do you have a warrant? And they said, and pardon what I have to say, we don't need a warrant, you live in a fucking tent. The 2 police officers conducted illegal searches, lined people up outside their tents, and verbally harassed them while, quote, looking for drugs. Can you imagine the outrage you would feel if your constituents were treated that way in their homes? When I called the offices of Mayor Smiley and the Providence Police Department, they lied and told me that no police officers were at the encampment that morning, going so far as to tell me I got the story wrong and should make a correction. I'm sorry, I'm going to go a little longer. I hope you don't mind. But they didn't realize that I had more information about the police officers than I put in my piece. I knew the make and model of the car they were driving, and the person I didn't put in the story, who I know very well, could definitively identify the men as cops from their interaction with them at another encampment. I wrote a second story asking the obvious question: if these men were not police officers, as the city claimed, why aren't the mayor and the Providence police concerned about 2 men in the city pretending to be police officers, brandishing badges and guns, and harassing Providence residents? Around 24 hours later, the city admitted that the 2 men were police officers, but added that the police officers had, quote, done nothing wrong. They refused to answer questions about the nature of the investigation and brought them to that conclusion because it was another lie. A 3rd time, the mayor lied to me because I asked pressed him for details. He promised to get back to me, and he wouldn't do it.
Okay,
I'll
Steve, you're going to have to wrap it up.
I will wrap it up. The 2 Providence police officers violated the Homeless Bill of Rights as it exists now. This needs teeth. They should be fired or fined.
I'll end with this. The story I said above is sadly common. Human rights violations, big and small, are a daily part of being unhoused in Rhode Island. The homeless bill, and I'll end here. If our rights as human beings mean anything to the members of this committee, you will pass this bill.
Thank you very much.
Thank you.
Any questions of Representative
Yes.
Agello?
The two people speaking from the viewpoint of landlords and landlord and tenant, both of you mentioned 7305 and your concern with that. Would you briefly, 7305 deals with assistance and service animals and discrimination.
Yes, service animals is something I actually have a lot of familiarity with on the federal and state level with public policy. My concern is that there's really no good enforcement or definition around service animals. We know what they are for service, but emotional support gets looped in, and when it does, without any real regulation, and even honestly, service animals aren't regulated, aren't licensed, there's no registry of them. It's kind of so loose that there's no real enforcement. To be fair with you, Representative, in every unit I've ever had, we have permitted animals. All right, and sometimes probably more than my partner would like me to. But I feel that to legislate this without the federal government having made the definitions that need to be made is going to be a very tough road to hoe. And it differs from state to state and place to place and even city to city and county to county. So trying to come up with a uniform way of looking at the animals and their place in our lives, I think we really have to start with the service animals, make sure we either have a registry for them or there's some way that they are identified and regulated, and then we can move down to the other support animals. Does that answer your question?
It seems to me for someone who needs a guide dog because they're blind, it shouldn't be necessary to have some sort of identification or proof. But that I read amendments that I would like to see to the service animal and assistance animal included in the bill. So, thank you.
You're welcome.
And thank you for saying that you do allow pets in, whether they're service or assistance or not. Thank you.
Thank you very much, all three of you. Next, did Jivan Sabrinho Wheeler, is he? She, he? No? Okay. How about Peggy DeJaris? Is Peggy here? How about Charles Smith? Is Charles Smith here? No? Well, they'll come in when they come. Katie West? Is Katie West here? Come on up, Katie. Sean Andrews, are you here? No? How about Robert D'Amico? Come on up, Robert. So, Katie, why don't you start?
Good evening. Thank you, Chair and members of the committee, for your patience tonight. I'm Katie West. I'm the Director of Strategic Initiatives at the Housing Network of Rhode Island. We are the backbone for Homes RI. I submitted written testimony on multiple bills. I'm just going to focus my remarks on 3 tonight, and just want to acknowledge and thank the sponsors of these pieces of legislation. On legislation 7304, I can tell you that even though we're not a service provider, we get calls every week from tenants who are butting up against their 30-day window, and they are absolutely terrified that they will be on the street. So this bill is a modest effort, high-impact policy to increase the time of notice. So we support it. I know the House passed it last year and hope that they take similar action this year. Thank you for that. 7647, this is a reasonable piece of legislation to ask landlords to disclose non-optional fees to tenants. It's a reasonable business practice. We think it will help avoid disputes later down the road, that there's clarity, and we would support Representative Kislak's amendments to make the bill language more clear. And then finally on 7957, which is right to counsel, We've seen the effectiveness of this in legal representation through the partnership with the legal service providers, community-based organizations, the Department of Housing, and the Judiciary. There's 25 states and localities that have a state-level right to counsel law. Maryland, and at the state level, I'm sorry, there's Maryland, Minnesota, Delaware, and Connecticut close by, so they've done it. And we need to have both tenant protections and build more housing, and these policies will do that. So thank you for your time this evening. We support these bills.
Thank you, Katie. Go ahead, Robert.
Thank you, and thank you for your time tonight. I first wanted to just comment on House Bill 7962. I would expound a little bit on Mr. Bilodeau's comments. I do believe that legislation as currently proposed is a tribunal as he described, but I think that tribunal has great potential for abuse and for tenants to use that procedure as a sword against landlords. There's an immediate presumption that any legitimate action that a landlord might take after a hearing process has been initiated is presumed to be retaliatory. The burden then shifts to the landlord to prove that he is not retaliating against the tenants. But the more glaring thing that jumps out to me in Bill 7962 is that this tribunal, this legislation, is appointing non-attorney representatives to prosecute the cases of the tenants union. This will, in my opinion, is clearly authorizing or allowing the unauthorized practice of law of these representatives to file complaints, make legal arguments, review evidence, submit evidence, and do everything else that a lawyer might be responsible for doing in representing someone's rights. I think that this legislation would unwittingly subject those tenant representatives into complaints being filed against them for the unauthorized practice of law. The Rhode Island Supreme Court addressed this issue in, I think it was in Ray, town of Tiverton, and this was regarding business agents in the labor unions to represent their members at grievance hearings. The Supreme Court, only 3 of the justices sat on that case. They thought it was an extremely close call, and they reserved further decision until the full court could rule on it. I don't think that this legislation falls under that purview, and I clearly think that it would result in complaints against tenant representatives for the unauthorized practice of law. There are plenty of laws already in place. There are plenty of procedures in place for tenants to take action against abusive landlords, dilatory landlords, landlords who keep their properties in uninhabitable conditions. Those laws, with the combination of providing representation to these tenants, there's plenty of access for them to be able to pursue their rights. One comment I want that Ms. Representative Cruz made about the disparity in people who are represented by attorneys in evictions and those who are not. Most landlords own properties in LLCs or entities. They're required by law to have an attorney. They cannot go to court without an attorney. So to use that as a wedge or a complaint against landlords that they're represented, they have no choice but to be represented.
Thank you, Robert. Any questions of these witnesses? Thank you very much. Let's see, Melina Lodge and Rosanna Ortiz. Didn't I just call you?
Yes, if I could speak on behalf of Melina, she had to leave.
Okay. Is it different from what you just said?
It
Katie?
is. Yeah, they're different bills.
All right, and how about Rosanna Ortiz? Come on up, Rosanna. And Greg Weiss, is he here? Greg? Come on up, Greg. All right, go ahead. Katie?
Okay, yes, so we've already established I'm not Melina Lodge, but I am here representing the Housing Network of Rhode Island. We're organization of nonprofit community developers, and we just want to offer our strong support of Bills 7949, 7950, and 7951, which are part of Speaker Shekarchi's housing package, and we appreciate his leadership and that of the co-sponsors on these bills. Just very quickly, what these bills do is amend various provisions within the law to provide greater clarity and specificity as to how municipalities are required to treat certain scenarios and streamline review procedures by delegating authority to an administrative officer. This is important to getting to our production, our housing production goals, and building more homes, and communities will help them become more adept at reducing barriers to this type of development, streamlining, clarifying processes that can often delay production and drive cost increases. So these bills fulfill those functions, and we reiterate our support. Thank you.
Thank you very much. And Melina?
I'm Roseanne.
Oh, Rosanna. Oh, God, now you got me all confused.
That's
Rosanna,
okay.
I'm sorry. Go ahead.
This is on, right?
Okay, Melina's done. She's not here, and she's Katie.
Good evening. Thank you so much. I am thankful for this privilege of your time. My name is Rosanna Ortiz, and I am a renter and I am a homeowner. I have lived in Rhode Island since 2009. I'm originally from Southern California, and this testimony, I followed Representative Craven's advice of coming from the heart. I am the owner and founder of internationally recognized Style Week Northeast, RMO Public Relations, and RMO Project Resources. My successes with my business have ignited my ambition to delve into the real estate development world. Alongside my new partners, born and raised in Rhode Island, we have acquired a 9-acre parcel of land in Providence to offer housing opportunities that are greatly in need. Yet, these bills directly imperil the quintessential American dream of property ownership, whether it's a condo, trailer, or a modest home. I implore each panel member to ponder on how these bills neglect the people's interests. Unfortunately, they do not assist tenants or property owners, but serve an undisclosed agenda and a safety threat. Throughout my business and my life journey, I've come to understand that true success arises from aspiration and the determination to overcome challenges. However, these bills threaten to suppress aspirations and cultivate a mentality of victimhood by incentivizing system exploitation. I refuse to be labeled a victim, whether it's due to my ethnicity, gender, or political affiliation. I challenge everyone present to embody the perseverance of my father, Martin. Descended from Mexican and Native American heritage, he confronted poverty head-on. Born into hardship in Tucson, Arizona, he transcended his circumstances to contribute to the Surveyor moon landing mission at the Jet Propulsion Laboratory in Pasadena. His journey, marked by sacrifices such as putting himself through the military, the U.S. Army, and studying at Cal State Northridge while delivering the LA Times at 3 a.m. every single morning, epitomizes the American spirit of resilience, but most importantly, accountability.
Why don't you wrap it up, Rosanna?
Sorry?
You got to try and wrap it up.
Oh, okay.
Okay. The time is up. When you hear the buzzer, that means your 2 minutes have passed.
Okay. To maintain affordable rents, we must focus on increasing housing stock. Recent legislative efforts championed by the Speaker and your colleagues have been aimed at precisely this goal. However, the passage of these bills would drive developers away, further exacerbating the affordability crisis in both apartments and housing. It is a straightforward equation. More housing construction leads to stabilized prices.
Thank you very much.
I have one more sentence.
All right, one more sentence.
We must prioritize incentivizing housing construction to ensure stability in housing costs. Thank you for your
very
time.
much, Rosanna. Greg?
I wanted to offer some thoughts you should consider about this security deposit bill. It was 7746. Under this proposal, landlords would be required to open and manage interest-bearing accounts for each and every tenant, ensuring compliance with federal regulations regarding deposit insurance and prevailing interest rates. The increased administrative burden would result in several cost implications for landlords, which would likely be passed on to the tenants through higher rents. Landlords would incur additional expenses related to opening and maintaining multiple interest-bearing accounts, tracking, calculating interest accrued for each tenant. And these would be particularly burdensome for small-scale landlords. So I looked up the prevailing rate on the DBR website. It's 0.05%. So if you had a $1,000 security deposit and a year went by, that's 50 cents. So it's hard for me to believe that a landlord's cost to administer all that wouldn't be greater than 50 cents. So the benefit to tenants from receiving interest on their security deposits would be outweighed by the negative impact on housing affordability caused by increased administrative burden and costs imposed on landlords. The next bill I wanted to speak to was Just Cause Eviction 7960. This bill eliminates a property owner's right to serve a non-renewal notice at the end of the lease term, essentially granting residents an indefinite lease, but it also implements rent control in this bill. I don't know if everyone knows that, but it says there's a 4% max annual increase in this bill. It's not just about just cause eviction. And as we heard, economists almost universally agree that rent control does not work. Under this bill, landlords can no longer decide not to renew a lease. Instead, it requires owners to show cause and obtain a court order to terminate a lease, which can be challenging, particularly in cases involving criminal activities. Meeting the legal standard required to prove a resident is disruptive requires detailed record keeping on the part of the owner and corroborating testimony. Just cause eviction policies make it harder for landlords to remove troubled tenants and protect good ones. Thank you.
Thank you very much. Any questions of these witnesses? Seeing none, we'll go to the next. Lynette Fury Menard, where is she? Jonathan Daly LaBelle, is he here? Diana Gray? No? Diana, come on up. Steve Brown, I did see him earlier. Is he still around? Oh, I guess he's not testifying. Okay. We wore him out. Lauren Hill? Is Lauren Hill here? No? Oh, okay, come on up. Okay, Lynette.
Thank you, Madam Chair. I appreciate the opportunity to speak before you, and I will be quick. You've got a number of letters from the Rhode Island Mortgage Bankers Association. I'm just going to quickly touch on two. 7964, which was put in by the good rep. We have a couple concerns with the bill, but I did quickly try to say to him, I think we can work them out. But what this bill does is it eliminates the use of certified mail, return receipt requested, when a borrower is sent a notice under the power of sale. And in its place, it says by way of the U.S. Postal Service and/or overnight delivery. That causes two problems for us. One is that the U.S. Postal Service first-class mail doesn't provide proof of delivery. For foreclosure activities, they're often litigated and sometimes reviewed for strict compliance with the statute, so any deviation from the statute can cause disputes. So, and secondly, there's no definition for an overnight delivery service. Most of us probably think that's FedEx and UPS or other brand names, but arguably it could be some of the task apps that are out there, which I didn't even know about before tonight. So those are the two things we would ask to work on. And then secondly, 7965, this bill proposes to provide owner occupants a first opportunity to purchase foreclosed properties. This causes a problem for us for a couple reasons. One's a general that you've already heard, but secondly, it creates a 30-day period for the first opportunity bidders. That coincides with a 30-day time frame that's provided under HUD guidelines for post-foreclosure sales. So we do think there could be a conflict there. The letter goes through more detail, but Madam Chair, I'll leave it at that if anyone has any questions.
Okay, thank you,
Made it
Lynette.
in my 2 minutes.
Diana, you're on.
Okay.
Yeah, speak into the microphone, my friend.
Okay. I'm here because well, I don't know the numbers. I really don't. I can't remember the numbers either, but it's about
Well, you checked,
housing.
you're for every single bill on here. You've checked every single one.
Oh, I know. I know.
She's in favor of all the bills tonight.
All right, well, thank you. I'm here for all of them then. But I can't talk about all of them.
That's
because you ain't
okay.
got that much time. I'll be here all night.
Yes, you will.
Yeah. I
So let's
know.
get to it. Let's get
All
to the
right.
one you want to talk
Well,
about.
for one, about the rents are too high. And maybe they should put a freeze on some of the rents, you know, put a freeze where they're at now, for like, because they already went up to 2,000 or whatever. Put a freeze on that. Give people more income, all right? That might help if you give, because a lot of people are getting kicked out in the street and they have nowhere to go. So if you raise people's checks where they work at, raise people's Social Security, welfare, and stuff like that, and for a few years, and freeze that rent that you're charging, the landlords are charging, and give them more money so that they can pay their rents and stay in their apartments. There's people all over the world getting kicked out, and especially in Providence. They have no place to stay. So they go to a family member, and a family member tries to take them in because they feel sorry for them. But because everybody's becoming homeless, they feel sorry for them, but the people won't let them stay there. So they're evicting the people that live there. So, and there's, well, I'm not going to skip that part and drop that for now. And I'm going to try to get on to the next one. The next one is when a tenant, when they go up on your, when they have security, when they have the your security deposit.
Deposit, yeah.
Yeah. When that security does gets interest on it, they shouldn't take the whole security deposit from them. It might not be no damage at all. It might not be that much damage. They should just take out for what that damage was and give them back all the rest of that money.
Well,
Okay?
that's what they're supposed to do, so.
All the rest of their security deposit. But just take out whatever they did.
What they need to cover the damage.
Yeah, the damage.
Yes, I hear you.
Another thing to make it sure, if a person dies, or if somebody has
Yeah.
an animal, and it's a family animal, and that animal has nowhere to go, I don't care if it's a service dog or not, you should let them have that animal with them.
Yes.
Okay?
All right. So your time's up, John.
All right, well, I'm
but
going to go, but
Thank you so much,
very
Diana.
Yeah, thank you.
And very good. So, Lauren?
Hi, I'm pinch hitting for Lauren Hill.
You're pinch hitting for
I'm
Lauren
pinch hitting.
Hill.
I'm Cynthia Hyatt. I'm a commissioner at the Human Rights Commission. I'm talking on House Bill 7305, which is the Fair Housing Bill. This is actually a cleanup bill. You'll probably hear many comments about how people don't like the definitions of assistance animal in this bill, but this tracks the Department of Housing and Urban Development enforcement of federal fair housing law. So the way our law is currently worded, it actually misleads landlords into thinking they have an out which they don't have, because federal law provides as a reasonable accommodation, you must allow people to have assistance animals that will assist them with their disability. So this law makes it so that people understand what the law is. It also, previously, the General Assembly passed a law relating to housing status. They put housing status in one section of the bill, but they did not put it in other sections of the bill. And this puts it in all the sections of the bill so that it's clear that the Commission covers it. There is also a provision that removes an unconstitutional provision which prohibits the parties from discussing their case. There was a similar provision in the Fair Employment Practices Act. We were sued by the ACLU and we had to remove it. I'm not sure why they haven't sued us yet over this one, but I think it would be nice to avoid the attorney's bills if they do sue us. So that's essentially it.
Well, thank you
If you have
very
any
much.
questions?
Any questions of these witnesses? Seeing none, thank you both for your testimony. Next is Richard Addison. Richard, come on up. Is Chris Bellotti here? Chris? No? All right, I'm putting these aside if they ever come in. So I'm just putting them aside. How about Rose Siegel? Rose, come on up. And Margot Morisseau, are you here? Come on up. All right, Richard, you're
All right.
up.
Good evening. Thank you very much. My name is Richard Addison. I hate to say it, but housing for people of color in the state of Rhode Island has always been a problem. I was born in 1940, so do the math. I remember when...
You look great. You look good.
No, I don't. I used to look a lot better, but I'm going to tell you. Unfortunately, I'm a disabled vet. I live in a housing that's owned by the Pawtucket Housing Authority, City of Pawtucket. We have had, not a union, but we've had an association for many years. I went there in 2003. When I got there, I was one of 3 people of color that moved into that building. Well, Vera died and the other one moved out finally. So it's been a problem. Right now, we have new management who came in, and for some reason or another, she decided that she was going to just take over and run the association and everything else her way. I asked her about the money that we used to get from HUD every year. She said, "You're not going to get it no more." She said, "The last executive director made a mistake. You weren't supposed to get it." So then I ran for the president, and it was the first time that somebody of color was the president of the association. We also had a woman of color ran for treasurer. She was the first woman of color to get that job. Well, unfortunately, the executive director decided she was going to change the bylaws so that she could manipulate the things that we did in the association. I called the Attorney General. The Attorney General wrote her a letter and told her that there is a separation between the association and the Pawtucket Housing Authority. So she got upset, and she decided that she was going to create another way around it. She was there, and she appointed, in 2019, I believe, a president and a treasurer, and she actually had her finance director, their names on the bank books that belong to the association. So after this new election, when I got elected president and Dominguez got the treasurer's job, we went to the bank. We made a deposit of all the new members that we brought in with us. And when we put the money in, we said we're going to put our names on the bank books. Well, a week went by, and I got a phone call and from the bank, and it says that we could no longer have my name and the other girl's name on the bank books because the other president and the other treasurer refused to take their names off. We couldn't get a peaceful transfer of power like we've always done since I was there. This year, the manager decided that she was going to leave it like that. So the committee went to management like a union, and we demanded that she do something about it. And she said to me, "You call the Attorney General. The Attorney General says that she has no authority over it no more. She couldn't do anything about it." So I said, "But listen, you're the manager. You have the right to tell these people, the 2 people, they have to take their names off because they are holding the rest of the building hostage."
So, long story short, what happened?
Well, I got charged, and all of a sudden, I got threatened with eviction.
Oh, jeez.
Let me tell you, here's the evictions. What eviction? It makes me laugh.
So
I got
you-
in the elevator in the lobby. I was going up to the 12th floor where I live. The treasurer got on the 5th floor. She wanted to get down to the 3rd floor.
Are you
Other-
still in the building?
Huh?
Are you still in your
Yes.
apartment?
Yes.
So did you resolve this?
No. what happened is, they charged me, the girl told the management that I was holding her hostage because I was going from the lobby to 12, and when she got on the 5th floor, she wanted to go to the 3rd. And I told her, I said, you know what goes up has to come down. You gotta go all the way up to the top before you can get out. She filed a complaint, they wrote me up. They said I was holding her hostage in the elevator. The next one was,
We're going to have to try and wrap this up a little bit because
yes, I
it's
know,
getting
but
long.
see, this is serious.
Yes.
The other one is Sherry Cruz's thing about everybody who goes to eviction should have some type of legal
Well,
representation.
it sounds like you need a lawyer with
Well,
all
let
that's
me-
going on with
yeah.
you.
Well, let me tell you, in that building, we have people who are on disability. We have people who are on SSI. Some of these people, their monthly paychecks, they get once a month, $700, $900. Now, these people who live in private, they could get a lawyer. We can't get a lawyer.
Yeah.
We can't get a lawyer. So what happened? One of the tenants got behind on rent. She got behind on rent. She went to court by herself. The people come in and said she owed $1,500 or $200, whatever it was. She told the judge, she said, Your Honor, I need time. I need time. Can you give me, the judge said, I'll give you 30 days. You gotta come up with the money in 30 days or you're gone. So what happened, she come to me crying, and I went to Sherry crying. And we went out, we went to the Blackstone Valley Community Action, we went to the Urban League, we went to all these organizations to see if we could raise the money for her.
Yeah.
One of the girls called Sherry and said to Sherry, you know what happened? I called to find out how much money she needed. And you know what the person said in management? Don't send any money. Don't send any money. We want her out of here.
I see.
We did raise the money, and we waited the 30 days, and then she paid it off, and now she's still there.
Okay, sir, but you are going to have to, the time is up several minutes ago. Are you almost done?
Yes, I'm almost done. The other one
And you're
was-
lucky you have Sherry on your side over here.
Oh, I know that.
Because she's a hard worker, and she'll
Well,
help
the
you.
thing is, the last one is, I come in my house, drove into my parking lot. I went to my parking spot. There was a car parked in my parking spot. I called security, because we don't have security in any of the buildings no more. I called security. They said, don't worry, he'll move it soon. I said, I'm going to park my car behind him because I want to find out who's in my parking spot. He said, you can't do that. If you do that, we're going to tow your car. So I took my car, went up the top of the hill, and I parked the car at the top of the hill. I went upstairs, went to bed. I woke up, I looked out the window, the car was still there. Brad Carney knocked on my door and said to me, he's the maintenance man, he said, Mr. Addison, they're downstairs, they're putting stickers on your car. I went downstairs, there were 2 stickers on my car because I was parked in somebody else's parking spot.
Oh.
So whose parking spot do you think it was? The executive director. These are the charges that they are using to try to evict me.
Okay, I think that we could talk on the side about some of this with Sherry, if you want to do that, but we have so many more people that need to testify. I think we get the idea on what's going on in your building. And were you here last year, I believe, right? Did you come here last year?
Yes, that's after Sherry got her first bill passed before the
Yes,
committee
yes.
and before the House, the first freshman to do that.
Well, you're doing a good job, but
Thank
thank
you,
you
Richard.
so
No,
much.
she's doing a good
And she
job.
is. You both are. Together, you're a good team.
Let me tell you, if all the representatives cared for their residents like Sherry does, we would be in good shape.
Well, that's the best compliment you could get, Sherry. Thank you very much, sir.
Okay.
Thank you, Richard.
And who's next? Rose? You're up, Rose. We're going to try and stick to the time limit. Thank you for your time today. I don't think 2 minutes is enough to defend my life's work. But I do want to say I don't check anyone's immigration status. I do have tenants who are immigrants. I give all of my tenants a minimum of 120-day notice, and I have current and valid lead certificates on every unit. That being said, I oppose Bill 7049, 7162, 7174, 7305, 7372, 7647, 7746, 7957, 7960, 7961, and 7962. At 45 years old, I found myself homeless and couch surfing. I know how hard it is to find housing. I looked at my life and I knew I needed to change my priorities so that I could support myself as I aged. I learned new skills, changed jobs, and moved someplace I could afford. It wasn't easy, but it was necessary. After an enormous amount of sacrifice, blood, sweat, tears, I am a housing provider in Providence for the past 22 years now. At 67 years old, I still personally work 7 days a week to renovate some of the most derelict, uninhabitable, and vandalized properties in the city of Providence, turning them into beautiful, safe places for people to live. I've had long-term tenants, many for over a dozen years. I try to be very fair and not raise rents unless expenses force me to. These proposed bills are disastrous. They will literally force me to lose everything I've sacrificed and worked so hard for. I'm going to give you some concrete examples. On one house, my property taxes went up 311% in 3 years, from $9,017 to $28,090. My insurance increased 50% in those same 2 years. That increase totaled $556 per apartment per month for my tenants living on that property. That did not cover increased water, sewer, any repairs, maintenance, nothing. That was just the increase in property taxes and insurance. If I can't cover those, my house goes into foreclosure and I lose it. $556 per apartment per month. The other fellow addressed the absolutely outrageous administrative time and effort for 0.01% security deposits. I don't need to talk about that. Another clause states that only one unit can be vacated for an owner-occupant to move in if I were to sell a place. I have built my places condo-ready with the knowledge I will convert my properties to condominiums to be able to sell them, to be able to retire. Of course, I would offer them to my tenants first. But my Social Security is $768 a month, and my IRA balance is $10,083. Every penny has gone into making my community better and safer, creating beautiful places for people to live. It would be cruel and unconstitutional to restrict my ability to sell my private properties in a manner where I could recoup my investment and be able to retire. I am exhausted. It's really unfair. And the other thing that's terrible about this, especially just cause eviction, I have had tenants from hell. 2 of them were attorneys and one was a CNA. They were a couple and a friend. Took advantage of every rule on the books. I finally filed for eviction in March of 2020. And the COVID eviction moratorium began. They stayed there for another year and a half. The back rent totaled $79,000. They destroyed the place. Every window was broken. The
doors were off the oven. The tenants above and below and next door complained. One of them was such a dangerous person. She busted down the door to the third floor apartment. She slashed the tires of the neighbor across the street, and they were too terrified. I could not get one person to complain, to fill out a police report, to anything. My only option was to not renew and ask them to leave. I wasn't able to evict for non-payment. They scared the shit out of everybody in the neighborhood. The damages and the back rent totaled over $109,000. If you think I'm ever going to see a penny of that, I barely survived. These bills, I'm going to beg you, I am 67 years old. I am exhausted. If these bills pass, I am literally selling everything. I'm moving out of state. I cannot deal with this. It is so blatantly unfair for landlords who actually have pride in their properties, take care of them, and deliver beautiful, safe, clean places for tenants. I've got to be able to cover my costs.
Yes, thank you, Rose.
Rose, thank
You
you.
did a great job. Thank you. And Margot, you're next.
How's that make you feel?
Good evening. I'm here representing the Rhode Island Coalition to End Homelessness tonight. We are in support of the speaker's package, but I am here testifying on two of our primary bills as well. So I am here to talk about the Fair Notice Bill, Fair Notice to Raise Rent, and also the Homeless Bill of Rights. I'll start off with Bill 7304, the Fair Notice Bill. So we run, at the Rhode Island Coalition to End Homelessness, we run the HMIS and the CES coordinated entry system, which tracks who's entering the homelessness system. We have data from that system that says that 39% of the people entering the homeless system came from permanent housing. This is due to rapidly rising rents, lack of affordable housing, and low-wage jobs. Today's Providence Journal featured an article that was titled, "Rhode Island only has enough apartments for half of its lowest income residents," and it was from the National Low Income Housing Coalition. It was stated that 49,468 low-income households, half of them are living with rents that they can't afford. The rents are raising at the highest rates in the country, according to Zillow. We're at 7.5% increase, and the national average is only 3.2%. Even people with modest rents find it difficult to adjust to rising rents with only 30 days' notice. This bill would do what is fair. Would give tenants time to adjust their budgets, find additional income, and have time to find other housing. So we hope that you'll support that bill. And trying to keep it quick, I'm moving on to the Homeless Bill of Rights. First, I want to just kind of clarify something that was asked earlier to Representative Stewart. We really appreciate her introducing these two bills. The Homeless Bill of Rights only affects encampments that are on public property. So people who have private property should not be concerned about this bill. This bill is necessary because the law that many of you helped pass is not being followed. This legislation is a crucial step forward to upholding the fundamental rights and dignity of people. We were the first in the state, as you know, to pass this under the leadership of Advocate John Joyce and Senator Tassoni, and we've been a model in the country. But sadly, dozens of incidents every year happen in Rhode Island where this law is not being adhered to. So these enhancements are needed to be enforced in the original legislation and protect people whose rights have been violated. So I hope that you will support both of these bills.
Thank you. Thank you. All right. People that were in the bell room, come on forward.
Is Paul Harrison here? Paul? No? How about Shane Cooper? No?
I could speak
Did he leave? He's here?
Is he out there? Oh, I'm sorry.
All right, he's out there. So Steve Stazzi, that's you? Then come on up.
And before this panel, sure, have him on deck.
Okay.
Before we start this panel, we got to stick to 2 minutes. I'll just interrupt you, okay? Because we'll never get out of here.
I got you.
All right, thank you. Who's first?
Go ahead.
They need to say what they do you know?
Yep.
Hi, my name is Mike LaGreco. I'm a small-time landlord, mom and pop landlord. I'm usually here with my kids. You've probably heard me talk before, some of you. When we started out, we had nothing, and we got to live the American dream. I was sleeping on a torn mattress on the floor. We had to have meetings to figure out whether or not we could afford a $20 toaster oven between my wife and I. After scrimping for years, we were able to buy a very dilapidated 3-family house and renovate it ourselves. Some of the bills that are proposed here would have worked against the business plan that allowed us to have housing and grow. Rent control would not have worked for us. The property was below market rent and had people in there who we were frankly afraid of, even though we were moving in as a young couple. I don't know how hard it would have been to get them to move out, but we raised our children in there, and I really did need the ability to learn everything about the people who we were renting to in the future, because we had babies in that apartment. I've since 15 years later been able to buy another building, and I'm creating low-income housing right now, and I want to protect the people who I'm renting to in Section 8. And it took us a long time to be able to build something and put it into practice. Every generation of my family has brought someone in from somewhere else. We're all immigrants. At our dinner table, there's always an immigrant somewhere there for every generation. And those immigrants work in construction, they work in housing. There's a whole other sub-economy here that supports people who, say, struggle with English as a second language. And the money that goes back into this sub-economy is the money that supports those people. I think that it's really easy to lose sight of that, but most housing providers that I know, they don't like to hold on to their money much at all. They like to put it right back into the system. And these are skilled laborers. There's a whole economy there.
Time's up.
Hi, Chris Bellotti. I am a housing provider. I oppose bills 7049, 7960, and 7174. 7049 is they call it rent stabilization, but it's a euphemism for rent control. It's been tried many times, always benefits those most able to pay the rent, and creates housing shortages among those least able to pay the rent. It also disincentivizes, it's a disincentive to landlords to maintain properties that are otherwise tired and in need of repair, which leads to blight in neighborhoods. It does not factor in times when property taxes and utility costs rise by exorbitant amounts, as we saw in Providence when commercial real estate taxes went up by over 35% to landlords owning 6 units or more just a few years ago, and the recently enacted 50% plus increase in electricity utility rates. It also doesn't address the issue with landlords who have variable debt, which is most landlords with commercial loans for buildings with 5 units or more that will have to refinance at today's higher rates over the next few years. Just cause evictions. I oppose this bill. I've had cause to remove many tenants in my 20 years as a landlord. I've never filed a just cause eviction. We filed no fault evictions because in order to remove for cause, you have to prove cause, which is extremely difficult when tenants, neighbors have issues with their tenant and fear retribution. They're unable or unwilling to show up to testify in court. Good tenants would rather move somewhere else than take time out of work to testify against a tenant who's a problem. Excuse me. The 7174 Fair Housing Practices Act may as well be called the Unsafe Housing for Defenseless Single Mothers Act. Roll the 4 of those together, or 3 of those, I guess I skipped one to keep it short, and you have a criminal living in a house with single mothers and elderly women I can't evict a criminal because the elderly and single mothers are afraid of retribution, and the elderly woman and single mother can't move because the unit is rent controlled, and if they move somewhere else, the rent will be too high. This should be a lesson in what not to do, and yet it is exactly what we're talking about doing. I'll be sure to take names so that my tenants know who to complain to when the law is enacted.
Thank you, Mr. Chairman and members of the committee, for the opportunity to speak today in opposition of, unfortunately, she's not here, Bill 7305, primarily the portion of the bill prohibiting the charging a resident a monthly fee for an assistance animal. I've worked in the past 5+ years in the property management business, and I've seen the damages that animals cause. The bill does allow for security deposits to cover for damages from animals, but I have seen catastrophic results of animal behavior, resulting in anything all the way up to having to remove entire floors, subfloors, hardwoods, so on and so forth. Pet fees mitigate those costs. There is a federally protected class between ESAs, emotional support animals. That is an FHA guideline, okay? But the difference is the qualifications of this. I would encourage you to visit supportpets.com. This is a website that's dedicated to issuing documentation for pets to be considered in the protected class of emotional support animals. From the website, any pet can qualify to become an emotional support animal, specifically if the pet provides comfort and emotional support to a person with disabilities. If your pet currently supports you in the management of emotional, psychological, or mental disabilities, they can become your emotional support animal. Here's the rub. There is no specific training or certification required for an emotional support animal, okay? But you know what it does require? $99. Go to supportpets.com. Check this out. It's not a joke. Try to fail this test. You can't. If you've got $99, you have an emotional support animal. This proposed legislation, as well-intended as it is, merely provides a loophole for pet owners to sidestep costs associated with pet fees by registering any animal under the Assistant Animal Act. I would be more than happy to sit down with anyone to talk this out, because I think that there's a compromise that could exist between a service animal and an emotional support animal. But I just want to say that I do want to go on record. I'm opposed to 7305, and I've got extensive experience to back it up. Happy to offer that up.
Thank you.
I didn't even get the buzzer.
There were some folks in the back there that got their name called. If you're here, come forward.
Mr. Chairman? Mr. Chairman?
Yes.
May I real quick?
Yeah.
Can I just say something? Hey, really quick. Anybody down the bell room, anybody in this room, do everybody on this committee a favor. Don't talk about taking names and making lists, all right? Don't talk about you're going to threaten people, all right? Every time I hear this, no matter what side you're on, it does no one any good, all right? If you come up here and you're a landlord and you say you're going to take names about people who vote for or against the bill, I'm probably, as far as the landlord's concerned, I'm probably your most friendly member on this committee. You get me mad when you do that, when you threaten my colleagues like that. I take that as a threat. So I would ask going forward that we not do that on either side of this issue. And that's it, Mr. Chairman. Thank you.
That was not intended for representatives.
No.
All right.
Anyone else that heard their name called that didn't come forward? Okay, then.
Brian.
Go ahead.
Brian Bishop, you want to come up? And Paula Hudson, are you here, Paula? Come on up.
You're up. Hi. Your name?
My name is Shane Cooper, and I'm a property owner in the great state of Rhode Island, and I want to try to continue to be one.
You're going to have to talk into the microphone.
Oh,
Just
sorry.
pull that over.
All right, sorry, let's try this again. My name is Shane Cooper, and I'm a property owner in the great state of Rhode Island. I want to try to continue to be one. Tonight, I know many of the property owners in the room are focusing on just cause and rent control bills. While I believe these are important, instead I want to focus on the pitfalls of H7647 and H7957. 7647 on the surface sounds like a highly innocuous bill. However, it's confusing and burdensome. I have read this bill over and over and still cannot determine if a property owner can charge a tenant to recoup the cost the property owner is charged for accepting alternative payment methods such as credit cards, Venmo, Cash Apps, Zelle, and so on. for the convenience of allowing a tenant to make on-time payments. Additionally, this bill potentially and severely unjustly punishes a property owner for simply failing to notify a tenant to something as simple as who their utility provider is, essentially rewarding the tenant by 3 times their monthly rent for searching for and discovering what could be just simple, innocent errors and omissions that were laid out by a landlord. And that's in the bill. If you don't notify the tenant as to who their utility is, they can charge 3x the rent. They come to the courts and ask for that. As for 7957, this bill would cause the state to bear the cost of providing free counsel to any tenant being evicted, good or bad. This would be a financial burden on the state and ultimately the property owner, who is already financially burdened by the loss of rent. As previously mentioned, many eviction hearings end in a mutually non-beneficial stipulation. Providing automatic counsel would prolong and add cost to what would normally be a mutually non-beneficial agreement. Non-beneficial meaning like a good deal is considered a deal that nobody wins. And that's what a stipulation generally is for a Rhode Island landlord. Many property owners are firmly aware of the stall tactics routinely employed by eviction attorneys representing tenants through means of some documentation error or not, which would just add time to an eviction. Which will only prolong the financial hardship property owners experience and is already suffering. From my understanding of this bill, it only provides for free legal assistance to tenants, no matter the case, but provides no assistance to property owners that in the face of loss of rent could be facing foreclosures. Can we not find a balanced and equal approach?
Thank you. Mr. Bishop.
Yeah, thank you. Thank you, Chairman and the committee. My name is Brian Bishop, and I have been also a landlord for essentially my entire adult life, and vicariously through my father during my child life as well. Our I want to speak quickly to just a couple of the concepts. One of the, I think the important concepts.
Mr. Bishop?
Yep.
Pull the microphone a little further away from you.
Oh, sorry.
You're blowing the ears out of the people at the station.
Thank you. One of the concepts that I think has the only kind of spokesman so far I see in kind of supportive ideas of a tenant union or tenant organization is someone who demonstrated a kind of long and arduous, and Vice Chairman was very fair to him, kind of difficulties with the Public Housing Authority. But I can understand where we have a large housing authority where you have, or even perhaps in a private development that has hundreds of tenants or something, and people feel that they can't get a fair shake or that somehow it's us against them. Okay, maybe I'm not saying that even what's on paper on this union makes sense, but I'm saying one can understand that in those circumstances, these are, especially with public housing, it's subsidized, it's a publicly chartered corporation. You know, that's something that perhaps it could look at. That's not what this bill is. The bill says any two people could form a union. I mean, realistically, somebody has a 3-decker and their tenants form a union. Now, in a way, I'm not worried because I get notes from my tenants saying, thank you, I couldn't find a card that said best landlord in the world. And you know, no such cards are made, apparently. And I get it. And so you each year are faced with the stories of the most difficult tenants landlords have faced, and then the tenants who come to testify about the most difficult landlords that they face in the most difficult conditions. But if 40% of the state rents, you know, 40% of the state is not here to tell you that our apartments are in a horrible shape, that things are going horribly wrong. And I think that one really has to, and I don't mean that everybody could be here, but if 40% of the state, that's 400,000 people. And I don't think that we thus have the level of problems with tenancy that are being illustrated. And likewise, I'm concerned about what we saw in one bill are overlapping concepts of just cause eviction. Rose was very effective on how difficult it is to demonstrate just cause in these very difficult situations where often other tenants are being harmed. And every eviction is not perfect, but that is not the way to fix it. And finally, the rent control only means, as many people, as everybody understands, where we own a house and we buy in at a certain level, I tend to rent at that level, not because the house has become worth 50% more than when we bought it 20 years ago. I kind of rent with our costs in mind. As Rose said, if the taxes double in a year, which they have, we raise the rent a little bit, not even commensurate with what those are. But the freedom to kind of do that and to work through that with tenants is important. So I thank you very much for your time.
Thank you, Mr. Bishop. Paula?
Yes, good evening. My name is Paula Hudson, and I am the Executive Director of Better Lives Rhode Island, a small but mighty agency celebrating its 50th year of service. Annually, we feed 30,000 plus Rhode Islanders at our food pantry and our community meal site. Additionally, we provide resources, provisions, and case management to over 400 unhoused individuals. Last year, we placed 53 individuals into permanent supportive housing. I'm here today to support H7967, the Homeless Bill of Rights. Homelessness is a public health issue, not a criminal act. And we have legislation that attests to that fact. Unfortunately, this legislation has been ignored and violated since its enactment. Ignored and violated by those sworn to protect and serve. On March 6, 2024, 2 uniformed police officers entered an encampment, ignored the protests of the clients, citing their rights under the Homeless Bill of Rights. They cuffed innocent residents and proceeded to enter tents and ransack the tenants' personal property. Residents were told they have no rights because they live in a tent. One of my social workers was there at the time, and she and the 2 interns with her felt very intimidated by these officers. So you can imagine how the residents must have felt. And this scene has played out time and time and time again. I know I would be terrified if armed men entered my house uninvited and unannounced, telling me that I have no rights, when I know, in fact, I do. Most, and I'm sure you all would be unnerved by that scenario. They're people, someone's daughter, someone's brother, mother, sister, father. They are human beings, and they are our neighbors. They should be treated with respect and compassion. Any one of us could find ourselves homeless in the blink of an eye. All it takes is a fire, a flood, a condemned building. Being homeless is not a crime, but it is a public health crisis. I beg you all to support this bill. These amendments, such as providing trash containers and porta potties, will at the very least help our neighbors keep their surroundings clean. And with your help, we can all work to ease this public health crisis, and let's just do the right thing.
Thank you, Paul.
Thank you.
Any more names?
Angelo Kappa. You got it. Come on up, Angelo. Victor Gutierrez. Is Victor here? What's this one here? Nina Harrison. Is Nina here? No? Okay.
How about Shayna Crandall? Shayna Crandall here?
Jimmy Murray. Jimmy, come on up. See who? Oh, Michael Tillinghast.
This guy's coming up.
Oh, yeah, Michael.
Mike, come on up.
So Angela, why don't
Hi.
you start?
Hi, my name is Angelo Capsamalis, Rhode Island Coalition of Housing Providers. Thank you for having us again tonight. We're here to oppose a bunch of bills tonight, 7049, 7960, 7372, 7304, 7174, 7746, 7305, 7162. Yep, I just wanted to give a little bit of background on myself. I came to this great country at the age of 15 as an immigrant. I didn't speak any English. I didn't have any money. Saved up some money to, buy some rental property back in 2011 with me and my wife. And we started becoming housing providers. A lot of these bills are very, very disappointing, very disheartening to a lot of the landlords in Rhode Island. Just going for a few things like the rent control bills are very, you can't really control, rent when we as landlords we don't have a fixed price or just a mortgage. We have many other expenses associated with the house, dozens of bills that would come through, utilities, water, sewer, repairs, electricians, pest control companies, material. We can't put a cap on the dozens of other expenses that come along with associated with the house. And I wanted to touch up a little bit on the just cause eviction also. It's very hard to prove the just cause, and at the end of the day, you want to take care of your property, and you want to take care of your other tenants there, make sure that you don't have a trouble tenant there with issues that you cannot remove from the property. So I wanted to keep it short. Thank you again for having us.
Thank you.
Good evening, Mr. Chairman and members of the committee. Thank you for the opportunity to speak this evening. My name is Jimmy Murray. I am a landlord in Rhode Island, and I also own Lion Property Group. We provide housing for 900 local families in the state of Rhode Island, and we take that responsibility very seriously. And I think, or actually I know, I stand with the Rhode Island Coalition of Housing Providers in their opposition to many of these bills outside of one of them in front of you this evening, because it would impair our ability to manage these properties and own these properties as landlords. I started out as a 22-year-old broke college kid, and I bought my first multifamily with the last 2 pennies that I had to rub together. I spent every night and every weekend the first year owning that property, bringing it back up to speed as it was a foreclosure, and the units were in disrepair that local families could not reside in these units. I developed skills in order to bring housing stock back into the great state of Rhode Island, and that's what we do today. So when I hear about these landlords not taking care of properties, I don't see it as much. I think we're really trying to legislate to a very small percentage of the population. Is there one landlord that consistently gets brought up in front of this committee? Yes, we see that. But I'll tell you that the housing providers that sit behind me and sit alongside of me, we take great care in the properties where we house local families. We take that very seriously. The bill that I want to speak directly to is the just cause eviction bill. I believe it's 7960 or 7690. I think that this bill as proposed has unintended second and third level consequences that would further impair the housing stock and further impair tenants. So as the legislation that we have that sits on the books in terms of the evictions that we can bring against tenants in terms of non-payment or possession, I think that the 30-day notice works as intended. I can tell you multiple stories outside of this committee because I know that I'm limited to time in terms of when we have leveraged the 30-day notice to ask a tenant to leave, and it's for the safety of other residents in the building. This document and this level of eviction has been used to protect the peace and quiet enjoyment of other families in our buildings. Thank you for your time.
Mike?
Thank you, Chairman Craveman and the committee and everyone for their exemplary work that has resulted in the bills here today and within this session that can help so many residents. There are many powerful bills that have the capacity to make a lot of change. We are here to solve the housing crisis. I am Michael Tillinghast. I'm an advocate. Several years ago, McKee asked me to find out what can be done to solve the housing crisis and speak out for the homelessness. I'm sure you've heard a lot from your constituents on the campaign trail about housing. At the DARE tenant and homeowner meeting, so many have spoken up about the high costs and the reality of displacement, non-habitable living conditions, faults in the current system, and so much more. I'm advocating for the passage of these bills to remedy the housing crisis and, in practice, help landlords who will be financially in better shape after the passage of these bills, and the tenants who are overworked and struggling with the high cost of living. This tent law is exemplary. I could write an extensive opinion, measures, criticism, intents, but next year we plan to do more on the Homeless Bill of Rights. This is America. We have the freedom to create subsidies and establish rights that Americans can enjoy and exercise. I could reference many civil rights leaders to invite this committee to pass these bills and give these defenseless tenants and tent owners rights that will certainly be historical. Sometimes actions are criminal, and things that are against the law are crimes. It should be a crime to raise the rent more than 4% in a year, toss somebody out into the cold, suddenly raise the rent without notice, not disclose fees, discriminate against a person based on the country of origin, or to evict someone into perilous situations without cause, or search a tent without warrant. Raising the rent more than 4% a year is generally unreasonable. It is critical to protect elderly Rhode Islanders with 60 days notice. Elderly people should have the stability, and sudden surprise hikes as permitted under the current law should not be permissible. The frequent and incredible hikes, I argue, violate the right to life for individuals over 65 in this case by tolling the cost of living.
Time's up, Mike. Thanks. Richard DeSeltz, Jeff Manning, Vivian Sutherland. They're here? Oh, okay. What are you talking about?
Do you want me to go first? Yeah. Awesome. Thank
All right,
you.
gentlemen.
Thank you so much. I have a bit of a long speech, but I'll try to condense it as much as possible for you guys.
2 minutes.
You got it. Hello, my name is Robert Deslatz. I was born and raised in the great state of Rhode Island. I'm 22 years old and a renter here. As a young man with no one to support me, I have no other option to survive but to rent. I must rent to survive. Not many people know that I carry right now the weight on my shoulders of all those around me, all those young people around me who have no idea what to do when they're faced with landlords that are taking advantage of them, that are hurting them, and they honestly are without any support at all. So I'm talking on behalf of all of those people. And just a few years ago, I was denied housing, not because I didn't make enough money, but because I was 18 and I was looking for a home. So many young people today can't even get housing at all. If they don't even have good credit, if they don't have parents that can co-sign, if they don't have these prerequisites, they can't even find a place to live. And a lot of people overlook just how hard it is in today's society. Back in the 70s, this is a recent one people have been using, you could get a mortgage on a house almost without any problems. You'd have minor obstacles compared to today. And the average person today will never be able to afford a home at all. Their only option is to rent. And as the pricing is increasing in today's society, we can't even afford the rent prices, let alone finding a house to buy. So we have been shrunk in our ability to own property, but even to rent in today's society. And going further in, I support every bill here, but specifically I'm talking about the right to counsel and the right to have an actual decent eviction process where we're actually given foreclosure and disclosure on what exactly is happening. Those are what I'm talking about today. And my personal experience with a landlord that just spoke just earlier today, funny enough, just a few hours ago, I will not name them, but they just spoke today, has been one of the worst experiences I've ever had with anyone. And I'll talk really briefly on that. It's basically I was having flooding from ceiling, from the sewage, basically of the apartment. Everywhere I was having flooding in, and it caused me to lose 2 jobs in the process. Just 3 months ago, I was talking to Gabe Amo on behalf of one of the biggest companies here in Rhode Island. And as I was doing that, I was giving the right to do that. What a privilege. I was having my apartment taken from me because my management and landlord said, get out, we want you out, your apartment's flooding too much, we're not gonna give you any compensation, we're not gonna find you a new apartment, we're gonna kick you out, and goodbye, pay your rent and leave. That's what I was told. And that's what I'm dealing with, working, who knows, maybe up to 70 hours a week, barely able to afford an apartment and trying to go to school. On my own, it's very impossible. It's honestly impossible. But I still try every day, and today I got a new job. I can't really say where for reasons, but it's paying really well, and I'm able to afford an apartment. But that's still probably above most people's wages, and honestly, it's above what most people pay for a mortgage nowadays. Like, it's insane. Quite incredible. If you really do look at the numbers, the average person makes not even 10% of what they need to actually afford a home in today's society.
Thank
so
you.
I speak on basically, just to finish out, I speak on specifically the Bill 7957, the right to counsel, and the right that any person needs a house or a home or an apartment that's safe, reliable, and functional. And that is a legal right. And if that's broken, then they have a right. They should have a right for any type of like legal assistance that'll help them to fight back in that perilous situation.
Thank you.
Thank you.
Thank you.
Good evening. My name is Victor Gutierrez. I came to Rhode Island in 2014. As he said, I worked 70 hours too. But I had goals. My goal was to buy my first house. And I'm the living proof that anyone that come to this country or to Rhode Island is able to make it. If you put the hours, I was working 70 hours for a dealership. I was going to school at night to try to learn the language, as you can see. But I just want to talk about my mother-in-law. She has one property. She lives in the second floor. She rents the first floor. A few years ago, she rented this apartment to a single father with 3 kids. They were around between 14 and 19. This tenant, he paid the first month, the security deposit, didn't ever pay any other month after that. After a year and a half, she was able to get them out of the house through eviction. You could go through the walls in the house, you can walk through the bedrooms because they broke every single wall. She went through foreclosure because of this tenant. Only one tenant. One bad tenant. I understand where he's coming from, but only one tenant. You need one bad tenant to take you out of business. To take everything that you work for, to take it away. Just one tenant. That's all I want to say. And I oppose all these bills because, for example, I only own one house. My homeowner's insurance went up 33%. And I raised the rent around 7% because I had a long-term tenant. She's a great tenant. I just got a phone call. I just replaced the whole heating system, around $10,000. It's still not working. Now I had to go and deal with that. I already work around 10 hours today. All these bills, they look like they're affecting the big landlords, but they're not. They're going to affect the small landlords. Majority of the people in the state of Rhode Island that live in properties that are landlords, they own one property. A lot of these people send their kids to school through these houses, refinancing these houses. Most of the landlords in the beginning, especially small landlords, we don't make money in the beginning. You buy a house that needs repairs, at least in the first 3 years, you're not gonna make any money. I understand where people is coming from, but it doesn't come to only to the landlords. It comes to the supply. If you try to build something new over here, it would take years and a lot of money, and you might get a yes from the zoning department.
Thank you, Victor, for your testimony. Yes, sir.
My name is Steve Golden. I'm a landlord. I have properties for the last 30 years.
Is your red light on?
It is not.
Okay, good. And pull it closer, please.
Okay. Is that close enough?
Yep.
I'm trying to make a profit on my properties, but I'm not trying to get rich. My properties right now probably are 50% of market. The bills that are talking about rent control would force me into a situation where I had to make a decision about suddenly doubling the rent on all of my tenants or allowing myself to get in a position where I couldn't afford to continue to own the properties. And again, the overall problem is people need more money to pay not just their rent, but their groceries and their insurance and everything else. If we're going to subsidize people, I think all of the taxpayers should be subsidizing people, not just landlords. And rent control essentially burdens landlords with that subsidy as opposed to the entire population. And that's all I have to say. I think the unintended consequences, though, of that sort of rent control might be severe. I would probably have 6 families that I would end up evicting. Thank you very much.
Thank you. Okay, is there anyone that was called from the bell room that could come forward? Please come forward. Come forward. Come on. All 3. Thank you. Homes for All. Could you tell me your name? No, you shut it off.
Hi, my name is Shana Crandall, and I'm representing Reclaim Rhode Island. And I'm here to, yes.
It is?
Yes, is that better? Okay, great.
It's not for us, it's for the folks who are watching TV.
Thank you. So I'm here to express our strong support for the Tenant Bill of Rights, especially tonight, 7957, 7960, and 7962. I'm going to jump right in. Every single day at Reclaim, we work with tenants who are paying rent to live in housing that's unsafe and makes them sick. Every single day, we work with tenants who've already exhausted existing avenues. They've already put in maintenance requests. They've already called, texted, and emailed their landlord. They've already gone to code enforcement. So tenants are already using existing avenues, and they're still paying market rate for unsafe apartments. Tenant unions and consolidated complaints are an accessible, fair, and low-cost way to change that. Tenant unions bring tenants together to leverage their economic power as rent payers to win fully code-compliant homes and fair rental contracts. Landlords who follow the law and maintain health and safety in their units have nothing to fear, because if you don't have patterns of abuse in your units, your tenants won't take you for a hearing. Moving on to 7957, Right to Counsel. Over the last 2 years at Reclaim as a tenant organizer, I've spent countless hours in eviction court supporting tenants, and what I've seen is a system bursting at the seams that can't deliver justice to working class tenants. The single most common thing I see is terrified tenants having conversations with their landlord's lawyer in the hallway, and settling their housing in that fashion. People who are desperate to keep their homes, even if it means accepting a bad deal or a deal they don't understand. People living paycheck to paycheck who already pay upwards of 50% of their income to their landlord, taking hours off work to show up at court, and have no opportunity to present their case. Finally, just cause eviction. Eviction affects all aspects of a person's life, from education to the custody of children. This crucial legislation, 7960, protects tenants from arbitrary, discriminatory, retaliatory, and economic evictions. So arbitrary evictions, when you want to kick someone out to get a higher paying class of tenant. Retaliatory evictions, right? All the time we see tenants who get an eviction notice for calling code or for making complaints or requesting repairs. An economic eviction, if your landlord raises the rent by more than your wages go up and you've already got 2 jobs, there's nowhere else for people to go.
Can I ask you a question?
Yes.
You mentioned code enforcement. In your experience, does that ever do anything?
We've actually worked really closely with several code enforcement agencies, and by bringing tenants into the process, so tenants being able to go to minimum housing court hearings, we do see it happen, right? When tenants are able to tell judges what's happening on the ground, we have seen real effects. Typically, just putting in a complaint, it doesn't go anywhere, and that's why this consolidated complaint, which identifies patterns across multiple units.
I'm just trying to get a handle on whether or not how our municipalities are doing in terms of actually doing the job that the law says they're supposed to do. Thanks for your answer. I appreciate it. But I think your time is up.
Okay, thank you. Yes, ma'am.
Hi, my name is Terry Wright. I'm a member of the Racial Environmental Justice Committee in Providence, and also the Tri-Chair for the Poor People's Campaign, and I also advocate for the unsheltered and homeless. And I'm just going to say, poverty is the 4th leading cause of death and as far back as 1942 and World War II, related to housing shortages back then in the Great Depression, Congress enacted sound tenant protections to make sure that struggling individuals and working families had housing stability. But guess what? We are headed right back to the Great Depression without adequate, sustainable rents and decent tenant protections for struggling families who rent. Anyone renting is in jeopardy of eviction due to rental increases. Our homeless crisis is growing. There are over 500 people forced to live outdoors in the state of Rhode Island. And those numbers are growing due to not having adequate tenant protections from price gouging landlords and ill-gotten evictions. People are being released from prison, yet a majority of city and state properties sit empty. Where do people go? If they are not able to have a tent, where do they go? Jail? Or to the next block and to the police are called, only to repeat the same cycle over and over again. And it's at the cost of taxpayers, it's at the cost of someone losing their sanity, increased mental illness is happening, new drug use. We held a direct action at Providence City Hall called Stop the Raids and Start the Aid. We had a meeting with Chief Perez, who stated that the job of the Providence Police is to enforce public safety. Tents are being kicked in, destroyed, belongings are being lost. Where is the public safety for the homeless and unsheltered? This is a state of emergency for anyone who is forced to live outdoors 24/7, without a porta potty, without hand washing stations, without tents and compassion. Help and healing. Pass the Homeless Bill of Rights with all of its revisions as it relates to the safety of Rhode Island's homeless population. And also a livable wage would help. That's it.
Thank you. Yes, sir.
Hello. Sorry. Wow. My name is Vivian Sutherland. Thank you, Chair, for having this hearing. I already sent in 5 pieces of testimony over email, one on my direct experience with rent increases and in support of the Rent Stabilization Act, also for the 90 days notice, the legal representation for tenants, and maybe some other ones. I'm here tonight specifically to testify for the right to organize bill around tenant unionization. In 1986, when the Rhode Island Residential Landlord and Tenant Act was passed, there was a provision in it under retaliation where no tenant can be retaliated for being part of a tenant union or similar organization. But since then, there's basically no teeth for any of that, especially around any type of enforcement. In the reality, should tenants have rights? This is a really big thing, especially after hearing so many landlords tonight. It's like, workers can have rights, tenants should have rights. Do people without property, do they deserve to have rights? With people who don't own a business, do they deserve to have rights? Are they equal before the law? Tenant unionization could help this. Also, specifically, we often hear that it would be great to have people go, solve their problems through the legal system, but we know how that just churns people out. Now, when tenants get an eviction filed against them, let's say through the pandemic, this is when I really started talking to other tenants about this type of stuff. It was always, I'm getting a 30-day termination of periodic tenancy because I told my landlord, hey, I can't afford that rent increase. And so the landlord is like, okay, well, I'm going to terminate your tenancy, and then you have to find a better place to live, or I'm going to file an eviction against you after the 30 days. This happened time and time and again as landlords found out that inflation was starting to go up and decided to, cash in on it. And we heard this time and time again. So to finish up, I just think that this bill could provide a way outside of the courts to deal with this, because tenants get it on their record forever if they're just even filed against. Landlords, you can't even find a record if they go to housing court or municipal court, And to answer what Jason Knight said, every time Like, it takes months to years for anything to ever go to trial in municipal court, and tenants just get retaliated against and churned out the eviction machine for trying to speak up for themselves. That's why it's had to get to the point of the Attorney General going after some of these major slum landlords. That's it. That's all I got to say. Thank you for everything.
Thank you. Yes, we have a question. Hang on a minute.
Just a comment, because I heard it across all, and just to Vice Chair's question, that the other side of that is when the tenant doesn't go and it's just the word of the landlord and there's no check, there's deference to the landlord, that, did you fix it? Yes. There's no check. So what happens, we have old stock. So it stays old and unsafe stock because those violations never get fixed. But now, seeing when tenants do go and you get both sides, you start to see the fixes. You start to see then, unfortunately, landlords who are behaving like slumlords will get fined tens and thousands of dollars and sell the property immediately. We've seen it in housing court. Once a municipal judge can get both sides. So I think, just to add that side to that, that unfortunately in code, another lack is they were giving deference to landlords and calling and saying, hey, did you fix it? Yes. Okay, all set. Trusting. And that's fine. But unfortunately, they weren't telling the truth, because once tenants came, they said, no, it wasn't done. So I think that's another side of it that needs to happen, because we do have old stock. It's not getting better. Somehow it's not getting fixed. And those are some of the issues that lie around it. So I just want to add to that I heard across.
Thank you.
Thank you.
Roberta, is there anyone still left in the bell room? There are? But is there anyone else still down there? Is there room to bring them upstairs? Yeah, thanks.
No, I'm sorry. You can take. Yes.
You're first.
So, my name is Andy Cotton. I'm a landlord, investor, developer. I've been a tenant in the past, but obviously now my profession is now a landlord. So I want to take a step back to 2 weeks ago when we had testimony from the House for one of the initial bills. And, you know, right before I gave my presentation, I was pointed to and called a vulture and a capitalist by some lobbyist people. So I just think it points out the underlying tone of how landlords are looked at in our state. And it's really a shame, because what we really are partners. We can all agree there's a problem with affordable housing. We're the most likely partners to work through that problem. We're not the enemy. We are capitalists, of course, but we're not vultures. We take pride in our work. And I think I'd like to hope that we can be looked at and talked to and treated as partners through this process, because we are. But on a high level, affordable housing isn't actually the problem. It's the result. It's the result of a bad economical stance in real estate. There's a huge disparity between supply and demand, right? So the issue is supply. The result is rising costs. So I think to shift the burden and shift the blame away from these fat cat landlords just jacking rents up on people and put it to a constructive talk about how do we get more stock is really where the conversation needs to be. So it's, the other thing I had a little bit of an issue with is the fact that there's 12 housing bills on the floor tonight, and I apologize profusely for everybody that has to sit here till however late to hear from all of us, but it is important for us. It would be great if there was a second night or a way we could break this up a little bit, because it's a lot, and we're not really going to adequately be able to speak to everything we want to, and but we will do our best. I'm not going to hit on everything, but a few other things. We already do have rent control in certain parts of our market. So my company uses or rents to quite a bit of housing voucher holders. There is already embedded rent control. They tell us what we can charge for apartments. That exists currently. I guess I'll wind down right now because there's no sense in going any further, but it's already there. We don't need to expand and embellish it. I think we just kind of appreciate what's there, and if we have a problem with affordable housing, let's move more people through the voucher program that already captures that covenant.
For what it's worth, for what you said, is one of the best things I've heard tonight. You said what you meant.
Yeah.
It doesn't do any good to repeat the 17 bills numbers. But everybody seems to want to do that.
It's our, at the end of the day, though, like, we don't get to do this often, and it's our day to kind of be importantly displaying what we feel passionate about.
That's why we're here. We want
Yeah, we appreciate that a lot. And furthermore, I'm not taking anybody's names down, but please reach out to me or any of my company if you guys want to have a working relationship with these things, because we see a lot of this. We manage close to 2,000 apartments, so we have front lines of what's going on in the marketplace, and if that can be of value in the legislative process, like, doors are fully open across the board.
Leave your number with the clerk. Thank you. Yes, sir.
Good evening. My name is Frank Rubino, and I've been the broker and leasing manager for Stonelink Property Management, formerly Blackstone Group, for the past 8 years. I've also been a Rhode Island renter for even longer than that, so I can speak to both sides of the coin as someone that works in the property management industry and someone that rents and pays their rent to a landlord every month. The bill proposal I would like to oppose is House Bill 7174, proposing against the asking of a potential applicant or processing of a background check for an applicant that would be renting an apartment and the denial of residency for said applicant based on their criminal history. On the property management side of things, our job is to mitigate risk for our clients that have hired us to manage their properties. Part of that responsibility is to have a maintenance staff on hand that have a certain skill set to fix maintenance issues at any given time at our properties. Our clients and residents are trusting that the property management staff we hire, especially those that are in and out of their properties where residents reside, are not going to commit a crime or put in potential danger those that reside at said properties. That's why before we hire anyone at our company, we do an extensive background check. Why wouldn't this be the same for those that are applying to reside in our properties that we manage? We have an obligation to keep our residents safe, and doing away with background checks or asking about criminal history would hinder that. On the other side of it, myself, as a resident, a husband, a father of 2 smaller children, and another one on the way, I'd be extremely upset with my landlord if all of a sudden I found out the person that just moved upstairs just got released and has a violent criminal history. Why should the average renter that doesn't have a criminal history or has never been incarcerated have to be faced with the worry that another person in their building could cause harm to themselves or their family? In my eyes, it just doesn't make any sense. Just recently, I read that according to the National Institute of Justice, in today's year, 2024, almost 44% of criminals released returned back into prison within the first year. 68% of those released were arrested for a new crime within 3 years. 77% were arrested for a crime within 5 years. Those are some numbers that just don't sit well with me. And as a renter or as a property manager, thank you for your time.
Thank you.
Appreciate it.
Yes, sir.
Hello, Mr. Chair. Thank you very much for hearing my testimony. My name is Jeff Manning, and I'm a physician who lives and practices in Rhode Island. I had originally planned to read a statement that I've already submitted, but rather than waste your time simply reading that when you can read it for yourself, I'd just like to tell a brief story. I come from a place of privilege. I recognize that, given my background and my occupation. I don't necessarily come into contact with people who are less fortunate than me on a consistent basis and have true connections with them in ways I wish I had. This past winter, I had the opportunity to meet a gentleman who's he worked in customer service at a store that I frequented. He testified earlier today. He's probably the best customer service person I've ever met in my life in any way, shape, or form. And one day he said to me, he said, hey, he didn't even know my name at the time. He said, hey, can I ask you a question? You look like you might be a lawyer. I'm not, but I said, I'm happy to hear a question. He said, I'm renting an apartment across the street, and it's been flooding sewage, and I don't have heat. And I'm wondering what I can do. They've actually told me that I have to leave and that I have to be out by the end of the week. Do you have any ideas? And I got to tell you, that broke my heart. This guy busts his butt. He's working like 60 hours a week. He's just trying to make ends meet. And it was just very sad. I think that he would have really benefited from having some sort of ability to have legal counsel provided for him because he doesn't have the finances to provide it for himself. He would have had the benefit if there was a union, other people that he could have relied on or he could have worked with. So I'm supporting those bills. In closing, I just want to say that in waiting to come up and testify, I've had the opportunity to talk to a lot of great people, people that are on both sides of this discussion. And I want to compliment you all for keeping this civil. And I think that we can work together to come up with some solutions. And I thank you for taking the time.
Thank you. You and I, you're a doctor, I'm a lawyer. We both learn a lot we can use in our professions by hearing the things we hear tonight. It gives me a sense of humility. And it seems like it does with you too. Thank you. Okay. We got 3 more folks.
We got 2 minutes.
Hello, hello.
Yep.
Hi, my name's Matt Patty. I'm a real estate broker, investor, landlord, father, Rhode Island resident. I wanted to congratulate everyone first for all the bills that everyone can seem to agree on, which are the bills increasing the density requirements or allowing more density to get built. That's something that's really necessary, and along with some affordable housing things, I think there are some consensus between the landlords and the people who are less fond of property rights. We keep hearing about protection. I think that would be great to see, since the majority of the protections are in favor of the tenant. As a 14-year real estate broker who sold around 1,000 homes, I've never once seen a situation where a property was at market rent and a slum and beat down, and the person just kept staying and paying. The reason that people stay in beat-up apartments is because they're paying low rent. If they were paying market rent, they would leave and go to another property that had market rent if the place was too derelict. As an overall rule, I'm sure there's exceptions to this rule, but that would be the rule. Another rule is that people have decency and common sense with each other in most cases when it comes to landlord-tenant relationships. So a lot of what is being proposed is regulation with second and third order consequences that attempts to legislate common sense in how people interact with each other. These laws are very dangerous because when you attempt to do this, you don't realize what the next consequence will be. Some of my proponents on my side have read a lot of studies about rent control, history of that, so I didn't want to speak to that. I just wanted to say that in 14 years, having dealt with thousands of housing transactions, mentoring agents, I've never seen a situation where the rent is at market value, the place is a slum, the people just keep staying and paying. It's kind of like a boogeyman. Why would you do that, right? So what it really boils down to is that a lot of these rules, I really think, as they are proposed, would violate what I understand to be constitutional and private property rights. They would be detrimental to both landlords and tenants. They would make Rhode Island less attractive as a place to live, work, and invest. And they would cause some of the surplus and the growth in Rhode Island to retract. Rhode Island does not have a good track record for growth in business. We have a good track record for importing poverty and exporting wealth. And our state could use some common sense legislation. There are some things, and I'll conclude quickly, that we're working together on. I wanted to point those out first because I do think there is an agreement between all parties that the density increasing and allowing people to maximize their land and their properties to provide more housing is a great place to start. Some of these onerous bills that really do limit what I understand to be my rights as an American are things that I would really stand in opposition of. Thank you very much.
Thank you. Yes, ma'am.
I'm Jara Coffin. I'm an architect, landlord, and I host one hell of a block party for my tenants and neighbors every year. At 35, with 2 sets of aging parents relying on my husband and I for support, the idea of a single-family home and having kids is a distant fantasy. Rhode Island is ranked number 5 with the states with the lowest single-family home ownership amongst millennials. This is a downward curve, only worse for future generations. Why I began investing in real multifamily properties is so that I could at least own my 900 square foot apartment while providing housing to other tenants. Bills where landlords are unable to adequately screen tenants, discontinue the lease, discourages landlords who should have control over who shares their space, especially with kids around. And in my personal experience managing properties in New York State, the right to legal counsel laws unfortunately discourage bad tenants who only take advantage of the system to elongate the eviction without paying. I had this happen to me. I could not afford a lawyer, and I did not have legal representation, and the eviction went on for months and months. As an architect and a specialist in the delivery of sustainable, healthy buildings in New England, I want to underscore this moment. We have the second oldest housing stock in the country. Rising temperatures, flooding, inflation, and a growing population. Collaboration with landlords, investors, and developers is essential to maintaining and improving and adding to our existing housing stock. If zoning allowed me to add a unit on the top floor or convert my garage into a handicap accessible unit, I would in a heartbeat. Bills that create caps on rent would materially cease investments in local housing, whether it be for the creation of new units or just investing in the maintenance required for the climate crisis. This, of course, would only make the problem worse. Therefore, a well-designed rent policy like the equitable one that we already have in place should exist in tandem with the great exclusionary zoning laws that are starting to be passed. Thank you.
Thank you for your testimony. I appreciate it. So we've shifted gears a little bit up here. My name's Second Vice Chair Jason Knight. What I'm going to do, because I think, is everyone up from the bell room, or there's still folks out there? This is everyone. So we're going to take your testimony next, and then I'm going to select 3 at a shot for people who want to speak on these bills. I am going to hold you to a hard 2 minutes. All right? So tell us your name, speak for the television audience, and tell us what you know.
My name is Christopher Smith. I'm here on behalf of Rhode Island Coalition of Housing Providers and myself. I am a homeowner. I'm a landlord. I own 1 house, 1 2-family. And I just want to point to real quick, 7049, 7372, 7960 all impose some kind of rent control. 7304 would hold me to a 90-day rent increase. If that was in effect today, my insurance costs went up $142. I split the difference with the tenant, so theirs went up $71. I would have been held to $58.84, a $12 difference. Not a big deal, except that I would have been held 3 to 4 months if both of these bills were in effect. And if it happened next year, this is just one thing, this is just the insurance. What about when my taxes go up? What about when water goes up? You can see how this compounds. So every year I'm going to be held 3 to 4 months where I'm covering the entire cost of this, and then I can no longer just simply split the cost with the tenant, so their rent goes up a modest amount. Residents being able to extend the term of a rental agreement, somebody will take advantage of that. Some crazy family member will move in, say they've been living there the whole time, and will just delay the eviction, and you'll get somebody in there that's beating the crap out of your apartment, and now it's just going to be that much harder to get them out. Prior incarceration, discrimination, I think it's my right as the homeowner to know about somebody's past, especially since they're going to be living in the dwelling that I'm living in. I would want to know anyway, even if it was somebody else, another tenant or something, since I'm at least partially responsible for their safety. Assistance animal, 7305. You can go on Reddit and pretty much type in, how do I get around landlord's rule regarding animals? And there's all kind of workarounds to call pretty much any animal a service animal. Yeah.
Thank you.
Maybe go
2
for
minutes.
a service deer.
Let's see where you're at.
A service
All right.
deer.
I'm opposed to pretty much any bill you have that's come from the progressive wing of your office. Thank you.
Gotcha. Okay. Are you interested in testifying? Are you? Are you? 1, 2, 3. I would ask folks to Once you're done, if you want to stay in the room, that's fine. However, just please keep the side conversations to a minimum so we can continue hearing what people have to say. Let's start at Ultimate Rebellion. Thank you, sir. And 2 minutes, and away you go. Tell us your name.
Good. All right. Excellent. Thank you very much. My name is Tyler Fontaine. I'm a licensed realtor here in Rhode Island and Mass. I'm a tenant, landlord, so I've done all the sides here. I want to thank everybody for their time, patience. I agree with many of the sentiments that were put out for some of the people that are not here. I disagree with some as well, but I think there is common ground to be made. In fact, some of the testimonies have been brought up. I probably would be willing to dive deeper and look at alternatives here. I am opposed to many of the bills in front of you, of course. That being said, you know, we talk about the rent control, and I was going to give you statistics and all of these things, and it seems like a lot of people have done some homework for me, so I will be brief. I'm going to go to a novel written by Ayn Rand called Atlas Shrugged. It's about 1,000+ pages, so I don't know who has the time to do that right now, but do the SparkNotes version. Long story short, alternate America, titans of industry, building railroads, developing what we need as a country to bring quality lives to everybody here. Eventually, these titans of industry get pressured by government because red tape comes in and government starts putting in laws and different things that are really restraining the free market and allowing people to come with innovations and change the pace here and make life better, easier, more affordable for everybody involved. Eventually, the dubious people in government and in titans of industry of business come in cahoots, and they start doing backdoor deals and things like that, and start blackmailing, et cetera. It gets nasty. At the end of the day, what happens is the titans of industry, the innovators, the people who provide thousands of jobs, the people who come up with real opportunity and help it come to fruition for masses. I'll finish in just 1 second. They leave. They all go away. They don't come back. They take their money and they move somewhere else, and the country becomes derelict. And I would just hate to see that.
Thank you for your testimony. I appreciate it.
Thank you, Tyler.
Tell us your name.
Good evening. My name is Stephen London. It's an honor to be in front of all of you today. Thank you so much, all the representatives and second vice chair Knight. Thank you so much for having us all. Let me start off quickly by saying we're all humans and we all have different perspectives. That's what makes this beautiful. But we start to paint the brush as if we're against each other. We're not. We're all trying to move this great state of Rhode Island and this great country forward. I'll tell you a quick little story. I had a testimony. I'm going to put it aside. There was a little boy. He was born of immigrant parents. They'd come to this country, and he went to Colombia for the first time with his parents. And he saw these houses, and these houses were all put together, run down. And he said, his first question to his parents were, why don't we grow here? There's more family here. And the father said, look at those houses. They're beat down and run down. In America, we have nicer houses. Okay. They continued, and that night there was a crime. There was police on that street. And that boy was very scared and said, why do we not have this in our neighborhood? And those parents looked at that child and said, because people in America work really, really hard and care about what they do. So we came back to America, and I was the poorest child in my community. I grew up in Cumberland, Rhode Island. And all my friends had all these things. And I said, why don't we live where the other Hispanics live? And my parents said, we will do whatever we have to do, 2 jobs, 70 hours a week, so we can put food on the table. My mother once said to me, if I have to sell tomatoes on the street corner after work, I will sell tomatoes in order to afford rent. Fast forward, the differences in what we're trying to accomplish here, it starts with the mentality of scarcity or the mentality of we can do it. We can wake up, we can rise. This country was built on incredible dreams and passions. Roger Williams founded here because he didn't agree with Massachusetts and the separation of religion, which is another point. My point that I'm trying to make is that we have great programs for first generation home buyers, first time home buyers, 3.5% down. We talked about 40% of people are renters. Well, to improve that number, all we have to do is decide if you're one of those renters and here in Rhode Island and you're one of those 40%, work hard, limit your expenses, save up a little bit of money. There's tons of programs and buy your first home. And that is the path to begin. That is what I did, and now I own a bunch of property.
Thank you.
And thank you so much.
I appreciate it.
I appreciate you.
Sir,
How you doing?
tell us your name.
Louis Ciano. I'm with the Rhode Island Coalition of Housing Providers, and I wanted to say thank you, guys. And this is pretty awesome being up here with these guys here. But as was just said, big thing that he was kind of talking about was education, and I think that's kind of something that we should dig into a little bit more, and just trying to educate both parties more on the right ways to do things, the right ways to act, the right ways to kind of go about their lives. Because everybody has horror stories on both sides. 95% of the room, 99% of the room probably has horror stories on both sides, but now it's to the point where, okay, what do we do to make this state better, as these guys said here. So thank you very much, and have a good night.
Thank you. Thank you for your testimony. I appreciate it. Sir, do you want to come on up? And I'll take this gentleman right here. And then ma'am on the end, are you interested in testifying? All right. Why don't you come up and take this last seat? Yellow shirt right here. Okay, let's go from, you want to go in the middle first? Sure. All right.
Good evening, Vice Chair Knight. My name is David J. Sheehan. Please consider my steadfast opposition to the vast majority of these bills. I am a landlord or a housing provider, but in particular, due to the shortage of time, I'm going to speak to Bill 7049, Rent Control Stabilization. I recognize the fact that housing has become expensive for everyone who's renting or purchasing a home. Higher rents are a direct byproduct of the substantial appreciation and costs of the housing industry as a whole. 80% in the last 5 years appreciation. But rent control is not the answer. As a housing provider for over 15 years and still carrying a mortgage, I understand the difficulty of maintaining suitable homes. For example, recently it was necessary to replace both heating systems in the duplex that I own at a cost of over $15,000. I've always endeavored to avoid raising the cost of living for my tenants with whom I've maintained a positive relationship. I typically absorb expenses as opposed to passing them along whenever possible. Having the ability to reset rent to market after a tenant departs, which this bill prohibits, is a saving grace for many small housing providers like myself. The bill limits the ability of a housing provider to raise the needed revenues in order to cover major improvements. 4%, as often proposed, merely allows for inflation costs, which have been recently as high as 9%. 4% does not take into account housing improvements, unexpected expenses, or exorbitant overhead increases, such as insurance, which has surged upwards of 30% over the past year. Rent control also punishes housing providers who have kept rents low or below market simply because many of us are empathetic and compassionate with respect to our tenants' finances and the rising costs of living because inflation affects us all.
That's a good spot right there.
Could I just end one sentence? If passed, this bill will undoubtedly, over time, turn all landlords into slumlords. Thank you.
Thank you for your testimony. Sir, go ahead.
My name is David Hand. I'd like to thank the committee for your patience and perseverance. I have been a landlord for about 20 years along with my wife, and we consider ourselves the typical mom and pop. We don't have...
Is your light on? Just pull it a little closer.
Okay.
There you go.
You can hear me okay?
Yep.
We own a number of units, but don't consider ourselves big players in the rental market. But right now, we would like to express our opposition to bills number 7409 and 7060, the rent caps, and that we don't have any control over taxes, insurance, utilities, and as such, if these were controlled, we would definitely be in favor of some sort of regulation, but until that time, we're faced with extreme cost increases that we cannot pass along to our tenants, and as such have to absorb that, which I think a lot of other people have expressed that same thing. We also realize that a lot of people are having problems with rent increases, not earning enough money, things like that. And we think it's something that needs definitely to be addressed, but not on the backs of the landlords. We would suggest, rent assistance back when COVID was in full-blown operation. The rental incentive programs were certainly good. There's tax incentives for a lot more for building affordable houses. And in conclusion, I think we would oppose any bills that affect our ability as landlords to screen tenants and provide the excellent housing that we do. And we would ask that this be kept in consideration when deciding which bills to act on and which bills need further modifications. Thank you.
I appreciate your testimony. Thank you. You have the floor. Tell us your name.
Yep. My name is Corey Johnson. Alongside Margot Morris, I'd like to support the Housing Bill of Rights. And then I'll get into the bulk of it. My background is looking at the engineering of economic systems primarily through investment work that I've done alongside the Development Finance Corporation, part of the federal government, investing in economic development in Central Africa, Brazil, China, the former Yugoslavia. In doing that work, I've come to understand two major things. One is the economic system in the United States is unlike no other economic system in the world. The other is real estate in particular over the last 40 years has transitioned from a private equity asset class to an asset class that generates the returns of a bond proxy, something that's priced off 10-year Treasury benchmark yields. And it's understanding that I decided to do what I currently do, which is invest in communities for a more sustainable future with an integrated approach to real estate, clean energy, and broadband. My testimony today is against the rent control legislation. There are better ways to get the desired outcomes. The first is zoning reform, which this legislator has already taken steps to modify. The second is direct programs like stable homes, stable schools, housing subsidy, and basic income programs. In the problem set that's defined in the rent control ordinances, the complexity of the fact pattern far exceeds what's laid out in the legislation. First, coming out of the great financial crisis of '09, there were legislative reforms that constrained the new supply of housing. Two, out of COVID-19, the demand side of the equation accelerated with accelerating household formation. Three, the cost structures of real estate today are decorrelated from the controls that are proposed for rents. Four.
Well, you're done.
Okay.
I'm sorry, 2 minutes
Thank
for
you.
everyone. But I am interested in what you have to say, and if you have the ability to maybe put some of those bullets down in an email to the committee, that would be helpful.
Sure.
Okay, come on up. I got, All right, 1, 2, 3, excellent. Let's take it from this end. Tell us your name, and you get 2 minutes.
Mr. Senator, sir, I'd prefer to protect that information if you wouldn't mind, in a similar manner to what the bill/article is
Sure.
proposing here, where the potential criminality is to be protected for prospective tenants. Is that what I understand? So I think that's a fair trade. It's my first time being here. First time trying anything like this. What do they say about politics? It's like show business for ugly people. So here I am, right on cue. Present company excluded, of course, right? And that gentleman in the painting. How are my levels? I think you're going to start the 2 minutes now. Timer.
No, you're good. You got 30 seconds down.
30
though.
seconds
Minute
left.
and a half,
Look,
minute and a half to go.
I haven't always been on the cusp of superstardom as a public speaker on social media. I've been bouncing around. I know it's shocking. I've been a struggling artist. I know what it feels like to have a neighbor threatening me with violence, proclaiming he's got a gun. You've got to have some kind of securities in place in the beautiful state of Rhode Island. You can't make criminals a protected class. And somebody can tell me I'm out of line. I'm not into politics, right? And it's just that simple. This betrays the common sense of people, and I'm here to speak out about it. That's all. And I'm giving you my opinion. Of course, I'll try to be here earlier next time so we can get the extended version. But this was fun, and that's how you do it on a hard tune. Thank you so much for your time.
Right on. Short and sweet, and you made your point. I appreciate that.
That's why they pay me the big bucks.
Go ahead.
Good evening, Chair Knight and the Judiciary Committee.
Would
I
you
am
pull
Rhode
that
I-
up a little bit
look,
for the folks in TV land? There you go.
I am Rhode Island State Constable George Clark. It's nice to see everyone. And I'm here to speak on Bill H-8084. I've testified on this, to this committee on this, the merits of this proposed legislation, so I will not repeat my previous presentation. What's important to note is this bill does not make evictions easier. I repeat that. It will not make it easier to evict any tenant. This bill does not change in any way anyone's right, ability, or access to have a hearing in court. Really, this legislation is not so much about evictions as about public safety. It's about protecting resident tenants from dangerous and predatory behavior. It's about protecting families from drug dealing and gang activity, to protect elderly residents from fire safety violations and financial scams, and weapons violations up to and including drive-by shootings. Newspapers and local news outlets have reported the awful outcomes of these incidents repeatedly. I know this bill will not prevent all this from happening, but it will be part of the solution. It will help with reducing dangerous behaviors against residents, tenants, and also improve quality of life. I am here before you tonight as the proud representative of over 100 officers in your Rhode Island State Constabulary. I'm asking for your help to protect our citizens. Citizens who can't always protect themselves, people who rely on the court for justice, who rely on us to enforce the will of the court. As the law enforcement agency tasked with this job, I am here asking you for the tools needed to be effective in protecting our citizens who are tenants. Thank you, Chair Knight, and the committee for allowing me to make this presentation, and I would be happy to answer any questions.
Thank you. I appreciate it. I don't think anyone has any questions.
I understand it's very late. Thank you.
It's sort of the de rigueur on this committee, yeah. Go ahead.
Hello?
Is that light, red light?
There you go.
Hello? Oh,
There you
okay,
go.
there we are.
All
Hi, my name is Kylie, and I'm speaking based off the bills for, the housing bills, in generalized. I come to you as a mother and second as a tenant. Being a mother comes with the constant worrying thoughts that pertain to the well-being of my children, such as worrying if I'll miss an important milestone because I'm working, if or when a boo-boo needs to be kissed, and or when and how I'll manage to get the endless piles of laundry done. What I shouldn't be worrying about is whether or not my family will have a home by the next month. If I complain about a broken plumbing or heating, black mold, lack of promised parking that results in vehicles being damaged countless times, if or when my rent will be jacked up, or when I'm already struggling to make ends meet, and if or when that happens if I can afford an attorney for it. These worries are not just real for me, but for many other Rhode Islanders who live paycheck to paycheck. This is exceptionally true for DV victims who have had to flee with depleted resources. As unexpected rent increases, people who have to tap into government resources and benefits, because that $300 to $400 rent increase that was used for heat and electricity is now warming the pockets of their landlords and upholstering their Mercedes. With many already being tight on money and single, very hard-working mothers and Rhode Islanders don't have the safety net, the home they rent is all they can afford. Unfortunately, many landlords see an opportunity to capitalize on higher-paying tenants, only if they renovate the unit that the current tenant already pays top dollar for. Due to insane rent increases. With 30 days, am I done?
That's your
man.
time. But you can finish your sentence.
Okay, it's a kind of a longer sentence.
No.
Okay.
Okay. I see where you're coming from, though. I get where you are.
It's a little.
Okay. Thank you, everyone, for your testimony.
Yeah,
You
I'll
can submit that,
yeah.
for sure. I'll take the next three. I got 1, 2, and 3. Right there. You guys are next. Okay.
How are you? Fantastic.
Next 3, let's start on this end. And you
Good evening,
go
honorable
ahead.
Good evening, honorable members of the committee. My name is Melissa Potter, and I am testifying in support of all of the tenant rights bills. For the last 2 years, I've been living on the property of a landlord that has had us living in code violation hell. From little to no heat throughout the winter months when it's included in our rent, and having to rely on space heaters for warmth, to broken walls, windows, doors, black mold, no outer walls or insulation due to ongoing construction, and a slew of other issues. This is why it's important that these bills be passed. People, families should not have to live in the conditions we've been living in, to have the landlord spend more time on TikTok than maintaining the unsafe living conditions that we've all been enduring for way too long. When I signed my lease with my now deceased fiance, we were told there would be minimal construction that wouldn't in any way interfere with our lives. 2 years later, conditions have just gotten worse, to the effects of a 7-foot deep trench in front of my door for about the last 3 months that has now become a dangerous mudslide with all of the rain we've had. On this past Saturday, during the course of the torrential rain we had, of the piles of dirt were collapsing in the trench, I had to evacuate my home due to the fact that the water was up to the bottom of my door frame. As well as the wind was so intense, I was afraid of windows being broken due to the amount of the debris flying around left behind by workers on the property. Emails warning tenants about the work on the property have been scarce, if any. The landlord or his maintenance crew just let themselves in as they deem fit. The lack of professionalism is slim to none with the landlord and all of his employees, and this is just the beginning of the horrors the tenants have had to endure living where we are. I work hard, my rent has been paid monthly and on time, and my landlord has done nothing to uphold his end of the lease. I implore you to please pass these bills so that myself and anyone else who is or has had to deal with a similar situation like mine can have what we deserve. A safe home up to code where we can live our lives in peace instead of fright and against retaliation in any form, because we have the audacity to ask for the bare minimum.
Thank you. I appreciate it. Go ahead.
Hello. Members of the committee, I thank you for your time. My name is John Maffoni. I'm a realtor and landlord. There's so much to oppose, but I would like to dedicate my time this evening to Bill 7746 specifically. This bill would require any owner of 6 or more dwelling units to hold security deposits in an FDIC-insured savings account and pay the tenant, quote, prevailing market rate of interest. Although I believe that the intentions are good and an effort to look out for the financial well-being of tenants, I find the problems with this proposed bill and the wording thereof are not only glaring but abundant. I'll begin with 6 or more dwelling units. I find this wording vague. Does this mean tenants residing in a 6 or more unit building, or would it also apply to owners of 6 or more total units? What happens in the scenario where a property owner crosses this threshold mid-tenancy via expansion or contraction? Who decides these things, if not courts and judges, at the time and expense of the parties involved and their respective attorneys? I could go farther, but my time is limited. More pragmatically, regarding the interest, as a real estate professional, I have been a part of many hundreds of apartment rentals. I've never encountered someone asking about my stewardship of their security deposit while they stayed in my property. Not once. As far as the tenant's interest in actual hard numbers, this is what we are spending our time debating. The most recent prevailing rate of interest I could find through Rhode Island Department of Business Regulations is as of January 2023. The rate is historically average. This interest rate is 0.05%. To put that in perspective, in this proposed bill, a tenant with a security deposit of $2,000 would be entitled at the end of each year of tenancy to exactly $1. I assure you, there is no tenant concerned with their yearly dollar. There are no property owners basing their business models on collecting interest on security deposits. There is no injustice here. I've yet made no mention of the extra accounting and bookkeeping this would require, no accounting for the time of our courts, attorneys, judges, tenants, and property owners for the lawsuits that would necessarily be taken to get a clear interpretation of the law judicially. I have made no mention of the costs incurred by property owners and how this cost would inevitably be passed down to the consumer, i.e. the tenants, let alone who would be monitoring and enforcing. Who would we as taxpayers be paying to peer into the bank accounts of private citizens and under what jurisdiction? Again, there is no injustice here, and I must ask members to vote against this bill as it is a poor and onerous solution to a problem that quite simply does not exist.
Thank you. Hi.
Good evening. My name is David Sisson. I am an architect, I am a contractor, and I'm a property owner. My livelihood and that of my family and employees literally depends on the creation and ownership of buildings. I've committed to the state of Rhode Island because I think it's a wonderful place to live and have invested countless thousands of hours and millions of dollars into this state. This year, I've counted almost 50 housing-related bills that the legislature, either the Senate or the House, has brought. I don't think any other industry in Rhode Island is as burdened as landlords and housing providers than what we're seeing this year. I understand that many people feel that the cost of housing is too high. I think many landlords would agree that cost of housing is too high. However, I don't believe that we're responsible for all of that. We've heard from many people this evening that the costs of property tax, the costs of insurance, the costs of utilities, the costs of ownership in many ways has created a situation where it's actually quite difficult to make money off of property ownership. Many of these bills you're considering today will further exacerbate the problems that all Rhode Islanders are experiencing with the cost of housing. You'll discover the rent control results in apartments being removed from the market, and the ones that remain on the market will be poorly maintained. Likewise, rent control will result in increases each year, which doesn't always happen right now. Additionally, rent control will result in cratering development in Rhode Island. You may think this only hurts landlords and developers, but construction jobs will also suffer, as well as design jobs like my industry. Just cause evictions, right of first refusal, the inability to see tenant criminal records, the requirement to accept assistance animals, and the requirement to accept any tenant who starts living in a unit without a lease will all result in landlords being even more careful about who they place into a unit.
Thank you.
Thank you.
That's the time. Thank you all for your testimony. I'll take the next three, and before we have a rush, let's just do this. I'll take you two, and come on up. Yep. And while you guys are getting situated, I'll just say this. I think it's important for everyone to know, because you guys probably don't come up here all the time, the General Assembly, I mean, I can't talk for the Senate, but I can certainly talk for the House. We have like thousands of bills that get put in by the members every year for consideration. So that little blurb that we read at the beginning of this session, where this day is about just seeing what people think about things, that is what it is. Just because a bill gets introduced doesn't mean that it's going anywhere, but they're all going to get talked about, which is what we're doing tonight. So I think it's important to reiterate that, because every year these bills in particular elicit some very passionate responses all over the place on the spectrum. With that said, go ahead.
Good evening, everyone. My name is Kelly Silva, and I am testifying in regards to Bills 7049, 7174, 7647, 7746, 7960, 7961, 7962, and 8084. This was my very first apartment that I have ever gotten. This was supposed to be my safe place and my taste of freedom. Sadly, it has been anything but that. Since January 1st, I have had heat maybe for 7 full days since January 1st. My apartment has gotten down to 42 degrees for 4 days straight. We are not asking for anything crazy. We are asking for the bare minimum as tenants. That is what we deserve. We pay these landlords rent, and for some reason, we don't have as many rights as them. That's not right, and we need to make a change. While my apartment building is under construction, I only have 1 of 2 windows in my entire apartment because one of them wouldn't open. So when I brought that to my landlord's attention, he screwed it shut. We have half jobs being done and not finished. We have people that can't afford rent because the rent increases while there's a 6-foot hole under my front door. I only have 1 entrance, 1 exit, and 1 window. I live in fear every day that I'm going to wake up to my ceiling collapsing on me. Every day there's new holes and cracks all down the ceiling and walls. Since January 1st, I have found at least 3 new cracks in the ceiling from the construction. There needs to be a change. We have people using every single dollar of theirs to be able to pay to live, to the point where they cannot afford to eat food. There is no reason that while we are going through this construction and going through everything that we have been going through as tenants, that you are allowed to raise our rent while we don't even have heat. I have heat included, but I have to run a space heater and use my electricity with the heat included because I haven't had heat even 1 time. There needs to be a change, and I hope we can all come together and make that happen.
Thank you very much.
How you doing? My name is Eugene. I currently live in my first ever apartment. First time ever living on my own. I was told many promises about a tub being fixed, a window being fixed, a door being changed, all types of things. None of it was done at all. They had told me actually if I didn't pay in that minute that I was going to lose my spot in the apartment. So that kind of left me with no choice. I had nowhere to go. They knew that. That left me with no choice but to pay for this apartment. They're very rude. The people that I'm dealing with, very rude. They tell me to go F myself. They tell me that I'm very annoying because I'm complaining that my heat doesn't work or that my water comes out white. They tell me that when my heat's off, I should contact my renter's insurance because I should get a hotel because they have heat in a hotel. I've asked for basic things. You know, I'm not asking for a new ceiling fan and like a smart fridge and a new TV. I'm asking for a new tub, new window, new door, stuff like that. I think there needs to be a better way to hold these people accountable for what they're not doing. Not only what they're doing. We need to make these situations more realistic, honestly. That's what it comes down to, because none of this is realistic. I think it's just all honestly out of control. I think there should be some way for us tenants to call somebody and at least get some advice. There's not even really that. There's really nowhere for us to turn, nothing for us to do except for deal with it or go find somewhere else, and that's not okay.
Thank you. Appreciate your testimony. Go ahead.
Is this on?
The red light, if the lights are on, and if they're on, just leave them on.
All right. Thank you, Chairman. Thank you, Committee. My name is Christopher Kretsch. I'm here to express my support for the position of the Rhode Island Coalition of Housing Providers. I'm also here with my wife and my business partner and my co-owner. We, who I do everything with the real estate, we are the definitions of mom and pop landlords. We got our entry into housing by being owner-occupant landlords. And so that was our way in from becoming renters to becoming landlords and having a pathway to the housing. It was much better, much more affordable than single-family housing. And then I fear that if we pass these legislations, we're going to lose the ability for young people to step up and instead of having the dream of a single-family home on a quarter-acre lot with the white picket fence, they're going to be able to better qualify for a two-family home, up, down, living in one unit, renting out the other. And these bills make it harder for someone to do that. They burden these small landlords with additional regulatory requirements, with additional administration fees. I'm already cutting costs pretty much as much as I can. I do all the snow removal myself. I've put a bunch of my own money back into the properties. So with being owner-occupant landlords, we were able to expand to one additional property. We put $100,000 of our own money just into that, just to help make the property better for things like unsafe electrical that was found during the inspection. So getting rid of all the knob and tube. That does not come cheap. That was $40,000 plus a $10,000 hit when we took the money out of our 401k to do that. We had our own sewage story, and I want to tell my own sewage story because I got a call when I'm cooking eggs on a breakfast morning. There's water in the basement. Run right over to the property because I fear it's something either with the plumbing, of course. And I can see that the sewer's backed up. Tree roots were growing into the clay pipe. We have old homes in our city. They are not getting any younger. They take a lot of money to keep up and repair. So I'm there in my boots, in the sewage, and I'm helping coordinate the drain cleaner, the guys who are going to come in afterwards and clean up, disinfect, do all that. And then also that very next business day, I'm on the phone with guys who are going to reline that pipe using cured-in-place piping from the basement all the way out to the street, resulting in literally like 1 4-hour outage for the tenants and then 1 6-hour outage of the tenants for 2 days. That's what we're going to lose if we lose mom and pop landlords. We're going to lose landlords who are going to stand in the sewage and make sure it gets right.
Thank you. Nope. Rep. Cruz.
Thank you.
If you don't mind, sir, hang on.
Yeah, I just wanted to thank the two tenants for coming forward because I stay here all night hearing about how there's nothing like you just described from landlord after landlord. Yes, there are good landlords. I've heard some examples, but to hear these stories and not admit, and you call yourself housing providers, that you don't want to stop this and have places up to code. I just heard from your testimony that you're hands-on, you're doing it. These bills wouldn't impact that because you're taking care of it. Unfortunately, I'm making a comment. So unfortunately, we're hearing from people who are against just fixing their properties. And when I hear every day tenants like this who come forward living in unsafe conditions, I don't understand why people are opposed who own property and rent property as a business not to keep it in safe standards. So I just want to thank you for coming here and your courage because you're clearly outnumbered and you came up the first time as a first-time renter. So I want to thank you for that.
Thank you, Sherry, for giving me the opportunity.
Yeah, thank you.
Thank you. I've been there. I've had a cut.
I actually am against that position because for $100,000 to do those repairs, 4% rent cap, I will never get that back in my lifetime.
I understand.
And also, I would like to,
Sir?
right to heat
Sir?
is already included in the law.
Well, we don't get that. That's why we're here.
It's not a back and forth. We appreciate your testimony. We appreciate your testimony. Can I have the gentleman in the back with the ball cap? You want to come up too? And is there? I can't see anybody. If you're behind someone, I can't see. If you guys are interested in testimony, would you please come to the middle? I'm trying to take them in groups of 3, but if I can't see you, I can't see it. Why don't we start on this end?
Hello. All right. My name is James Height. I'm a landlord, property owner, taxpayer. I agree with a lot of or pretty much all the regulations the Rhode Island Coalition of Housing Providers support and oppose. Many people have expressed a lot of things I was going to express, so I have the luxury of cutting it down to just a few items. As far as keeping up properties, we're not opposed to keeping up our properties. I think there's laws in place already for that, your zoning, housing, et cetera. As far as rent control, I mean, I bought a multifamily 13 years ago, so I can have a place for my son. I ended up having custody of my son. He wanted a stable place to stay. It's not been easy. It's expensive. All my tax returns went right back into the house. I actually kept rents below market rent because, felt I had good tenants. I even had a couple veterans, Army, Navy, kept it under market just because of my respect for their service. But with all the increasing taxes, water, sewer, fire district, insurance, if you have like 4% or 10%, I'll have no choice but to raise the rent every year for that, whatever your cap is. So those who are for that, remember that when your rent goes up every year. And as for me, at some point I might reach a breaking point where it no longer makes sense, and I'll either just pull the units off the market and just unfortunately pull from my 401k, and so my kids at least have something to inherit, or just sell it and be out. That's what I have to say.
Thank you for your testimony.
My name's Kelly Baxter. I'm a volunteer tenant organizer, proud lifelong Rhode Islander, and a current renter. I'm here to support the bill for tenants unions. It closely mirrors the process for grievances that I was afforded as a former member of Local 94. The current system to address landlord deficiencies is weighted heavily in favor of landlords. The outcomes for tenants are minimal. We don't have to venture far to see the need for recognized tenants unions with grievance procedures in place. Some of the most vocal self-described housing providers against tenants' rights legislation have been open to the press, this legislative body, and advertised their own dangerous conditions. Presumably, they know that there's minimal consequences for doing this. Recently in the Projo, we've had these landlords brazenly admit that they haven't followed laws aimed at preventing lead poisoning in children. Our own Attorney General tweeted about this. Astonishing admission by landlords, this is Peter Nerona's words, including a member of the Commerce Corporation Board, that some are already in violation of law requiring every pre-78 rental property to have a lead-free certificate. Given that, of course, they oppose a law ensuring they are in compliance. It was just last week that a landlord representing Providence Luxury Rentals testified in front of this body and two fire chiefs in this room that they were renting out an illegal basement apartment, in their words, a beautiful one. They discontinued this only when they were caught by building inspectors. At this very moment, you can rent an apartment advertised on Zillow by RentProv Realty. It's a basement apartment with no visible smoke detectors, one point of egress, and windows I could personally not crawl through during a fire. It's currently available if anyone's interested in here. These are all examples of landlords that have been telling on themselves. These are property conditions that result in the most severe consequences, such as children with permanent lifelong disabilities or burning to death. This justifies the need for collective bargaining. Some of the larger property management companies that are against these tenants' rights bills include StoneLink, RentProv, Nexus Property Management. I implore you to take the time to read their online reviews. They're absolutely abysmal. Common allegations, infestations, building code violations, ignored maintenance requests, harassment, and not returned security deposits.
Thank you.
Thanks.
I get your point. Go ahead.
Good evening.
USS Whale?
Excuse me?
USS Whale?
Yep.
638?
Yep.
I was 706. Thank you for your service.
Thank you. I missed that time. I started off, I had a list of like 12 bills, and when I came in here, I found another 12. And most everybody has already said everything they need to say. I'm a member of Rhode Island Coalition of Housing Providers.
Use the mic.
And REAG. So for the most part, I don't know if you want me to read off all these bills, but it's going to take too long.
Why don't you just tell us what you think without going through the list of the numbers, because we don't have the numbers memorized.
Let's see. There's the limited increase of 4% or 10% or whatever it is only going to be detrimental to tenants because effectively the rent is going to end up being increased. I have a tenant right now that's at $950 for a 2-bedroom apartment with a garage that Section 8 will pay $1,550 to $1,600 as we speak. I could have it re-rented tomorrow. So it's ridiculous. This is telling me that I have to substantially raise their rent right now, which will put them out of the house. The thing about applicants' incarceration, I feel it's my duty to watch out for my other tenants, not to have somebody there. I had one that decided that he didn't want to be evicted because just because he hadn't paid his rent in 6 months, so he assaulted me, laid me out on the street, and I had to go to the hospital, in an ambulance. So aside from watching out for my tenants, I want to watch out for me. I'll just try and skip some of these. This thing about assistance to animals, I find that most people, they just sneak the dog or cat or whatever in anyway, so it's kind of a no thing. To me, it's baloney, that an assistance animal is just an end run to get around an animal that somebody really needs if they're blind or they're invalid or something like that.
That's your time, sir. Thank you. Thank you for your testimony. Thank you, all three. Okay, let's do this in order. Are you interested in coming up? All right. Sir? All right. Ma'am, you've spoken. Anyone else? Come on up. And last time we started over there, so let's start with you.
Hi, my name's James. I'm a renter in Rhode Island. I was renting from a previous landlord. I was on a month-to-month, and on a very short period of time I was asked to leave because he was going to be renting to family instead. I didn't have much time to look for a new place. It was kind of a quick thing, and I ended up with Pioneer, who I'm sure most of us know. And I think that's where a lot of this comes into play. I think the right to counsel, earlier this winter I was without heat for a couple of months. Being able to go to somebody to bring that, would be very helpful. Me and my two roommates are kind of at the top end of our budget, even with being in West Warwick and at a lower rate. The 4% would definitely help that if he ever decided to increase. And I've also, since then now, been working with the tenants union, and I think there needs to be more structure there. Thank you.
Thank you for your testimony.
Hi, my name's Dominic. I'm a landlord. I think I distilled everything down to one line, so I might repeat it twice, but I have a 6-family in Providence. If the tax continues to rise as it did last year, and I can only raise my rents 4%, my taxes alone will exceed my rents in 6 years. So at a 4% increase and my 37% tax increase, in 6 years, my taxes alone will exceed my rents. Thank you.
Thank you for your succinct testimony. I appreciate it. Your turn.
Okay, hi. Hi, my name is Josefa Jenna Kornwitz, and contrary to what people assume, I'm actually a landlord. I came here I actually have like spackle on my sweatshirt working on one of my houses. And I want to say that I am against any bill that limits my ability to manage my properties, and I support RICOP. Specifically the bill 7960, which would prohibit month-to-month rentals. I work with companies that house people that are displaced from fire, floods, and refugees, and they're in a month-to-month contract. I currently have a cop and his 3 children under 5 and his wife and their puppy staying at my home, and it could take months and months and months to get their house back to living. Otherwise they'd have to live in a hotel for months on end. So yeah, I'm just worried that these bills will lose mom and pop landlords like myself, and that I won't be able to provide housing to the people in my community. And I'm totally against the rent control, and I don't want to, everything that everyone said I also agree with. So there you go.
Thank you. I appreciate it.
Yeah.
Okay. Is there anyone in the audience? You guys are free to go. Is there anyone in the audience who signed up to speak, wanted to speak, hasn't had the opportunity? Come on up. I think you might be batting cleanup. Is that it? Roberta? Last witness?
All right. My name is Anthony Thompson. I've been a housing provider.
You went. Hold on. You went, ma'am.
She was so good.
Come on up. Just a quick half minute. Go ahead. You are batting cleanup. I want to have you last, okay?
Sure. Thank you.
So I want to say something about posting violations. I got a violation on my house. Said there were rotting porches. My house didn't have any porches. I went, took pictures of my house, saw that it was the house next door that had all the problems, brought labeled pictures of my house and the house next door to inspections and standards. They submitted it. Did they dismiss it? No. The inspector and his big, huge ego went by with a magnifying glass, had to find something. I had garage door rails and no garage doors. So to go through having to notify everybody about violations that were completely fictitious is not fair.
Thank you. Okay.
All right.
Tell us what you know, please.
All right. My name is Anthony Thompson. I've been a housing provider, real estate agent, and property renovator since the early 2000s. I generally support the position of the Rhode Island Coalition of Housing Providers on housing issues and oppose the bills they are also here to oppose. All right. Sorry. I oppose Bill 7746, mandatory interest on tenant security deposits, because tracking interest on tenant deposits is a bookkeeping nightmare, not only determining the interest as it fluctuates monthly, but also because banks issue 1099 int forms every year for every interest-bearing account, no matter how small the interest amount, even for just a few dollars. It's unfair to expect housing providers to pay the taxes on interest from tenant security deposits, but then have to pay the interest itself to tenants. I oppose Bill 7960 because I believe just cause eviction is a fundamental violation of a property owner's freedom to choose when and to whom they rent their property. Residential leasing has always been based on a fair and mutually beneficial agreement between housing providers and tenants that allows either party with sufficient notice to end the agreement and go their separate ways. This bill would fundamentally change that relationship, making it severely one-sided in favor of tenants, forcing housing providers to continue rental agreements even if they no longer want to. For example, if they want to renovate a unit or for a buyer who requests a vacant unit to move into. So I strongly oppose this bill. 7960, along with 7049 and 7372, also has a limit on residential rent increases, rent control. I believe rent control is well-intentioned, but a misguided effort to address the increase in rents caused by a supply-demand imbalance in our state. Like other forms of government price control, economists overwhelmingly agree that rent control has the opposite of its intended effect. It disincentivizes creation of new rental units, the only real solution to the supply-demand imbalance, and it discourages owners from modernizing our aging housing stock because it limits what they can get back from property improvements. I had more to say, but I just do want to address some of the tenants that had mentioned deplorable conditions. It is possible to contact code enforcement of the municipality, and they will be very happy to notify the owners of such properties of violations and eager to enforce them. As a housing provider, I dread any kind of letter from code enforcement, and I address it right away. I'm pretty sure you can contact them anonymously. No one should live in those conditions, and I agree, but there are remedies under current law to address those conditions. Thank you very much.
Thank you. And with that, that concludes the testimony on our bills tonight. I'm not going to run through the list. We all know what they are.
Motion to adjourn.
Second? All in favor? Thank you very much.